Nacional de Justiça, José Rotondano. E como palestrantes, o juiz de direito do Tribunal de Justiça do Distrito Federal e dos Territórios, Fábio Esteves, e a procuradora do Distrito Federal, Ana Maria Prates Barroso. Para a condução dos trabalhos, tem a palavra a ministra Daniela Teixeira.
Bom dia a todos e a todas. Eu vou seguir todos os conselhos do nosso presidente Herman de ontem, da ditadura do cerimonial. Então, a senhora manda em mim e avise quando alguém estiver passando do tempo. Muito obrigada, ministro Schietti, por esse espetacular evento que Vossa Excelência promoveu aqui no STJ. Ele vem tarde, ele podia ter sido feito no dia que inauguraram essa casa, porque aí não teríamos tido tantas decisões injustas, das quais nós nos arrependemos. Mas nunca é tão tarde assim, e é menos tarde do que daqui a mais 35 anos. Então, foi um evento de uma abertura muito emocionante. Ontem eu vi várias pessoas chorando na apresentação daquele filme tristíssimo. Quem não esteve ontem aqui, foi mostrado um vídeo exatamente da questão da prisão injusta. E, às vezes, aqui, nós nos prendemos mais à súmula 7 do que à humanidade. Então, eu deixo aqui esse meu sofrimento, de que a súmula 7, ela é injusta e ela é racista, porque ela nos dá um escudo para simplesmente dizer, isso não é um problema meu. Esse fato da vida que essa pessoa injustamente foi presa, não me interessa. Então, em boa hora veio uma nova lei que nos permite, em qualquer grau de jurisdição, não conhecer do recurso, porque ele é manifestamente incabível, mas, vírgula, meus 3 assessores estão aqui, concedo a ordem de ofício diante da manifesta ilegalidade. Eu espero que tenhamos aqui uma nova era, de menos erros judiciários, de menos processo penal, não permitindo que a justiça seja efetivamente feita. Eu participei do julgamento da 5ª turma, onde nós anulamos 12 condenações criminais de um só ser humano, que já estava preso. Eram 14 decisões judiciais dessa pessoa que estava presa há 12 anos. Então, isso é algo que realmente nos envergonha, não como magistrados, mas como pessoa humana. A pessoa humana que ouve isso e acha justificável, ela em algum ponto da vida deixou de ter uma humanidade dentro dela. Então, nós vamos apresentar aqui uma questão muito importante, a mais importante, que é a questão do racismo, exatamente nas decisões policiais e judiciais. Se essa questão, meus queridos amigos Fábio e Ana, falo deles porque são as pessoas negras na mesa, fosse um problema dos brancos, já teria resolvido. Já estaria resolvido. A abordagem policial que ofende o Estado de Direito, a prisão manifestamente ilegal, fosse um problema dos brancos, já tinha tido uma solução. No Supremo, no CNJ, no curso de formação dos juízes. Mas agora é que nós estamos falando sobre isso. Há 10 anos atrás, não falávamos. Então, eu fico imensamente feliz que as 2 pessoas que mais falam sobre isso, com mais propriedade, estejam aqui nessa mesa. Doutora Ana Maria Prates Barroso, minha líder, não vou chamar de professora porque vai parecer que ela é mais velha que eu, e ela não é, mas minha líder especialmente nesse assunto. Há 2 décadas nós caminhamos juntas nesse espinhoso reinado da maldade, seja a questão das mulheres, seja a questão dos negros. E o nosso mais querido juiz do Distrito Federal, Dr. Fábio Esteves, que também é uma liderança nessa questão que não tem nada de glamurosa e é uma questão muito difícil. Eu faço uso aqui dos dados do nosso pesquisador, Davi Metzger, que está desenvolvendo a mais detalhada pesquisa sobre habeas corpus no Brasil. E são dados que são científicos. E quando a ciência aponta que nós estamos errando, nós temos que ouvir a ciência. Se não ouvir a humanidade, se não ouvir a Constituição Federal, ouvir a ciência, matemática. Matematicamente, a conta está sempre no mesmo lugar. Por que eu digo isso? Nós tivemos aqui 174 decisões concedendo o habeas corpus no caso do reconhecimento falho, ok? 174 decisões em um ano. 133 foram em roubo e só 8 em furto. O que isso quer dizer? Por que no roubo se erra tanto e no furto se erra tão menos no reconhecimento? Porque a vítima está nervosa, violenta emoção. Ela reconhece até essa placa como o autor daquele malfeito, daquele delito. Então, isso nos diz muito. Isso diz que a palavra da vítima, quando em violenta emoção, não pode ser reconhecida como um dado concreto e científico da vida. Não pode. Dessas 174 decisões concessivas, é quando o juiz, aqui, os 10 daqui dizem, nossa, que erro horrível. E quando chega aqui, a pessoa já está presa há 1 ano, 2, às vezes 12, como foi o caso do ministro Reinaldo. 174 decisões. Fica o meu apelo. 119 pareceres contrários do Ministério Público Federal, que trabalha aqui conosco nessa casa. O Ministério Público Federal precisa voltar a tutelar os interesses da população vulnerável. E o réu sempre é a população vulnerável. Ter 119 pareceres contrários em 174 decisões concessivas mostra 2 vieses. Que os ministros dessa casa têm coragem, porque não é fácil você anular uma operação contra um parecer do Ministério Público. A gente corre um risco de massacre midiático, mas foram concedidos. E mostra que o Ministério Público precisa abrir os olhos para a questão do reconhecimento errado, do inocente que foi preso. Temos aqui também 174 decisões. Em 141, o reconhecimento foi feito por foto. Ou seja, a foto tem que ser abolida do sistema policial. Ou por lei, ou por prática, ou por curso de delegado. É muito erro. São 141 decisões erradas por conta de uma fotografia. No nosso gabinete, nós pegamos 2 casos muito significativos. A foto era preto e branco, completamente impossível de saber quem estava na foto. Podia ser o meu marido na foto, porque a foto era de tão péssima qualidade que era impossível. E o outro era uma foto tirada de redes sociais, a pessoa estava de lado. Assim, era impossível reconhecer. Tive também alguns casos que eu gosto de citar, Ana e Fábio, não porque eu jamais acredite em racismo reverso. Isso é quase como acreditar que você pode, sei lá, rezar para pneu. É uma coisa que você ouve falar que existe, mas não é racismo reverso. Mas eu tive no meu gabinete um caso de reconhecimento errôneo de um rapaz absolutamente loiro de olhos azuis. E ele foi confundido com um criminoso absolutamente loiro de olhos azuis, porque são parecidos. Mas o que acontece? É muito raro um loiro de olho azul ser preso, é muito raro ele não ter um advogado que já o tire da delegacia, mas eu gosto de citar, para que quem está no meu lugar, de loira, de olhos azuis, entenda o tanto que isso pode dar errado. A foto vai dar errado. Tivemos também um caso de um rapaz árabe, com aquela barba bem comprida, característica, que foi reconhecido erroneamente em relação ao seu cunhado. O cunhado praticou o crime e fugiu do Brasil. O que eu quero dizer com isso? A foto não vale para ninguém. Não pode valer. Se só tem a foto, é melhor dizer que nem houve o reconhecimento. Dos 174, só 19, um índice muito pequeno, foi realizada essa identificação pessoalmente. Então, assim, a gente está falando de 10 vezes o erro. É simples corrigir o erro, Ana. Outro dado que, para mim, é muito significativo, das 174 decisões que o Davi estudou, 94 são da Defensoria. 96, 94 estadual, 2 Defensoria Pública da União. Só 76 de advogados particulares. Aqui entra o Innocence Project, Núcleo de Prática Jurídica, etc. É o único dado do Davi.
It's the only data where the public defense managed to have more rulings than the private attorneys. Why? Because those who have misidentification are the Black, the poor, the peripheral individuals. This is data. This is a fact. For us to pay even more attention when there is a process. Anna gave a lecture that changed the way I understand this issue, and she's my leader, as I call her. A black person goes to the police station and the execution in the penitentiary system, and during that process, we say, why are we going to say that the defendant is Black? What for? We need to know that that recognition done by a person within a person that is Black has 10 more times chance, probability of being wrong. So for us, it is important to actually say that that person is Black, because I follow Schiaretti, and it was the minister that I was more in tune with. We have here 3 judges, and judging is actually a very solitary task. We have few information, almost no information at all. And with those generic concepts, and we need to either leave that person or take them out of the imprisonment system. So this is important data to have. So this is a suggestion for those of you who are attorneys. Put that data within the process. It's not enough to say that the photograph was invisible, but you need to actually include it. You need to say that he or she is part of a population that to the eyes of the law are almost always the same. This is data that for us is important. We have João da Silva, but I don't know who João da Silva is. I don't know if what he or she says has a basis. You need to put photographs of individuals that look similar to him or her to see the high probability of making a mistake. Let's start with a video, which is a hard video to watch for us to show here at a House of Justice, because it shows a misidentification. This is of Mr. Carlos Edmilson da Silva. Let's watch it together. My name is Carlos Edmilson da Silva. I was convicted. I was imprisoned for 12 years unjustly. My life before prison was
sonhos que foram impedidos. Às vezes eu tentei tirar minha própria vida. Mas eu pensava na minha mãe. Na minha mãe e no meu filho, que eu tinha esperança de encontrar ele vivo. Na prisão eu tive que lutar para sobreviver. Trabalhar, esses anos todos, fazendo crochê, cortando o cabelo, para poder esquecer um pouco, né? Mas eu tinha plena certeza que eu era inocente. E isso daí para mim foi que me deu força, minha mãe, que me deu força para poder continuar. Lá no presídio eles fizeram em todo mundo o DNA. Aí eu falei, eu vou embora, rapaziada. Vou embora, o DNA tá vindo aí para mim embora. Esse ano ainda eu vou embora. Aí fizeram os exames, aí foi na onde que em veio a pandemia, 2019. Aí veio os advogados da ONG. Eu até comentei que não tinha feito o exame de DNA em mim, né? Aí fui na onde eu falei, pode fazer o exame de DNA que vai estar lá, que não fui eu não. Isso daí foi, quando veio o DNA, um monte de gente ficou com medo. Eu falei, essa é a minha oportunidade. O que eles fizeram comigo foi a injustiça, cara. Acabaram com minha vida, pô. Acabaram com minha vida. Isso daí que... Por isso que eu não gosto de lembrar muitas vezes, porque tinha tudo, cara. Tinha tudo. Perdi tudo. Hoje eu não tenho nada. Minha mãe, meu medo era perder minha mãe. E se eu sair de lá revoltado? O que eles iam fazer? Não, eu fico assim meio assim de falar porque o coração ainda tem uma cicatriz ainda. E eu sei que ela não vai cicatrizar. Sempre vai ficar comigo. Ia casar, ele tava indo tirar o dinheiro para dar entrada no aluguel da casa ainda. Um dia. Caixa econômica. Não esqueço mais nunca. Falaram que eu tava sendo preso para vigoração. Falei, tá bom, daqui a pouco eu vou sair mesmo. Fiquei 12 anos. Minha vida virou de ponta cabeça de um dia pro outro. Um dia pro outro. Trabalhando. Falaram que eu tava sendo investigado há 4 meses. Entrei na CD da Globo lá no Rio de Janeiro e eu tava sendo procurado. Difícil, né? Eles pegaram Na realidade, eles pegaram o preto, favelado, né? Pobre. Sabia que não tinha condições de pagar um advogado. Primeiros que eles acharam, eles foram lá e torceu. E hoje tá aí. Fiquei preso com o rapaz do lado da minha cela. Sei que ele não tem culpa também das acusações que fizeram comigo. Mas se juiz, promotor tivesse analisado o caso de novo bem direitinho, ele tinha achado o verdadeiro culpado. Toda vez que eu chegava num presídio diferente, contava a mesma história. Muitos abraçavam a minha causa. Abraçava a minha causa, mas sempre falando que estropou mesmo. Ele mesmo tá metendo louco. Um monte de B.O. aí. Você acha que ele não fez? Quantas vezes eu escutei isso? Minha mãe é tudo pra mim, mano. Se eu tivesse perdido ela, eu não sei se eu podia ser inocentado disso, mas eu não sei se eu estaria aqui hoje. Não é fácil não contar, não. Se for contar mesmo que eu passei lá dentro mesmo, é luta, é prova. Ele é o juiz, o promotor, ele sabe o que um estrupador dentro da cadeia, se ele não lutar pela vida dele, ele morre, mano. Ele sabe o que é isso. Ele sabe o que é isso. Policiais sabem o que é isso. O cara é estrupador, jogou lá dentro, lá, se ele não lutar pela vida dele, ele vai morrer, mano. Outros presos vão matar ele, porque não... A sociedade discrimina. Todo mundo discrimina. Às vezes eu tenho medo de andar na rua, mano. Eu ando de óculos 24 horas por 48. Com medo. Muitas vezes. Isso daí é medo. Isso daí não é porque eu gosto de usar óculos. É medo. Uma pessoa... Olha lá, fulano de tal lá. Isso aí nunca vai sair da mente. Eu fui escrachado como um estrupador, mano. Em rede nacional pra todo mundo ver. Eu mesmo me assisti na televisão. Não aceitava, não. Aí hoje eu assisto. Hoje eu assisti também. Eu ando no meu celular, reportagem. Toda vez que eu tenho uma oportunidade, eu assisto ela. Que eu fui inocentado. Aí chega a parte da minha mãe, eu não consigo assistir. Pelo que ela fala, que ela passou, eu não consigo assistir toda. Porque ela nunca tinha me contado isso. Não é fácil nunca. Eu gostaria que juízes, juízas que trabalham com isso, principalmente nos casos como esse, olhassem mais por ser humano, né? E não pelo que ele está sendo acusado. E olhar também pela a dignidade da pessoa, né? Porque se depois que vai preso não tem como mais, né? Julgar é fácil. Mas inocentar é difícil. Eu sei que minha vida não vai voltar atrás, né? Meu passado não tem como pegar uma borracha e apagar. Ele sempre vai estar carregado comigo, como uma tatuagem escrita na minha pele. Isso daí não tem como apagar da minha vida. Só tenho a agradecer por vocês estar me ouvindo hoje, porque lá atrás vocês não me ouviram. É isso aí, obrigado.
Não dá nem para aplaudir, né? Porque a vontade é realmente de chorar. A nossa querida Dora está aqui hoje já? Não.
No, she's not. Dora is the Innocence Project coordinator who actually took this case to tried this case. And I talked to her about the case where 14 women were misidentified. Yes, they misidentified 14 women, were shown the same photographs, and they later on did the DNA, and the rapist out of 7 of the victims was in fact in this cell, in the same prison as this gentleman. So this is what I started by saying. There were 500 processes, and all the actions were stopped at once in facing the incredible misidentification and wrongful conviction. This is the video that I wanted to show you. I now hand over to Counselor José Rotandano so that he can continue calling on our speakers. Right. First of all, good morning to everyone. Minister Daniela, it is with great joy that I am next to you, as I remember that I went to see your presentation. When you started talking, you said you talked about your family and talking about your youth, and that you never imagined to be sitting here to be Justice of the High Court of Brazil. And this shows how much you are humble and how you are within your dreams, that you didn't even imagine, dreams that became a reality. And your perseverance, your positive attitudes show this. They show that you are at the right place, a great woman, and women, as usual, showing what they're here for, showing how they can contribute to society. And this makes us extremely happy as we have new justices here in Brazil, and I see here on the table that gender equality is in fact perfect according to the CNJ. So I wanted to congratulate you. It really is a great pleasure to be next to you. I never imagined, and I tell you honestly, I am a justice in Bahia, and I had no pretensions whatsoever. I was an attorney, and then I was invited to be a counselor of the National Council of Justice. And the first time I came to the National High Court of Brazil, where Barroso called on me to be part of the National Council of Justice. I was always at the TRE, the Regional Electoral Court. But this shows that things happen with us. Unexpectedly, we find ourselves in places we never imagined that we would be. I would like to greet our dear Ana Maria, who is a prosecutor, and others here. I congratulate you, and I say here, Justice, that this is an absolutely necessary debate in our country, even if it's deeply marked for its roots that have links to slavery. which irrevocably changes the actions of institutions. As you said, this seminary came at the right time. It should have happened before, but it's never too late for us to learn lessons, to exchange experiences, and to look for improvements in our justice system. I believe that this is in place for us to leave here today with great teachings. The numbers around the themes are actually quite worrisome. As an example, the Justice campaign gives us the data that 70% of those wrongfully convicted in Brazil due to misrecognitions are Black. And Minister Barroso also talked about, Justice Barroso also talked about this yesterday at the opening. We need to admit that it is a problem, and it is an institutional racism practice that is ingrained in the structures of the judiciary. And on the other side, we need to build solutions that at least stagnate this incredible scenario. I was thinking about when this young man was talking, when we think about the surroundings of this person that went through this, that is so upsetting. A mother, and as you all can imagine, a mother suffers the most faced with this injustice. So the surroundings of this young man, the suffering that these people went through for 12 years, this is something that you just don't come back from. Nothing will pay that suffering that these people went through with a situation such as this one. From that point of view, I'd like to highlight the fourth resolution from 2022 that establishes guidelines for people recognition in procedures and processes, criminal processes. This is within the judiciary power of the judiciary, and I now talk about the importance of the National Council of Justice in every civil matter. I think that it has been a great source and a source of situations that can improve our actions, our work. I am very happy, I'm charmed, even if I am part of the CNJ. I've always been an enthusiast that the National Council of Justice is, in fact, absolutely necessary to the judiciary. We never imagined that we would have a resolution from another institution that was capable of disciplining a process of this nature. So congratulations to the National Council of Justice for creating this resolution. For more, I will not talk about what Daniela already mentioned in brought data to us to mitigate the effects of the selectivity on recognition, persons' recognition processes. And here, I should highlight the relevance of the work of Rogério Schietti,
who has been bringing excellent contributions in order to overcome the state of things through judgments in the Citizenship Court. And then he deserves a round of applause for his persistence, his intelligence, his courage, his teachings, and overall for his competence. I admire you. There is no doubt in that. So without further ado, I have no questions that our panelists, Ana Maria and Dr. Fabio, will award us great information. And so here I leave my recognition for all of the organizers of such an important event like this one. And now I hand over the floor to Dr. Fábio Esteves. He has a degree of law for the Federal University of Mato Grosso do Sul. He has a master's in law by the University of Brasília. He has a doctor of law by the University of São Paulo, a master's in business administration in high performance leadership. He is a judge in the Court of Federal District. He also works in the cabinet of Minister Edson Fachin. He's a professor of administrative law in the Administrative Law Academy in Brasília. He is a founder of the National Meeting of Black Judges, NAJUD, and also the National Forum of Judges Against Racism and All Forms of Discrimination, FONAJUD. And actually, the next meeting will be in Salvador, and I will be there giving my support, since this is where we should give the importance for this topic. And we also need to think about our culture in relation to that area. And he also worked on the project Speaking About Law. He is a member of the loyalists that are promoting racial equality in PSC. And he's the president of the Association of Judges in Brasília in 2018, 2016, and 2018, 2020. So Fábio is known by all of us, and without further ado, I hand over the floor to him. He has 20 minutes for his speech. We are very anxious to hear what he has to say. Good morning, ladies and gentlemen. So I will begin by my audio description so that we can integrate here the participation of people that have visual disabilities in order for them to access the space, and also for us to maintain a constant concern for accessibility. I am a Black man with dark hair. I have a plain nose. I have full lips. I use a beard. I am wearing a blue suit with a lilac shirt, and I'm sitting down. Behind me, there is a panel with my presentation. By my left, we have 3 persons, and here we are before the audience waiting to hear us. I'm very joyous in being here, sharing this panel with gender parities, race parities, Minister Daniela, who is always sharing ideas, not only in the academic field, but also here. The appellate judge, it is a joy to have you here. The National Council of Justice really needs to interact with the judiciary branch, not only in the disciplinary aspect, but also in creating public policies that in somehow can dialogue with our process legislation. And dear Ana Maria, we were remembering speeches and moments where we met during our trajectory. I also want to salute Minister Schietti, not only because eventually he brought up a matter, but in what Professor Adilson Moreira says, Professor Schietti talks for the underdog. And in the hermeneutics, this is not only a point in the criminal process, but in law as a whole. This is a way of removing a foundation of structural racism, which is reached by an universalist hermeneutics. And in the field of the judge's work, this is very common. We have some abstraction in that neutrality, and this needs to be set apart through this provocation. And I know that this has been contemplated by voices coming from this huge country of underdogs. I also want here to make a special registration of my colleague from Mato Grosso do Sul, Dr. Mauro. He comes from the same place as I do. He has studied in my university. He was also a professor there in the university where I studied. I want to also greet all of the Enajuns that are here, Adriana Cruz, Mara, and all of the others that I cannot see here, but I want to register how much this National Meeting of Black Judges and FONAJUD have somehow showing us what are honest mistakes. And I want to congratulate this event for bringing interdisciplinarity. Here we'll have today psychologists, and I think that social psychology needs to have a dialogue with us in this specific point. And Enaju, the National Meeting of Black Judges, can have an interaction in this cognition, this social cognition process from a jurisdictional standpoint. And for 8 years now, we'll have our seventh meeting. We will be celebrating in Enaju debates about technology, racism, and this will make it possible for the judiciary to recognize possibilities of cosmo perspectives in the topic of social cognition. First of all, many of us here, when we saw the video played, we wonder, how did this actually happen? Maybe we are imagining that the police chief was very arbitrary, that maybe he was explicitly racist, explicitly author of an individual racist, and sometimes we wonder, how did this happen? Did the judge go there and he said that this should happen because the subject was Black, and how did this happen throughout the justice system? How is this possible? Maybe we can only think about a very concrete, specific, individualized racism, or we're going to get lost in the idea of the institutional and structural racism as a vague, personalized, immoral idea, an idea that maybe should be real, but we're not responsible for it, since we're talking about a structural or institutional standpoint. And me here, as a mere worker of the law, do not have such a responsibility on that. And the crucial issue for me is for us to understand the relationship between the institutional and structural racism with something very specific, the articles of the Code of Civil Procedure and these results that we've been getting. So we are reflecting on two different points, something very specific, even though it happens many times, but very dependent on an individual concrete action. Or we are in a very abstract plan of the structural institutional idea. And here I want to focus on this discussion so that we can somehow make an articulation in a very honest and critical manner. The structural and institutional racism with the legal daily practice, so that we can explain that this identification, this misidentification process is a result of an orchestrated action within a body of elements that are structuring of the society to which the institutions are conformed, and they are responsible for shaping the society, and in which the law somehow or anyhow bring this earlier with technology. So the law is operating in that through the technology of racism. And I brought up a quick analysis about some points so that we can enrich this debate. And ever since the vote of Justice Schiachi and some things that we have been seeing, the fact this type of occurrence could be as such something that we are discussing but no longer happens. But this judgment that we are considering here was from last week in the recognize that due to the manner that their eyes were at the moment. And honestly, the judge was doubtful. He thought that it was frail, but they still made an indictment. But the suspect was not found, but later on he was, and then he was arrested. And here we're talking about something that, even though it scares us, it is happening right now. This is happening right now. It is not something that happened back then when Justice Rogério was judging this, and now, no, this is something that is happening this right second. So we need to articulate this idea, the structural and institutional racism, for something that happens right now. And later on, we'll have the speech of a psychologist that would then be proposed topic for the second panel, honest mistakes. He's going to talk about how this psychology of testimony, and not only this type of psychology, but how we think about these things, how we can commit systematic mistakes, systematic errors. And within the guarantee of rights, we were thinking about that. We have many famous books, Quickly or Expeditiously, which is a bestseller in that sense, Rápido ou Devagar in Portuguese. And through several and diverse and unnecessarily negative reasons, we can process our thinking, our cognition as to make systematic errors. So we have these mental structures for us to be able to process thoughts, and we can make mistakes. One of the structural thinking processes that we can have is a body of beliefs, stereotypes, and this goes through the processing of information in our cognition. But this also does not mean that we are right away ready to process from this body of beliefs in a negative manner. Perhaps this processing in our heuristics will come from a positive standpoint. The firefighter sometimes has to use his intuition to solve problems. Sometimes we have positive stereotypes. For example, for an elderly person who is at home with wisdom, the idea of the elderly person who is mature and wise, this is a stereotype that perhaps might not carry a negative association. So I must understand that these belief structures, these men structures, which help us to process and to actually make systematic mistakes, they
que são intencionalmente colocadas em circulação para poder gerar a discriminação. E a discriminação racial, no caso aqui que a gente está falando.
Discrimination in our specific case. And this produces and reproduces the way in which we act. And this reaches the reproduction of behaviors. In the specific case of the criminal situation, the Black population and racism, and I know the Professor Mauricio is here. He is one of the biggest criminal authors in Brazil. And I dare here to talk about an eugenistic criminology. And at the end of the 19th century, the beginning of the 20th century, we had a rich character, a character that wrote some works within a pseudoscience about the study of races within a perspective that, thank God, has been surpassed over the last few years, but there we had a biologic perspective of race. So Raimundo Lira Rodrigues wrote a number of pieces within this distinction to work with the Black population based on this eugenistic criminology, meaning that the Black population had social issues and the criminal law should protect these people. It is an interesting speech, a protective speech. And Raimundo Rodrigues is going to work very much with mental asylums, and all of us here can conclude the reason why the racial aspect in judicial mental asylums are very common. And sometimes people might think, well, this has already been overcome. Brazil has abandoned entirely this eugenistic perspective. But that is not true, because we have Brazil in their constitution in 1934, 1937 as well, incentives, and that constitutionally speaking, incentives to eugenics education. And in 1945, we had a decree by President Vargas stating that any subject that is not coming to Brazil to improve our European background is not allowed entry. And we had a huge body of laws at the time prohibiting Asians and Afro-descendants to enter into Brazil, because this would be a risk for the improvement of the race. And the concern from the criminal standpoint was huge. That is the reason why we had this being seen as criminal at the time, and this came before the Constitution itself, bringing the culture, the religion, everything as criminal at the time, for them to re-signify the slavery, enslavement of people. Capoeira as a crime, the Black culture, the Black religion, all of those would be crimes. And this is done in a way as to control the population. And so there was a need to produce a negative meaning to that. And I can only make this legitimate if I bring meaning and I make this meaning go around people in order to justify the criminal justice through a perspective of race. And today we're trying to deny this logic. We try to understand why we have a prison system filled with Black people. We have more than 90% of Black imprisoned people in Brazil. And we have the war against drugs, and we're going to reach 81% of the population within prisons that have been convicted by drug trafficking are Black in Brazil. And so we can understand that nothing has changed ever since the beginning of this century until the beginning of the next century, which is nowadays. So, in this case, we have a relevant issue to understand as structural racism. That is a concept that has been undergoing discussions. Many times it is appropriated to exempt people from responsibility.
And within the pillars to build the structural racism, we have the ideological part and also the judicial part. So I cannot talk about justice against Black women if there is an idea, especially from the media or any kind of communication, that the Black woman doesn't deserve our respect. At the end of the day, it's difficult to look at an ad or a series of elements of communication where we don't see a Black woman yelling, or a Black woman looking after a whole lot of people, or an educated Black woman. So that's why when we go to OB, we give her less anesthetics because she's more resilient. So along that sense, this will justify those practices that within a judicial optics of an universal hermeneutics will identify it as such. So many of us, I include myself, perhaps have great difficulty in understanding that we are actually linked to this universal Eurocentric hermeneutics that within the idea of abstraction or impartiality of the judges and so forth, thinks that law applies to all, that law is at best looks for a very specific situation. And we don't understand that process of formal equality has a sense, that has a reference. There is a reference. Perhaps here we can have clarity on this. We are discussing something that is crucially racist. And an auditor here in the room, there's barely any Black person. So, and not one Black woman. So it's very hard for us to understand this article of the penal code that calls itself universalistic, but in fact it's not. because as Gardner said, all hermeneutics depend on a pre-understood structure. We're talking about an hegemonic structure. It doesn't include the historical universe of the Black population that was perceived as dangerous in the last century, as not adequate to adhere to the penal system. And so we managed to see only an hegemonic historical horizon. And perhaps for us it makes sense, the idea of having a series of people along a line, different people and so forth. But I could even think, well, there is the chance that the person makes a mistake. There is a systemic error, perhaps, but that systemic error is polluted by an ideology. It's polluted by an ideology that comes from the need to keep a group as such. And for us to keep that group down in a structured way, I need to have a powerful network of senses that place that Black woman, that Black man, as if they were, and here we talk about a hierarchy of humanities. Within a hierarchy of humanities, but in a very sophisticated way, invisible to these hermeneutics. And we will have on the 7th of December a speaker who will talk about Black hermeneutics, and we will not be able to understand this Article 126 and its dangerous power if we continue to find that this is a universal law, that it is an abstract law, that it is a law that can be applied to everyone without distinction. If we don't, in fact, consider the history, the background of these inequalities, we need to change the way in which we think about an institution and also its constitution. We have a structure in the judiciary, but we will have this difficulty. Why? Because is it because of the faith of the members? No, it's about capability. If I don't ask myself, listen, you can understand every difficulty of a Black woman's life in terms of inequalities. No, of course I can't. She needs to be here for us to understand that. Even if I have the best of intentions, I won't have that understanding. And I won't have the understanding of the historical background. So we need to be careful. At some point, we need to say, look, the systematic errors are not the same for everyone. Those beliefs, that body of beliefs that help us process knowledge, cognition, and so forth, needs to specialize in what can actually lead to errors. Those beliefs that are that have racial ideas. And here I will come to an end. I'd like to thank once again the National Council of Justice for bringing the discussion in a very free manner. I had the opportunity to say, and I will continue to say, we are very shyly moving forward. We're giving baby steps. We're just throwing a little ice here, a little ice there, because it's not enough for the justices to solve issues here. This is just a minuscule percentage of what's happening. We need to understand the depth of Brazil, which is actually made up of and has racism all through its structure. Thank you. For those of you who didn't know, you now know this powerhouse. We're so proud of the Justice of the Federal District. Thank you so much. Now, Dr. Adriana Cruz, I'd like to greet you, Dora Cavalcante. We greet you, Dr. Carriel, who's also joined us, who also talked about the importance of the Defender's Office. We now have Ana Maria Prates Barroso, Federal District Attorney, Professor. She's a Doctor of Constitutional Right, a Master's by the University of Pernambuco. She was a public defender here at the Federal District. within the criminal district. She is the daughter of Donna Ruti. She's the author of a book for penal process that is non-racist. For those of you who work within this sphere, it is a must, all of you. It is actually necessary to read this work before you judge any Brazilian person. She talks about the process of racist practices. She will talk about this here. And I will now let her speak because why should I talk if she's here among us? There is a phrase within her book which I like to quote. Being Black on its own is already enough to justify mistrust on behalf of the police officer. And with that, I now hand over to you, my dear friend. You have 20 minutes. Minister and Justice and I have a long history of fighting this, where she talks about mother of daughters. We've met when our children were babies. I remember that we were the only two women at the AB. This is 20 years ago. And since then, Justice Daniela has continued, Dani, as I called her, continues along that struggle, that fight for gender equality that we started many, many years ago. I think since we were born, it's just like being Black. When did you discover that fight? Since the day you're born. So I'd like to greet Justice Daniela, Councillor José Rotomon, Minister Sketch, Justice Sketch. I'd like to thank you for bringing this debate. He has been of great importance for us to manage to talk more about this. I remember that years ago, we didn't even touch on this. I'm one of the oldest here, and at least now we're sitting down and we're listening to this, even if we're rolling our eyes. This will take some time, but at some point it will sink in. So we need to work with the issue of racism. Minister Sebastian, there's a wonderful book that he wrote about a case. I remember Justice Sebastian, as he said, that it was thought that the focus would be simply to say that it was because he was Black. It would be an ideal case, defending a vote, saying that the focus had been such, and it happened because he was Black. And Justice Sebastian said, look, in all of my years of work in the court, I never saw someone convict someone because they were Black. If it's not a racism case, I don't know what it is. So Justice Sebastian, we also understand that has been in that fight for many years. Dr. Adora, head of a project that has saved lives. Penal right kills as well. Penal law kills as well. Being a doctor is complicated because it kills, but law also kills, as we heard today. I wanted to also greet my professor, my mentor, Professor Carolina. Justice Daniela talked about the issue of my book. It was the product of a thesis, and my mentor, Carolina, really went deep into the study of race as a white woman, precisely to be able to be my mentor, because there were actually no Black mentors at the time, supervisors. So I'd like to thank her presence here. It was really an amazing partnership. I'd like to greet Dr. Adriana Cruz, Secretary at the National Council of Justice. She was also part of my thesis panel. And I'd like to thank her very much. When we do a doctorate, only those who actually go through it know what a hell it is. So any help is welcome. For those of you who've been through it, you know that it's wonderful when it ends. So I've loved my PhD because I'm no longer doing it. I decided the topic, in fact, when Jana invited me, and I thank you very much for that, Jana, it was to talk about racism and the impact in judicial decisions and rulings, and I decided to work on it in this way. Fabio started talking, and he talked about criminality, criminology, eugenics, and he started bringing a vote that was from yesterday or the day before last. And to arrive, we're talking about the Supreme Court with all of the barriers that entails. To arrive here, what arrives at the Supreme Court is only a tiny percentage of what actually happens. So we need to believe. It's not believing. We actually need to enter into our reality. But human law is not this here. The real world is completely different from this. The real world is Carlos in his testimony. That's the real world. The real world is made up of errors that reflect the life of a person that is imprisoned for 12 years and will never again recover. It's not a scar. It's actually a non-recovery. This is a wrongful conviction for 14 crimes, I believe that was. And the issue of racism, and I was talking to Fabio about this before we came up. As long as we don't face racism as a central issue and it continues to be seen as a peripheral issue, we will continue to have these kind of cases. We will continue to have still in a, where do I click here? Oh. Continue to have the idea of a colonial justice. And this is brought from a colonial period that enslaved, where there was this idea of colonial power, and that has been kept within our state structures. The vision of social exclusion, of racial exclusion. So when we talked in slavery times, and Fabio brought this, he brought eugenics, which in reality was a way to justify the thingification of the Black and the belief that a Black person was a criminal for the mere fact of being Black. Justice started reading a phrase where I said that a person is often apprehended for being Black. We don't see a shift here. There's no shift. At that time, you had legislations in the colonial period that allowed for that slavery and that undermining of the Black person. Today, we have a penal code that ended up having the role of that process of slavery. So much so that Fabio brought the idea of criminalization that was a raising or a law from 1890. We had the formal abolition of slavery. And what do we do with those former slaves? What do we do with those Black individuals? We will place them in prisons. And that's how it happened. And it continues to be done in this way. That was done with a legal permission, with legal allowance. It didn't say this and such, but it said, let us convict those who don't work. And we have thousands of slaves, people that were taken out from their families, taken away from their families, that were submitted to living in harmful conditions with punishment. Where would they go? There were people that stayed in the streets. There were people who remained in the streets because they had no profession. They had no degree of education. They ended this process of objectification. This, we talk about the Black person as a subject of rights. This happened with the penal law. It doesn't mean that he couldn't be a victim, but he could be a defendant. And that's what happened. And why does Fabio bring something that happened? And what am I talking about? Why do I talk about something that happened? Because in actual fact, this happens today in a different way.
Isso acontece hoje de uma outra maneira.
This criminalization of Black individuals continues to take place. It continues to take place for our actions and inactions. The inaction also leads to a racist act, if we like to call it that. As we let it happen, we let the difficult processes or misidentifications, this also leads to a racist act because we are still embedded within this vision of the Black person as the defendant, as the convict, and Fabio made a very good observation. We look at the public here at the High Court, and we can only count less than 5 Black people in the room. If you tell me that that's not a way of discrimination, then what is it? In a prison, you manage to see the absolute opposite. And that's not because Black people are more criminal than white individuals. Of course not, even though that has been taken as true for many years. But we still have that vision. We still have that vision. When in the real world, I have Black territories, I have actions in Black territories that is quite different from that which is carried out in white territories. And I don't ask myself, I don't question this. My inaction is, in fact, a racial act. I continue to let it happen. Professor Salomatos, who is a prosecutor in Bahia, has a master's thesis which we can criticize, we can critique our institutions. So it's actually great because he actually wrote his master's thesis on the MPE. And in no situation, he actually conducted wonderful field research. There was no questioning of the cases. Now we have a judicial problem. Stop being a police problem. In actual fact, the decisions are being perpetuated. They're perpetuating something that happened in the field, a criminalization and a racial attitude, and that permeates our system as a whole.
And I agree with Fabio. We get here, but we cannot go ahead from this point. How can we reach the down part so that these types of cases do no longer reach us? When this reaches our instance, you already had 12 years of someone incarcerated. Someone has been in incarceration for 12 years. Oh, I don't have so much time. Yes. Oh, Justice Dani has warned me. She has a charter here. She has subtly told me that my time is running out. But I must say that we always have a lot to say about the racial issue. Because in actuality, and Fabio knows this, there is no willingness, there is no desire for this unconscious biases. So there is no action with intention, but there is a feeling of I should intentionally try to no longer do this. How can I, as an actor within the process, deal with this type of situation? How can I visualize, perhaps as a white man or a white woman? I can't necessarily relate to what Carlos said. I don't know what it is to have the policeman pursuing me. This is a natural reality for a Black young man because they're used to this. So my least obligation as an actor within the process is to try. This is the least of my obligations. So I run the risk of having a racist bias. So what can I do for this not to happen?
para que eu possa olhar para esse
How
processo
can I
e
look
ver
upon this process
o ato
and
racista?
actually
E aqui
see
o que a
the
ministra
racist
tocou,
act? And this is what
a gente
the
vê a
justice
raça
has
no
said
momento
previously. We
presa
see the race
e
once
vê a
the
raça
person
nos
is
presídios.
arrested, and we see the
Decorrendo
race
aquele
within
processo,
prisons.
o processo
Throughout the
passa
process,
de uma
and the
forma
process
normal,
runs
entre
normally,
brancos e
so to
negros,
speak,
ninguém olha a cor.
between
Mas na hora
black
que
people and white
preso,
people. No one is
quando
looking
chega
at the
no
color,
presídio,
but
você
once
sabe
that
quem
person
é.
is incarcerated,
Então,
you know the
aqui
color.
eu, como
You know the persons
profissional,
that are being arrested.
como advogado, como
So when I'm doing this
como
assessment as
magistrado,
a
o que
lawyer,
eu faço
as the
para que eu
public
possa
prosecutor's
ver
office,
onde houve esse racismo?
how can I know
Raramente,
where the
como diz o voto
racism
do ministro
happened?
Sebastião,
And I remember a
se
vote from
alguém
Justice
disser, estou
Sebastião.
prendendo porque é preto.
Sometimes no one will say, I'm arresting you because you're black.
Ter
That
uma
won't happen.
abordagem
But you
feita
have an
de uma
approach
forma
that was done
completamente diferenciada.
in a completely different way.
brancos e
There were
um
4
grupo,
black
só um negro
people
foi
and
abordado.
only a black man. And that was the person who was approached by police. No one was saying that that was the reason why, but there were 4 white people and only a black man, and that was the person who police looked for. Of course, there is racism happening there. Sometimes this is more than evident within the evidences of the case. And Dr. Dora mentioned this within the aspects of people recognition, because people cannot recognize a race other than their own. And this is extremely common because people sometimes they mistake me for the Minister of Culture in Brazil. This is something extremely common. People see 2 black women and they assume that they're sisters without even questioning that. No, there's no way. You must be her sister. So I can only imagine how this happens within people identification. If you can difference me from the Minister of Culture, how can you make a difference between the person who actually committed the crime and the person who allegedly committed the crime? So we need to recognize, we must bring this racist debate to the center of the legal debate, or we're going to continue doing meaningless things. We're going to continue debating, we're going to continue talking endlessly, and we're not going to be able to move forward because we can't see the actual problem. We need to recognize within ourselves the failures that we might have, for us to have these biases within those processes, and that's it.
A palavra, a expressão, só
The
isso.
word,
E o nome
that's it, and the name Ana Maria cannot go together. They don't go hand in hand. I'm going to leave the plates here for my friend, Justice Saldanha. Are they useful? Okay. So now I close this panel. And I would like to thank our counselor, Dr. José Rotandan, and particularly the panelists, Dr. Fábio and Dr. Ana Maria. I know that all of us are going to leave this place better than we came. And I just wanted to mention something. A month ago, the 10 justices of the criminal session were with the Chief Justice Barroso, and they were making adjustments in matters of judgment. One of them were the based reason that would justify police approaching someone and particularly invading a home. For example, someone runs away. So if that person runs away, that is enough reason for them to be approached by the police. And Dr. Adriano said in front of one of the justices from the Supreme Court and many others, they said, well, if the police comes after me, I'm going to run. And then 11 people were completely quiet. We had 11 lessons. Thank you very much, Dr. Adriana, because this is exactly it. Only those of us who experience the situation can give this testimony. And this was a lesson to those 11 people. And today here, I think we're going to have several lessons. And thank you, Justice Sketch, for inviting me to be a part of this today. So I welcome Justice Saldanha and Dr. Adriana Cruz, who are going to preside the next panel, which will be exceptional. Thank you very much, everyone.
Senhoras e senhores,
Ladies
agradecemos
and
os
gentlemen, we
pronunciamentos
thank the speeches given, and afterwards we're going to begin the second panel. The identification of people in science, memory, and honest mistakes. So we ask that you kindly remain within the auditorium.
Neste momento,
Right now, to present the second panel, people identification, science, memory, and honest mistakes, we'll have within our panel as mediators the Minister of the Supreme Justice Court, Antônio Saldanha Palheiro, and the General Secretariat of the Secretary of the National Council of Justice, Adriana Cruz, and as speakers, the philosophy and law professor, Jennifer Leckie, the psychology professor and coordinator of the Research and Teaching Laboratory for Cognition and Justice, William Seconello, and the professor of criminology and criminal law at the Faculty of Law of the University of São Paulo, Maurício Ditter. To conduct the work, Minister Antônio Saldanha Palheiro has the floor. Good morning.
Fico bastante envaidecido de poder participar de evento dessa envergadura.
It is very emotional for me to be a part of this event, such an important event, and particularly to be a part of this panel. As a judge, I had the opportunity of participating in the process of building a new interpretation and a new approach for how the facial identification is conducted. That is interesting since Article 236, which establishes the criteria and the legal rules for facial identification, was there. It was always there. And there was a mistaken understanding with regards to the severity and the hermeneutics of how we should conduct people recognition within the criminal courts of Rio de Janeiro, particularly. So I've experienced some things, and I must be making some self-criticism. Over there. There were a huge amount of processes, some of them very serious. And so there was always an interpretation with some lenient, recognizing what it should, not recognizing what it should be, but actually what it was. And there is this impression, not an absolute and complete idea of how people might have been suffering injustices due to this approach. On the one hand, the police was trying to solve issues. They were going after the necessary statistics to deliver the numbers, and the victims were impregnated with fear and with a desire to punish. They had a feeling of making justice through revenge. Someone is the victim of a crime, for example, if they were robbed, which is something that has a lot of emphasis through the eyewitnesses and the face recognition. And sometimes the police just wants to get rid of the investigation, that it is getting in the way of their statistics. They present a photograph, they ask the witness whether they're certain, they say that they are. Many times this is ratified in judgment, and people say, well, I'm sure it was him. At times, I was a part here in the National High Court of Brazil, and I participated in recreating the interpretation of this mechanism of how we should concretely conduct people identification. I should highlight the work of the Innocence project. The first time I came into contact with it, I was introduced to this project by Dr. Adriana, my dear friend. She's here. At the time we were in the pandemic, through video, she introduced the project to me, and I was impressed. She talked to me about it. But in the judicial scope, and I must highlight, even the determined action of Justice in 2020 judged in habeas corpus that I brought up 5598886, which was presented and deduced by the Public Prosecutor's Office of Santa Catarina. And indeed, it was a sentencing that had a significant impact. We would be then reviewing everything that we believe then to be sufficient. And also in the sense of us raising a reflection and thinking, well, how many times might I have made mistakes due to this? But through this habeas corpus, a long habeas corpus, we have 47 pages, and we have a reflection upon the methodology, scientific reflection in the criminology, legal, processual sense.
And it brought us, it presented on that vote, on that ruling, that it immediately had the addition of other members of the team, and Justice Sebastian is part of that team as well. And from then on, we can establish and demand in the instances of origin for them to actually abide by this mechanism. Bringing to suitable, to an adequate process, the judicial process, one that is dialectic, the issue of identification based on that which already was in the law. So it was right. We understood it incorrectly. We wanted it to be a certain way. So I am very proud to be able to be here today and talk about this. And we brought a specialist to ratify that which we already know is true, but we need for it to have a multiplying effect. We need to make so that these criteria that were always within the law are actually abided by with more rigorosity, with more rigor. We bring the responsibility of the prosecutor's office and the police authorities. We understand why they do what they do, or why these bad habits sort of took place along the years, which is a way of killing the investigations. We know that this happens, but in the concrete cases, we for many years, more than 30 years, so for a long time, we simply didn't want to see it. And the prosecutor's office also closed its eyes to this. We need to monitor the acts. The prosecutor's office demanded strongly this attribution then for it to be part of the country's constitution. This gives them a lot of power, a lot of prestige, but we need to turn this into concrete situations in action. Dr. Pedro has arrived, public defender, prosecutor, a real fighter, always bugs us with these processes, and with his determination. But he really fulfills his role very well. He really executes his role artfully, and it's a pleasure to preside a trial in which Dr. Pedro is defending those that need it. So from this trial, from this ruling that I repeat was launched in the Sixth Circle, we in a very positive way. We see that the processes arrive with a certain level of demand, and that's our role. That's just one of the things we need to work on. This legality shock. And this expression, I was here yesterday with Luciano Bandeira, who is the president of the Rio de Janeiro, he's the president of OAB, and we were discussing certain issues that sort of bother us as to how the police acts, police violence, should they have more flexibility, we asked ourselves. And he said, no, we need to have a legality shock. That's what he said. Even if that brings discomfort, we need to have that legality shock just to really bother them, to lead us to reflection. He works at the Brazilian Bar Association. He's the head of the Brazilian Bar Association. So this brings us the certainty that we are on the right path. These are just initial words to bring us into the topic, and I now hand over to Dr. Adriana Cruz. Good morning, everyone. I'd like to thank the invitation to preside this table with professors, with Justice Saldanha for us. As judges working in the field, so to speak, it's a little bit disruptive to be here side to side with the justices that we refer to in our decisions, in our rulings. So it's really thrilling. So I thank the opportunity. And I will now introduce the professors. We will not hear from me, we will hear from them. But I wanted to make an observation so that perhaps we can understand and have a dialogue between this table and the one that came before. There is no possibility that when we grab a pen, and here I'm not just talking about justices, I'm talking about the office of the attorney, the idea that black is all the same. So I need to have this legality shock. We need to have this shift in understanding. And I could talk about many situations. But I will tell a little story. I'm here called on by Justice Barroso. I came here last year. There are some other colleagues that were also called on. Karen, who's here, she works at the National Council of Justice, and many others. And the three of us were working. And here, as we arrived, Karine was here already, I arrived a little bit later. There was a multiverse, really, that established itself in Brasilia because people mistake us. And those of you who know us know that the only thing that differentiates us is just a slight shade of skin color, which have different hair color and eye color, and weight is different, height is different, the style in which we dress is different. But every day this happens, and we even joked, we even stopped correcting people so that we would embarrass them. Oh, I was here with you yesterday, they would say, oh, we just didn't correct them. It was wonderful, just to make it easier. And now I was promoted, and now they mistaken me with another person, with Justice Milene. We were there the other day at a party, and they said, Justice, it's really hard to be in the same physical space because people mistake us, even if it's curious. But I think it's for us to really ask ourselves, justices, judges with which you live day to day. You cannot actually tell them apart. How do you think someone can have the certainty of identification based on a fact that happens in seconds or minutes under stress? So it's something that gives us food for thought in a very practical way. All the dimensions of this racism that happens in a very concrete manner every day in the lives of people. I've said too much. Let me introduce the professors now. Today we have Professor Jennifer Lackey. She will talk in English. Professor Lackey is professor in law at Northwestern University, founding director of the Northwestern Prison Education Program. She received a medal in 2023 and the award Leibowitz for philosophical achievement and contribution, and she has 20 minutes for her speech.
Thank you so much. It's truly a pleasure to be here, and
Are my slides? Yep. The slides are available. Yeah.
Temos vídeo aqui, não estava no meu roteiro, eu pulei, perdoe. Vamos ao
I'm so sorry. We will now watch the video first.
Meu nome é Igor Barcelos, tenho 27 anos, moro no Jardim Corisco, Zona Norte de São Paulo. Fui preso por um crime que eu não cometi e condenado a 24 anos e 6 meses de reclusão. Na data do dia 2 de outubro de 2016, me trataram para levar para o hospital. Cheguei no hospital, eu estava numa maca, foi tirada uma foto minha ali na hora, que naquele momento eu estava na maca, e apresentaram a vítima, né? A vítima que tinha sofrido o crime terrorismo, entendeu? Eu falei que eu estava preso. Inclusive, são os amigos do Secretariat que me ajudou a tirar o gesso da minha perna. Porque se meus amigos mesmo não me ajudassem, me dassem um apoio a tirar o meu gesso da minha perna com um monte de gilete, prestogada, podia até me cortar. Vamos ser realistas, podia até me cortar. Eu tinha ficado sem perna hoje em dia, era bem capaz de ter ficado sem perna, porque o gesso prende a perna. Conforme passa o tempo, se você não tirar a tempo, ele vai inchando. Ele vai inchando por algum lugar e ele vai ter que sair. Entendeu? Aí foi onde eu tirei o gesso da minha perna, estava muito roxa. Mas tem que contar os pontos da minha perna. Os pontos da minha perna foi o que eu queria. Então, para resumir. Foi eu que tirei e fui no meio para não infeccionar, porque inclusive é tudo sujo, mano. Entendeu? É que nem tem pessoas que pegam doença hospitalar, é a mesma coisa. É a mesma coisa que está no presídio com o hospital aberto. Você pegar entendeu? Então, eu faço tantas coisas, por ser injustiça, entendeu? Você é uma pessoa nova, tanta coisa na minha vida que eu falo, você já falou na minha vida, sabe? Eu sou difícil. Eu não acredito que eu estou muito bom, você está na minha vida, como eu sou, eu gostei, entendeu? Tinha vez que eu tinha que ver minha menina pique, vou embora. Como é que se você escolhe da sua mãe, tá vendo? Você não vai ver ela por um bom tempo. Na hora que ele batia ela, eu falava que eu estava voltando assim. Eu ficava como? Eu virava as costas, tentava ser o mais forte possível, mas no meu cantinho ali sempre caiu uma raiva, né? Falar, caramba, tô muito tempo longe da minha família, minha avó, como é que tá? Minha mãe. E na época que eu estava na carreira do funk, estava tudo indo bem. Depois que aconteceu isso aí comigo, que veio essa injustiça, que eu fui preso, experiência da família, experiência do cachorro, do passarinho, que tinha em casa, experiência de todo mundo. Eu falei isso em tudo, não consegui mais. Eu quero estar agradecendo também por participar desse seminário aqui. E queria deixar um recado, entendeu? Para as pessoas que vão assistir esse vídeo, entendeu? Que o que aconteceu comigo, eu não quero nem desejo nem com o meu pior inimigo. Não quero que aconteça isso com mais ninguém. Porque uma pessoa incapacitada, na mapa do hospital, tentando se movimentar, perdendo muito sangue, de uma pessoa tirar uma foto sua e mostrar para a vítima, e você ser acusado por fotografia, não é justo. Porque eu sou da favela, eu sou da periferia, eu ando dessa forma, tenho tatuagem, em tudo. E você não pode julgar as pessoas pelo pela capa, entendeu? Você tem que procurar saber o que a pessoa faz na vida, se ela trabalha, entendeu? Se ela estuda, entendeu? Se ela tem filho para cuidar, e etc. E queria deixar esse recado, eles olhassem mais com cautela, entendeu? Com mais inteligência, entendeu? O povo da periferia, principalmente comunidade, para que não tem um recurso, que uma pessoa inteligente para trabalhar, que dá uma apoiada para o que está fazendo, tudo que está fazendo com você não é certo, entendeu? Não é uma periferia, mas eu não tenho estudo terminado, não faz isso. Entendeu? Procura ganhar nosso dia a dia, ganhar nosso pão, procura de um emprego aí. Entendeu? Justo tem que ser justo. Eu já irei com o Brasil e da frente. Estou aqui para agradecer de coração.
Professora, the floor is yours.
So much for having me here. It's really an honor, and thank you, Jana, for inviting me. So my area of expertise is in the United States criminal legal system. So all of the research and cases I'm going to be drawing on are from the United States. But I think that there are lessons to be learned from all of the mistakes we're making in the United States about eyewitness identifications more generally. So eyewitness testimony, I'm sure this is pretty prevalent, is a powerful form of evidence, and this is especially true in the United States criminal legal system. In this, dissent from 1981, Judge Brennan said, all of the evidence points rather strikingly to the conclusion that there is almost nothing more convincing than a live human being who takes the stand, points a finger at the defendant, and says, that's the one. But eyewitness misidentification in America is the greatest contributing factor to wrongful convictions proven by DNA testing, playing a role in nearly 70% of the 375 convictions overturned through DNA testing. So we have this kind of puzzle where on the one hand it's said to be perhaps the most powerful form of evidence for convictions, and yet it's also the form of evidence that is responsible for the most documented wrongful convictions in the United States. So I'm going to look at this kind of puzzle today, and I'm going to be focusing specifically on this. I'm just going to move over to here. I'm going to specifically be focusing on interpersonal cases. So there's all sorts of research that we're hearing about memory and contamination, and if there's a gun present, for instance, then attention is turned to the gun and not on the face, and so there's traces of memory. I have a friend that I've met in this work who wrongfully identified a man as her rapist, and he went to prison for nearly 20 years for it, and then DNA exonerated him. And she, to this day, says his face is still in her memories of the attack. It's just all of her memories have just been kind of impacted by seeing his face after the assault. So we know all of those kinds of things happen, but I want to focus specifically on the interpersonal cases. What can happen between people? Usually it would be like a lineup administrator or an interrogator, for instance, and the purported eyewitness, and the ways in which those things can lead to wrongful convictions. So just generally speaking, we all know that lineup administrators can steer witnesses towards particular identifications. This can happen in a number of ways. Some of the ones that are most documented are the number of fillers used in a lineup, the similarity to the suspect, the ordering of the people involved, and then cues that are provided either intentionally or unintentionally by the lineup administrator. And then there are all sorts of interrogation techniques. I'm only going to focus, because I only have 20 minutes, I'm going to focus, a lot of my research is specifically on interrogations of all sorts of people. So in the United States, I really don't know what it's like in Brazil, but in the United States, the same exact interrogation techniques are used for suspects, defendants, witnesses, victims, the same exact interrogation techniques. So these sorts of maximization techniques are used both when when they're trying to extract, for instance, a confession from someone, but also when they're trying to get information about an eyewitness identification. And so these maximization techniques are, the hard sell approach, which is, kind of usually, it's illegal in the United States to make a promise, a direct promise, but there's all sorts of implied promises and threats that play a role in various kinds of identifications. So I'm just going to take as a paradigmatic case a very sad and kind of we actually, I don't know how much you all follow news in America, but Missouri just actually executed someone a couple of weeks ago where there was just an outpouring. I mean, the prosecutor, everybody was begging the state to not execute this person because of concerns over his innocence, genuine concerns about his innocence, and the governor went through with the execution anyway. So this is not, this happens, with more regularity than it should in the United States. So this is the case of Troy Davis. A police officer was working as a security guard in Georgia when there was a homeless man who was being assaulted, and he went to intervene in the assault. And he ended up being killed, the officer. And Troy Davis was found guilty of the murder, and it was based almost entirely on eyewitness testimony. There were some other witnesses as well, but there was no physical evidence of any sort that connected him to the crime, but almost exclusively on eyewitness identifications. And despite the fact that lots of concerns were raised about the reliability of the eyewitness identifications, the state, and there were lots of protests and lots of public outcry, the state of Georgia went ahead and executed Troy Davis in 2011. Now, there were 10 eyewitnesses and 2 informants that provided the bulk of the case against Troy Davis. And in subsequent affidavits, an astonishing 9 of those 12 witnesses revealed that their testimony was false or inaccurate. And the one eyewitness that did not provide an affidavit is the person that people suspect was the actual killer of Officer McPhail. So these are just a couple of the witnesses. I'm not going to go through all the detail. Try to not be too much of an academic here. So Dorothy Farrell was one of the eyewitnesses, and they showed up at her house. They had one picture. They showed her the picture of Troy Davis. They said, and all of the evidence shows that, you're not supposed to give cues like this. You're supposed to have an array of at least 6 and so on. They just showed her the one photo and said other people had pointed him out as the killer of Officer McPhail. She was on parole at the time. She was worried about her children. There were some, implications that if she didn't cooperate in the way that they wanted, that she might go back to jail. She had to raise her kids, so she ended up identifying Troy Davis. You can see on the slide, she says, I had 4 children at the time, and I was taking care of them myself. I just couldn't go back to jail. Larry Young was the homeless person that had been attacked at the time. And he was bleeding. He had been assaulted, and so he was in the car, and they interrogated him for an hour in the car and then brought him back to the station and continued to interrogate him without providing any medical care until he gave them the identification that they wanted. Okay, so in this sort of case, I think that we can understand the kind of eyewitness identifications that we have here as being extracted from these witnesses. And we see this again in the United States criminal legal system. We see, for instance, victims of domestic violence often have recantations extracted from them. Suspects often have confessions extracted from them. And we see this a lot with eyewitnesses. When there is pressure, for instance, to close a case, oftentimes there is, and they zero in on a suspect, there's the pressure to get the eyewitness to identify the person that the investigators want to build a case against. And so we see this kind of extraction being, happening in a lot of different ways, but we see it mostly with manipulation, deception, and coercion. So when people are talking about rational decision-making, we think about going through people's agency. And the way we would do that is if you have an array of photos or a lineup and you say to the suspect questions that are appealing to their rational capacities. So was the person you saw above 6 feet or below 6 feet, right? Did they have a hat on or did they not have a hat on, right? So you're really appealing to their rational capacities. And that would be us going kind of through their agency. But we see in a lot of the ways that lineups are done and interrogations are done that there is I want to say intentional or non-intentional, irrational influence that's taking place. And so I know that the panel was on honest mistakes, and I think that some of these really are. I've been in lots of contexts in the United States, like for instance with people who do the training of police officers who do interrogations in the United States. And the training, the people who do the training are sort of horrified that they're being taught tactics that social scientists have shown a long time ago are really problematic. So I do believe that some of the processes that we see are non-intentional in various ways. And then we see all sorts of kinds of deception, withholding information or lying. So in the United States, it's completely legal for interrogators. Is that the case here as well? It's completely legal for interrogators to lie to suspects and witnesses. I mean, to the point where you can be, I have your DNA. We have, you were identified by these people. And so deception has been shown to be a very powerful form of extracting testimony. And then various kinds of coercion, like implied threats and promises. So we see in the Troy Davis case that Farrell was shown a single photo of Davis. She was given a cue to kind of pick up on it. And that's ways in which there was manipulation. She was threatened with arrest, and so it's unclear whether they were being serious or not, but either way, either the threat was functioning coercively or it was functioning deceptively and coercively if they had no intention of actually arresting her. And so there are general features of lineups and interrogations through this interpersonal exchange, these interpersonal exchanges that we see are problematic. So these are some of the things that we highlighted earlier, the number of fillers, similarity, and so on, in ways they can be manipulative. Lineups often involve deception regarding, for instance, previously existing evidence, saying like someone else picked this guy out. Regarding the lineup process, suggesting that the person is actually in there, the suspect is in fact in the lineup, or the consequences. You'll go to jail if you don't pick out the person we want. And then all of the implied threats and promises can be coercive. And then the interrogation techniques, I think this is a pretty straightforward one. So one of the things that I really want to kind of leave the discussion with, that I'm curious, I don't know how much this is of an issue this is in Brazil, but many of the wrongful convictions based on eyewitness identifications, there is no DNA evidence available to be tested. So that number, when you're looking at 370, it's so artificially small, right? Because it takes so long to exonerate someone. And on top of it, many of the cases don't have any DNA evidence. So what a lot of them do involve, I mean, I work with a lot of incarcerated people, and so many of them who are wrongfully convicted on the basis of eyewitness identifications, there's the possibility of getting affidavits that involve recantations, because many times people, if they did give false testimony early on, maybe change or grow or have their conscience is sort of riddled with doubt, and so they come forward and recant later on. And in the United States, these are just dismissed. You see court opinions where it literally says things like, we all know that recantations are just unreliable. Like, you see these sweeping claims about them. And yet there's all sorts of reason to believe that recantations can often be very reliable. So one of the things that happens in these cases is that the eyewitness identifications get this massive excess of credibility. Again, thinking about the first slide we saw, a judge one time said, eyewitness testimony may be the least reliable and yet the most compelling. And so again, this sort of tension between the oversized role it plays in criminal convictions and its kind of low reliability in many cases. So I'm going to skip this, and I'm going to, because I want to save some time for the main thing I want to get across. So eyewitness testimony, when we're talking about this excess, has 3 different ways in which it plays an oversized evidential role. So it's weighed too heavily in the United States criminal legal system. It distorts other evidence, and it's resistant to counter evidence. So it's weighed too heavily, for instance, that we execute people purely on the basis of it, even after, nearly all of the evidence has been recanted. And so I think that when you have executions being done purely on the basis of eyewitness testimony, especially eyewitness testimony that we have good reason to believe was coerced or manipulated, it looks like it's being weighed too heavily. This is a former student of mine that I founded a program in the United States that provides bachelor's degrees to people who are incarcerated, and I met him inside. And so eyewitness testimony distorts other evidence. So his name is Albert, and he spent nearly 30 years incarcerated for a crime he didn't commit, that he was arrested for as a child, as a juvenile. Here he is talking about his wrongful conviction at an event we hosted at Northwestern. And so the eyewitness had been threatened not by interrogators, but by a rival gang member who had actually killed the person in question and told Willie Johnson, you're not going to say it was me. So Willie Johnson just kind of was thinking about someone on the block, and he just mentioned Albert, okay? The thing I really want to highlight here about the role of recantations is the way that they are handled in the United States. Again, I told you that you have court opinions which just say things like they're just unreliable. So Willie Johnson moved out of Illinois. He moved to Texas. He left the gang. He was a vice lord. He left the gang. He got married. He had children. He was a stay-at-home dad. And he just was all these years, 2 people, because it was Albert and his friend Cedric, are locked up right now for crimes they didn't commit. So he submitted an affidavit and said, I lied. I was afraid this rival gang member, the actual shooter, threatened my mother. That is what happened. He threatened my mother. The Illinois state's attorney at the time, Anita Alvarez, was outraged by this and threatened to prosecute him for perjury. She said, these 2 things can't be true. You said it was, and now you're saying it wasn't. So I'm just going to charge you with perjury. There was a huge outcry. All of these judges and prosecutors and defense attorneys submitted forms, submitted a letter saying, this is going to chill the truth, because if you go after people and prosecute them for recanting, no one's going to recant, right? This is not something that is serving justice. She didn't listen, and she prosecuted Willie Johnson, sent him to prison, and the only reason he got out was because the governor was was going out of office, and he pardoned him right when he left office. Albert served nearly 30 years, and he still does not have his certificate of innocence, in large part because of what Anita Alvarez did. So this is to say that the attitude that people have towards recantations needs to change, because so many wrongful convictions cannot be overturned when there's no DNA evidence. All we have is that somebody said that it was at one time, and then they come back and they are riddled with guilt. There's so many cases. I could tell you so many cases. Anyway, I'm not going to tell you about all of them. But I talk about Albert because it was such he's a friend of mine, but also it was a shocking case, the way that the state's attorney handled it. Incarcerated the witness who came forward. Anyway, sorry, I'm going on and on. Okay, so it's resistant to counter evidence, this evidence. Again, when 9 out of 12 witnesses recant in the Troy Davis case, and the one who doesn't is the suspected shooter, and we still execute this man, I think it's pretty clear that eyewitness identifications are often resistant to counter evidence. Okay. So basically, I, in my research, have identified this notion of agential testimonial injustice, and I say that it is we see it throughout the criminal legal system. In a book I recently wrote, I start in the interrogation room and show how we extract testimony from people in ways that don't honor their agency. I was struck in the first video from the Innocence Project when Mr. Silva was talking about treating him like a human with respect and with dignity, right? And this is something that we don't do to anyone in the United States criminal legal system. And I mean not suspects, defendants, witnesses, victims. They're all treated horribly. And so I start in the first chapter in the interrogation room, and I end in front of parole boards, because we see so much of the same thing throughout from start to finish. The state is extracting testimony from all of its participants, and then that testimony plays this big oversized evidential role and not the testimony that they give when they're not being interrogated or not being pressured to say something. And so I identify some of the ways in which this wrongs people. One is through, bypassing someone's agency, and then the second one is regarding them as reliable only when they're sort of a puppet of the state. And so just to bring this to a close, lineups and interrogations often extract testimony from eyewitnesses, from all sorts of people in the system, through processes that are manipulative, deceptive, or coercive. And when that extracted testimony is given this unwarranted excess of credibility, I've argued in some of my other work that there's a distinctive kind of injustice that is perpetrated. Since much of the testimony of eyewitnesses in criminal cases in the United States is both extracted and given this excess of credibility, there's this fairly widespread form of injustice being perpetrated in the system. So otherwise put, I think courts are systematically privileging forms of testimonial evidence that are derived from the straightforward application of state power. And so this calls for significant reforms, and there's lots of different reforms, that we can do with respect to the mistakes of witnesses, but with respect to the interpersonal issues that I think are, I wanted to focus on today. Lineups and interrogations should go through the agency of eyewitnesses rather than bypassing it, for instance. And so the resulting testimony should be viewed as a highly fallible source of evidence that needs to be substantially corroborated, something we don't actually do very often in the States. And such reforms have the result of not only treating witnesses as rational agents deserving of respect, something that I mentioned we saw in the earlier video, but also of reducing the number of life-shattering wrongful convictions like Albert Kirkman's and Troy Davis's, for instance, based on false eyewitness testimony. So that's it. Thanks.
Muito obrigada, professora. Aproveitar, tomar a liberdade de sugerir a leitura das obras, alguns textos da professora de
texts that are available, and also your book. I highly recommend it. I did my homework and I looked for it yesterday. So continuing now with the agenda, with the table, we will now hear from Professor William Seconcello, professor in psychology by the University of Rio Grande do Sul and the University of Arnstville. He is the coordinator of the Teaching Laboratory and Research in Cognition and Justice, and he also is a member of the Convention Against Torture and was a consultant at the National Council of Justice. And we talked about the resolution that he presides. Thank you very much, Professor. Very well. Good morning to everyone. I would like to briefly thank the organizers of the event, the speakers that came before me and that are here on the table, and those who will come after me, and also those who are here for a little bit more than a year, and your cognitive apparatus switched on for us to hear and discuss on this issue that is the innocent identification, acknowledging those that are innocent. Perhaps It's a strange, I'm sort of a strange individual because I'm not a criminologist. I'm actually a healthcare professional. I'm a psychologist, but more than that, I'm a researcher. I'm a scientist that tries to understand human memory and from that understand what can lead to misidentification and how we can avoid it. There are, in Twitter times, which are now apparently back, there's a phrase that starts with climate issues that we saw quite often, which is that every catastrophe film starts with a scientist being ignored, right? So we can draw a parallel with identification of individuals, which is not such a new problem in our justice system. In 2015, there was a report done with the Ministry of Justice with Professor Lilian Stein. I was mentored by her, and also all the researchers such as Avila that mapped issues with identification of people in Brazil. And at that time, they called researchers from other countries to look at the data and look at the results, and the result of that mapping as to what the practices were in Brazil. And at the time, a researcher that was quite famous today, he's no longer active, he gave a diagnostics and he said, look, Brazil is not the only country that has issues with the recognition of persons or inadequate processes with identification. We were the first country to have all of the problems together all at once. And that awards us sort of a diagnostics of how the situation was and what has changed along the last 9 years. Of course, I am an optimist. If we have an event today to discuss this, if we have the resolution 484, if we have now people that are engaged and committed, we need to look at it. We need to look at this movement to precisely avoid for this problem to perpetuate. And I'm very happy that we are talking, and it's been mentioned, to bring the science. We need to hear science because we had other times in which we should have listened to science. A few years ago, we had a pandemic that forced us to listen to scientists to understand the issues that we were going through at a global level that was invisible and had a group of individuals that were more vulnerable, and we needed to pay attention to that. In the same manner, we need to do this with the people identification, as Jennifer brought, is not an issue that is restricted to Brazil, but it is a global issue. It's a problem. We have researchers studying this issue. But it's also a problem that is invisible because you don't see a false recognition. You don't physically see a memory leaving, or you're not able to assess whether a memory is right or wrong. But the victims have, of course, the consequences. And as we saw, there are those in Brazil that are more vulnerable, more susceptible to being victims of misidentification. My contributions here today are as a researcher, so I can contribute with the understanding of this issue, understanding why it happens, and from that understand also what can be done to avoid for it to continue to take place. Because researchers have, different from those who are judges, who need to try, or a police officer who need to work on a procedure, researchers can do controlled studies. If I want to know if it's better to identify a person through a photograph or not, I can simply simulate an attack here, an assault, and then half of those groups I can present the suspect through a photograph, and to the other half I will have this in person, and then I actually have data out of that study to inform the justice system. So my role here is to briefly bring some considerations as to why these honest mistakes take place from the cognitive point of view and the practices point of view, and what science can contribute so that we can avoid for them to continue to take place. Well, We talk about identification of people, and sometimes it's counterintuitive, or it seems to be counterintuitive for us to have so many issues in recognition and identification, since we're actually quite good at it. Day to day, I can leave the house, I can do my job, and I don't have to ask myself who that person is all the time. I can look, I can identify in my day-to-day life. We have, for example, we had elections last Sunday. I went to vote in the same school where I actually studied, primary school. When I got there, I found people that I hadn't seen in 20 years, more than 20 years, and I was able to identify them, no problem at all. And I was right in my recognition. And if you asked me if I was confident as to whether or not those people were people, I knew I was. So we need to be careful so we don't draw false parallels from a cognitive standpoint. When I am talking about a familiar face, for example, a person that was a schoolmate, a professor, a relative, a friend. I'm talking about a consolidated memory. It is a memory that is very well fixated, and it would be very difficult. Of course, I can recognize my mother if you placed her here on the stage right now, because I've looked at her face many times from different angles, with different clothing, different hairdos. I had many actions with that face, so my memory of that face is consolidated. But I can't draw a false parallel when I'm talking about identification of faces that are not familiar. It's a face that I saw once under conditions that are not the best for me to have a consolidated memory. A person that was talking here for 20 minutes and I was able to look at it, it's actually an attack or an assault that happened when I was in my car. It was dark, there were two people, one was wearing a helmet. All of those are variables that make that memory of an unfamiliar face that is already fragile even more compromised. And this is what we try to understand. What are those variables and what can we do with that? In general, we can divide those variables into two groups. One would be the variables of estimation that are, for example, the issue of distance, whether the person was wearing a helmet, what the time of day was, if there were many, few people together, race, if the person belonged to a race different from mine. These are variables that we call estimation or estimation variables. I'm going to have to hurry up because I thought I had 20 minutes. So,
Posso seguir? Então tá. Então vou segurar. Tá. Então muito bem. Voltando ao que eu estava falando.
Going back to what I was saying. We had these variables that we can only estimate that they have an impact on identification, but there are other variables that the justice system controls, such as how that suspect is presented, how that witness will be instructed. All of these are variables that have an impact. This is an experiment that I generally do, is to show a video of a person stealing a notebook. Then I show 6 photos and ask people to tell me which person is the one that you just saw stealing the notebook. In general, I manage 80 to 90% error. Why? Because of the photo? No. Because of the instruction I give. Because I say, who out of those people was the one that you just saw? Just the fact that I don't mention that it could be that the person is not actually there is a variable. So this is what thinkers try to understand, so that from that point they can understand honest mistakes and stop them from happening. So we need to understand this, and going back to the variables of estimation, such as race, we have cognitive factors that will have an effect on the identification of people of another race, because for that we are not our own rules. So if I'm a white person, I will measure people from my face. So if the person, for example, an Asian person, I will find their eye quite quite different because it's different from mine. Black people I will find as a distinctive the color of the skin or the width of the nose, because these are features of a race, and this makes it so that I am predisposed to making mistakes. When we look at the race issue and we bring this cognitive aspect purely, this doesn't explain on its own the error that I have in the justice system. It's harder to acknowledge people, to identify people of another race. Yes, the error is actually increases at 30% roughly. When I go to Brazil, I see the people that were victims, innocent people that were misidentified. The statistics of people that were misidentified and are innocent and are Black is 80%. Which means that the cognition alone doesn't explain this. We have a group of individuals that are being more exposed to inadequate procedures in the justice system. And we need to look at what are those procedures that I need to avoid, what are the procedures that I need to then look for so that everyone is submitted to identification in an appropriate manner. Firstly, the main issue with the identification is the justice procedures, and here I will cite 3 of them. Show up is the first one. For lack of a translation, is when, for example, they stole my car, the military police comes and they show me a photo, or they bring someone to the police station and they bring just one person. They present this person on its own. That is the procedure with the highest risk of misidentification that we currently have documented. From research from last year with more than 1,200 individuals, when they identified through show up, and only those that had 90 to 100% of certainty were taken into account. They verified that 50% out of them were misidentified. So you want to do a show up to save time throwing a coin and flip it, the heads or tails, that will be the same. We need to look at these procedures. The first one is that show up is a problem. The second is the suspect album. It could be physical, it could be virtual. I have people that have already been investigated for similar crimes, and I have on file at the police station their images. I have a problem, firstly, which is that I already have a predisposition for the witness to identify a person because I think at least that they were all involved in crimes. And I have another factor, which is that 50% of the individuals that identify an innocent person, they identify it again when there is a suitable lineup. So there is sort of the memory is compromised, and this could be the main problem, which is the repetition of people identification. Remember, we talked about this fragile memory of a face that is not familiar, that is quite fragile. The memory is fragile. And the first identification then becomes crucial. Why? Because memory was developed with an evolutionary aspect that is quite important to us, which is to enable learning. And to enable learning, it means that I saw a face. I have that memory. And then you show me a new face of an innocent person, I recognize. But for my memory, it means that I am learning how the face of the person that committed the crime was. So then the police, with the best of intentions, does their recognition. I recognize that innocent person. And then the civil police follows procedure following the resolution, the 484, they do the lineup and so forth. The trend is that I will identify the person again with more confidence. I will have more trust in the fact that I am right. And then you get, and then you're crying in front of the judge saying that that is the person that committed the crime. When in actual fact, the justice system reinforced that identification for me to acknowledge that person yet again. I would love for that trust, for that confidence to be an excellent indication of precision. I believe that Even those in the Innocence Project would love for confidence to be a good indication because that would make the job it would ease the job, it would make it easier. But that would be so easy, such as testing the water to see if it's drinkable or not. I can buy a test. If it's green, I can drink it. If it's red, I shouldn't drink it. Unfortunately, this rule with which I can measure that memory doesn't exist for me to have that indication. But I invite you to think about this. How many of you drank water today? I hope all of you. Hope you're all well hydrated. How many needed to test that water before you drank? How many of you trusted that you could drink that water because you had a test and it came out red or green? I hope none of you, because this could be a symptom of paranoia even. I don't think there is reason to do this test. Why? Because all of us here trust that there were good procedures that brought that water to us for us to drink. And that is the role that science places in the importance of the judge, which is not placing the rule to know if it's red or green, do the test, but it needs to look at the procedures that brought this identification to that point, because from a cognitive standpoint, the recognition is non-repeatable. Once the identification happened, that identification is already compromised. I would have many recommendations, but I'm actually coming up to my time. Many recommendations that science can bring. Summing up, I can say that they are contemplated in the resolution 484, and also in these guidelines there is a scientific explanation that as to why what's in the resolution is not a mere opinion as to why something should happen this way or another way. So if the show-up is bad, why is the show-up is bad? We have a statistic. We have the basis to say this, to make this statement. Some people agreed with me. So I'd like to bring this point. The photo recognition is not the issue. It's not the issue in Brazil, the fact that we use photographs. The problem is that we use suspect albums and show up, because it's important for us to think about this. Otherwise, we take away the photo and we seemingly solve the issue. Instead of showing the photo of the Igor, I will bring the victim in person, just look at him in the hospital. No, this would be the same. Instead of having a suspect album, I would just bring all of those suspects, place them here in person. It's not the presence of the person. It's the way in which I use it. So when I talk about photo recognition, following what's in the resolution, which is to have an appropriate lineup in which the suspect is not doesn't stand out with other innocents. I am talking once again not as a personal opinion, because it's already been there's a scientific basis to show that the photo is a possible alternative. Is it the only one? No, but it's important for us to look at the procedures and not just to the means, because otherwise we will not move forward, or we could even bring instead of moving forward, we could actually stagnate. Thank you very much once again. Thank you. Thank you very much, Professor. For us to manage to keep our time, we will now hand over to Professor Mauricio Dieter. He's a professor in criminal law at the University of São Paulo. He's a postgraduate from the University of Rio de Janeiro, and he's a criminalist lawyer. And now you also have 20 minutes. Thank you very much. I hope you're all tired and hungry. such as most of the prisoners in Brazil. It's good to think about this, to identify and to empathize also. Thank you very much. I'd like to greet Justice Saldanha, Jennifer, other researchers that are interested in the topic. I greet Sketch Cruz, an ethical important presence for us, Dr. Dora Cavalcante, Flavia. Your work is exceptional, and I am very honored to have cooperated with your work and for us to establish this link, which is both intellectual and affectionate. I really feel at home. Dr. Pedro Carrero, who just received the best my colleagues, fellow lawyers, professors, researchers, Dr. Janina Matilda, Carol, who organized this, Dr. Ana Maria Prats, and many others, or other speakers who preceded me and who will come after me. Thank you for keeping men and women of great dignity. But I am not kidding myself, because yesterday, today, and tomorrow, despite what's happening, we will continue to have problems in São Paulo. We're leading, unfortunately, this process to negate the jurisprudence and the president of the Supreme Court of Brazil and best practices as defined in the resolution 484. So we maintain the illusion, but without kidding ourselves. The fight barely begins. This is something that has been affecting me 10 years ago when I went into University of São Paulo. I was just as any new professor destined to those topics that are sort of at the end. I was given forensic psychology as a topic to teach, and I really found great potential in this to start discussing the production within the criminal systems. And I created this discipline called criminology, subjectivity, and I've been working for 10 years in it, because every system that we worked here, misidentification, false accusations, the hypothesis for subjectivity, for biases that lead to more convictions than freedom, integrate this. And the criminology is still quite small.
Most of those that have graduated ever since the 2000s had 6 months of psychology as an elective class, and it is fundamental for those of us working on the system of criminal justice to have a critical and theoretical education about this. Recently, in this initiative of making rights and guarantees popularized, we made a movie saying, "I have been approached by the police. What now?" And Justice Saldanha, I should say, we took 10 years to record this short movie to talk about people's rights, and the courts weren't even aware of what were the rights of the people being approached by the police. You have the right to remain silent. You don't have the right to remain silent. The policeman has the right to look at the person's phone. They don't. Well, and I want you to understand what a person can say or not when they're being approached by the police. And there was no consensus. They didn't even know whether running away was a foundation for suspicion. And the innocence of those persons were not protected by the normal police work. And I want to thank Dr. Luiz Anfred that named me in the work group of the Council of Justice with a lot of other researchers with different perspectives, and we built a technical document that was very important. It is also important for us to be aware of the distance of the theory and the actual practice. In Brazil, we should notice that liberalism has always been authoritative. We can talk against racism and maintain the criminalization of disrespect. We know exactly the pathways that bring racial differentialization. For example, the production of traffickers. They have an unworthy life And they can change the way of the life by changing the naming. And the justice system should take care of the policeman action, but they are sometimes made responsible for violence. And from the technical standpoint, I want to demonstrate alibis, and this is tough. Sometimes the suspect is arrested even promoting an alibi, the insufficiency of evidence. They need to prove that this person is not the culprit, not the other way around. But the crime needs to be terrible for the person to believe. The suspect needs to be desperate. So we need to be careful with that. These cases, they are sensitive, they bring a lot of social mobilization, and we need to work on that instead of rendering people innocent. And this has a big role in the system of criminal justice. In my speech, I should say that we have to wonder why women that are being raped by people they do not know make so many mistakes when identifying the culprit. This is a very dramatic case. This is one of the worst crimes that exist. Rape mobilizes the senses immediately, and it goes hand in hand with murder, the most abominable of crimes, and they interiorize risks as their content. And within the research, as I said, that had its continuity, had also an impact of Ms. Brennan-Garrett, and that in cases of murder, rape, or rape followed by murder, the rate of identification by the witnesses was about 68%. How is it possible? This person was inches away from this other person doing an abominable act of violence. How can they not remember that person's face? And those rapes that were conducted by people they do not know, and as you know, that is not the case. Most of the times you have friends, you have boyfriends raping. So this is normally done by someone familiar. But when this is done by someone they do not know, a lot of errors come from that. So a woman will sometimes point out a subject and say, well, this was the person, and sometimes it wasn't. And there is an affiliation in this identification due to how scared these people are, undergoing a stressful situation. Sometimes the place where this happens is dark. Sometimes the person is focusing on the weapon being used during the rapes, maybe a knife, maybe even a firearm. And so their focus is not on the face of the culprit, of the perpetrator, but on escape routes. And this is a subjective displacement, since the victim is not there. She's trying to remove themselves from the situation. They're thinking, I'm not here, I shouldn't be here. So they can't even think about identifying this person because they want to rebuild their subjectivity after this abominable act. So the measures to protect the victim and innocence, they need to walk hand in hand in such sensitive cases. And this implies very rigid protocols. And in some of the cases where victims of rape that were raped by people they do not know, photographs can be the best options for identification instead of having re-victimization in bringing that person face to face to her rapist again. And in the evolution of psychology, when you're telling an incomplete story due to that lack, you cannot unsee this person. I can't unsee the face that I identified, even though I know that this person is innocent. They are also victims of the misidentification. They're going to feel guilty. And that woman will say, I cannot believe that it wasn't him. He entered into my story to take this place. And I found something that really raised my attention, and I need to tell it to you. Sports to continue to evolve. We took a big step in identification. And I want to bring another dimension to this topic, which is the common changes and also recantations in the witnesses that are testifying to rape. And we have a lot of changes in the narrative in those testimonies. Women that were raped and women that were not raped, but they are saying that they changed their testimonies. And so we have the credibility of the word of the victim. But if they're changing the word, is that less reliable or more reliable? How is this evolution of the narrative of rape victims being dealt with? How can we make a difference between the actual testimonies and the false accusations? For example, you have a rape accusation that is somehow inexact, or you have a fact that did not happen due to a deliberate lie from the victim, or due to a fantasy, sometimes determined by adjacent psychic problems. This was a research by a regional journal of criminology. And this researcher talks about cases of rape where there was a moment of a false testimony. And this false testimony does not correspond to what can be proved by an empirical verification. And those moments of falsifying the narrative of the victim of a sexual crime can have non-intentional reasons. For example, the fallibility that we know of the register, or the bureaucracy, that it is also a problem. The way that the narrative is formed sometimes brings contradictions, or other intentional motives, such as regret, or as an impact to the uncertainty, or protecting someone specifically. Normally, when you have an actual rape with things that are not exact, people are actually bridging gaps, and they're trying to correct imprecisions. So a rape victim says that this happened about 5 p.m. But there is a footage from a cam saying that no, that was not the time. The time was 6 p.m. And then she said, no, the culprit had a white shirt. And then no, the footage says no, he had a black shirt. And this is different from false testimony. And here I'm entering a sensitive topic that demands maturity. And this is an issue within the criminologic field as a whole. False testimony in rape is very uncommon for people that are unknown. In places such as Brazil, where legal abortion is valid for cases of rape, you have many more rapes being alleged so that women can enter into the healthcare system to be able to have an abortion. And on the other hand, false testimony in rapes is very common for people that they do know when there is a dispute for the minors guard, parental alienation, when there are disputes, and then there are sexual allegations, so that a mother can keep their children and within an intimate scope. Literature says that when we are dealing with custody, and in those cases, different from the other reports that are changing, what happens is not the bridging of gaps, but the saturation of inconsistencies and the suppression of failures within the narrative when you receive a counter proof. The victim of a real rape, when she sees something that is not consistent with her report, in reality, she's going to say that they do not know how to explain that inconsistency. But someone who is lying will try to change their narrative to say that, no, it was different. And what is the dimension of all of this? Susan Brown Miller, in a classical book called Against All Will, presented data that was internalized by the criminology field that has not been disputed, saying that only 2% of rape allegations would be false. So a minor issue. But the Uniform Crime Report from FBI has presented 15% of false allegations in rape within the same time range. So this number of Susan Brown Miller is wrong. In later studies with peer review in 1973 and 2004 in the United States, United Kingdom, and New Zealand, identified that from 8 to 41% of rape allegations were false. rapes that did not happen. And in reviewing that methodology, as a rule, we went back to the same status of 15% of false rape allegations. Here I'm going to make a pause for ethical sensitive matter. The word of the victim in those types of crimes will not invert the presumption of innocence within a criminal process, within the logic of the criminal process. And in that sense, bringing credibility to a report from a victim of a crime of rape means to take it seriously, above all. And this is something else entirely. It means to submit it to evidences without offending the dignity of the woman that is making the report. But what is the protocol to test that? The literature says, how can we identify false accusations? The first one would be falsifications and omissions. This is not uncommon in actual reports that they have some small lies, some falsifications, sometimes because the victim is embarrassed. They want to hide elements that would make them be guilty because they are feeling guilty themselves. For example, clothes or anything else that could bring blame onto them. So contradictions are not necessarily a problem. Just because a real report from a rape victim is inconsistent, this does not mean that it is false, because this is not something uncommon. And we need to be careful when contacting the criminalistic, the forensic psychology, and the report of the victim. We should not attack the victim's character. We should not bring them any indignity, but there is a statistic relationship between the background of false crime reporting, and previously the use of drugs and psychic suffering previously, and all of this needs to be corrected before the investigation. When this reaches the investigation, there are impurities that cannot be corrected by traditional methods. The third element is the interview with the victim, and this cannot have a logic of an interrogation, something incisive, but the criminal process is a place of doubt, a place of debate. So the interview with the victim in Brazil, I would say, has the main problem, which is how the investigator is apathic. They're not making a real investigation, and they have evidence standards that are very low. And this, of course, implies a different training for policemen in Brazil. And to conclude, what the literature found out about the motivations for false rape accusations, or things that should at least alert the investigation of such sensitive crimes, would be first the obtention of advantage by the part of the victim in any way. There are particularities in the research of the United States where the information is concentrated, where you have procedures for a board, financial advantage, previous relationship with the accused, affective dispute, divorce, or the custody of minors. In order to hide the practice of illicit acts, this as an alibi or a justification for unlawful actions by the victim or others, trying to avoid a social accuse. So you have rapes in campings, university camps normally in the United States. So there is a frustration of a social expectation of grades in the campus, of the development of the young women there. And so this has a deviation of social and emotional matters. Matters of social health, psychotic breaks, which is very rare, or psychic suffering, which has a subjective illness related to it. But we need to start from the good faith. When we are considering an honest mistake of actual victims that are identifying third parties, and in their narratives, we cannot separate the two. We cannot separate the narrative of the identification and how far are we from considering the sex crimes in Brazil that today they focus our attention from the small amount of considerations by the academy. It is always good to talk about the Federal Prosecutor's Office, but here I'm blaming the academia. In what law class did we have classes talking about rape crimes, a revision of case law? Where did we study the literature about that? Nowhere. And here, looking at the data of the Public Prosecutor's Office in the Federal District, the main entry door for the hearings in Brazil are of domestic violence. And then we see rapes in that scope. And as a conclusion, as a type of mea culpa, the literature in Brazil is very delayed in systematically studying the topic, even though this is central within the political discourse in Brazil. And we need to consider the sentencing and the rulings with more deepness. And this is a new and complicated topic, but I think that the National Council of Justice needs to start to consider that, to qualify the technical legal decisions. And these rulings need to be built with a basis on that. And now I want to define a new study program on that sense. It is, of course, something that should always privilege the protection of human dignity without setting aside the presumption of innocence, which is one of our principles. Thank you very much.
Would like to thank all of the Professor Mauricio, for your wonderful explanation. I would like to greet once again the initiative of the event. And I would like to make a suggestion. I think we need to continue talking about this, and perhaps it would be important to think about an event specifically, perhaps a training specifically on the issue of sexual crimes and the analysis from the perspective of gender. We have Professor Carolina here, who has wonderful works with from general theory and specific suggestion. Then I leave my suggestion. Sometimes we suggest and then the work comes knocking on our door, but I think it's important. I now hand over to our president, Antonio Saldanha. Thank you very much, everyone. I'm sure that we leave enriched after these speakers, after these words, particularly Professor Jeter's speech, who brings to our reflection the penal right that makes us very uncomfortable, a procedure in which the evidence is precarious, it's hazy, and even if we are embedded in the gender point of view, it sort of makes us uncomfortable as an injustice is being committed. And the evidence against sexual dignity are, from everything we know, the way they're committed in hiding, they rarely have a witness proof or evidence or a scientific or technical proof. And this brings us a lot of friction.
Além de tudo, professor,
we have dealt with quite often with sexual crimes that are committed in a special way or a different way in certain parts of the country, which are young men of 18 having sexual intercourse with 13-year-olds, and there was no violence, but there is a rape. So something that brings us great worries that they then have a relationship. Will you take him out of that relationship that is consolidated as a familiar relationship and take him to prison for 8 years? We deal with this perplexity. And sexual crimes, in them we have witnessed issues of indubio pro reo, and it doesn't really work in this case. Because if you think about a victim, this permanent contradiction, those who work with this system are oftentimes place the onus on the judge. Am I leaving the rapist set free? Am I convicting an innocent man? It's not rare that there are uncertainties. So, this pretension that we actually do justice is an illusion. We merely coordinate in the best way possible. So I'd like to thank you all. Congratulations, Professor Jennifer, Professor Jeter, and Dr. William, and my dear Adriana, who conducted the works masterfully. Thank you very much. Ladies and gentlemen, we'd like to thank all the speakers, and we will have a recess for lunch. We will come back at 2 p.m. A request of democracy itself and the republic itself, a vision which we have to reflect precisely on the guarantees and on the principles, constitutional principles, and at the same time be able to see the aggressor, the victim, and the community and the society as a whole. And that evidently sort of comes back with the whole proposal today that is not so new, but where we begin once again from a perspective of restorative justice, which is the cycle that places us in this reflection always. And when we deal with this effort of qualifying the investigation and the production of evidence, this reflection becomes apparent, and nothing better than to have today a table that is so diverse, in which the actors of the justice system will bring us their views, their difficulties, their perplexities in the search of a penal process that is just, democratic, and at the same time firm in the sense of abiding by the law without forgetting at any point of the constitutional guarantees. And it is in that sense that we are working with the judicial errors. It is in that sense that we work with the possibility of making mistakes as human beings. And therefore, we have within the justice system quick mechanisms that are not that quick, right, Dr. Flavia? In actual fact, there are mechanisms that we find as we move along precisely to correct something which is wrong. And that is not the commitment of the prosecutor's office or the advocacy or the public defender's office, and it's not the commitment of the judicial power. In that sense, that this table is very much pertinent. We have here at the National High Court of Brazil some cases that are emblematic, that show errors in 60 cases, some in 14 cases, 16 cases, and the surge of evidence production that goes along a penal process that is just, that is appropriate, that we are here in the search of that instrument that is so important, which is today the genetic bank. And that here at the High Court, with the Innocence Project, with the Public Prosecutor's Office of São Paulo, we managed to correct some grave errors within the justice system. Therefore, Just those initial words. We have a very diverse table and limited time for each person to bring their contributions. Before that, I would like to greet, first of all, each one of you here at the table. Dr. Adalberto José Queiroz Teles de Camargo Aranha Filho, who is the president of the section of criminal law in São Paulo. Dr. Anderson Jean Piaoli, Chief of Police in the state of São Paulo, responsible for the Secretariat of Courses and Training of the Police Academy of São Paulo. The Public Defender's Office present here, as we are joined by Pedro Carriero, who is always here with us on Thursday on every session. I think he competes with Dr. Flavia and other doctors in that sense. Dr. Daniela Favaro, who is an example of the Public Prosecutor's Office, which is very much active and worries with the defense of the judicial order. That is important. And with the constitutional system being followed. She tried a case that involved other cases, and she had the courage to talk and to request that a more careful study would be made in that case. So I only have good things to say. National Secretary of Public Safety, Dr. Mario Sarrubo, and he also worked in safety in the state of São Paulo. Without a doubt, they honor us and they brighten the institution with their performance as a member of the Public Prosecutor's Office and defenders of constitutional guarantees and rights. Therefore, after that introduction and introducing each one of the speakers, I would now like to announce that we will have 2 videos with testimonies of cases, and after those videos, we will have our speakers share with us their comments.
Oi, eu fui condenado injustamente por 2 anos, onde tive a vida parada, né? Sofri muito naquele lugar. Eu estudo hoje com exatamente 6 anos, quando eu fui preso, eu tinha 3 anos de idade, então pude acompanhar dele. Minha vida normalmente, uma vida
era CLT, trabalhava registrado. Infelizmente, todos os meus sonhos que eu tinha foi cortado, perdi, né? Porque fiquei todo esse tempo lá. E foi um momento da minha vida muito chateante, muito triste para mim. Não só para mim, como para toda a minha família, né? Que estava do lado de fora, mas querendo ou não, quando a gente cai num lugar daquele horrível, a família acaba ficando presa junto com a gente também, né? Como eu já disse, eu senti muita falta do meu filho, né? Porque nesses 2 anos e 2 meses que eu fiquei lá, eu não pude ver ele, porque a família dele tinha um certo preconceito, né? Da minha ex-mulher, mãe dele, tinha um preconceito, então eles não deixavam a minha família levar o meu filho para me poder ver, ficar próximo e tal. E a minha mãe sofreu bastante com isso também, porque enquanto eu estava aqui em São Paulo, nesse período eu passei em várias penitenciárias, vários presídios, né? E quando eu estava aqui em São Paulo, era mais fácil para ela me ver, de 15 em 15 dias ela estava lá, que era quando podia. Depois, quando eu fui para longe, ficou muito ruim e apertado para ela, né, que estava aqui fora. Porque aí era 9 horas de viagem, ela ia lá sempre quando podia também. E tem gasto, né, que ficou tudo só com ela, né? Porque nesses momentos difíceis é só a nossa família que tá aí com a gente. O momento mais difícil na prisão para mim foi quando eu entrei pela primeira vez naquele lugar. Ali parecia que eu estava vivendo um pesadelo na minha vida. Um lugar que eu nunca nem imaginei entrar. Esse para mim foi o pior momento. Um recado que eu queria dar é que, para mim, a justiça do Brasil tinha que ser mais profundo, ter mais prova, comprovar mais, porque é muito fácil você pegar uma pessoa que tirar uma prova como eu posso dizer, uma vítima que te reconhece, mostra uma foto sua, fala que é você, te coloca, e a juíza vai, te condena, te coloca dentro de uma prisão, mesmo os próprios policiais falando que não é você, a juíza vai e condena sem mais nem menos e te coloca lá. E então acho que eles tinham que ter mais, sabe, mais provas, eles tinham que se aprofundar mais no que eles fazem, porque fora eu, né, tinha diversos deles lá, assim também, mesma coisa do que eu, tinha muita gente inocente, claro que tem bastante também que não é, mas eu convivi e eles mesmos me falaram o caso deles também, e até os familiares foram lá e falavam pra mim também, ó, inocente, meu filho também sempre trabalhou e tal, e só pra gente conversar a gente percebe, né, também que é pessoa do bem, que lá tem sim pessoa do bem, assim como eu, entendeu? E eu peço até pra Deus que eles possam se aprofundar cada vez mais, ir adiante, porque é muito triste, tomara que nunca mais, né, tomara não, que nenhuma família passe por isso que a minha passou. Eu não desejo para ninguém, para nenhuma família. Eu quero agradecer muito ao Innocence Project Brasil, que eu tenho certeza que se não fosse eles, eu ainda estaria naquele lugar horrível. Primeiramente a Deus, e que eles possam continuar com o projeto, né, para tirar essas pessoas que estão lá inocentes. Como eu já disse, não só eu, existem sim pessoas inocentes lá naquele lugar. Eu quero agradecer a oportunidade de todos dos seminários ter me escutado, ter deixado eu falar, né? E a oportunidade de expor minha história nesse seminário. Muito obrigado.
Meu nome é Ione Matos dos Santos, sou mãe do Lucas Santos de Medeiros, jovem condenado inocente há 2 anos e 2 meses. A prisão do Lucas virou a minha vida de ponta cabeça, não só a minha vida, como a vida da minha família também, né? Um dia o Lucas me levou para trabalhar, fui ao ponto do ônibus e me deixou. E no meio da estrada, do caminho, me ligaram falando que a polícia tinha invadido minha casa e que tinha levado meu filho preso. Me dirigi para a delegacia e lá eu fui informada que meu filho estava sendo acusado de um assalto de farmácia, que a gente nem sabia onde era o local. Então, daí por diante, a minha vida virou um transtorno e eu fui em busca de absolver meu filho, de provar a inocência, mas é muito difícil, no país que a gente vive, a gente conseguir pagar... Desculpa. É muito difícil quando você entra dentro de uma delegacia, você tentar provar que seu filho é inocente, porque você não tem voz altiva nenhuma. E o nosso país, a gente sabe, quando a gente não tem dinheiro, piora, acho que em 300%. Eu não tinha condições financeiras de pagar um advogado ou um investigador para ir atrás de filmagem e mostrar que realmente o Lucas não estava lá no local. Eu tinha o ponto do serviço dele, que a juíza não levou em consideração em momento algum, só visava a vítima, que acusava pelo fato do Lucas ser parecido com um rapaz que de fato fez o assalto. E eu tive que ouvir tudo aquilo por um período que tinha sido ele, sofri diversas acusações de estar escondendo o que o Lucas fez, porque tem muitas pessoas que não acreditavam na inocência dele, né? Tanto no trabalho como na rua, até mesmo familiar, a gente sofreu, né? Todo esse período. Após a condenação do Lucas, comecei uma nova jornada porque aí eu comecei a ir de presídio para presídio. Enquanto ele estava aqui em São Paulo, eu conseguia visitar ele a cada 15 dias e conseguia estar com meu filho mais tempo. Após o período da condenação, ele foi para Oswaldo Cruz, uma penitenciária que fica a 9 horas de distância daqui, e eu trabalhava. Então, graças a Deus, a minha chefe me liberava e eu saía dali com a minha mala, já ia direto para Barra Funda, e de lá eu pegava o ônibus e viajava 9 horas, cansada, porque tinha entrado às 6 horas da manhã no trabalho, mas precisava ver meu filho. E aí, após essa viagem de 9 horas, a gente chega num lugar que não conhece as pessoas, não conhece ninguém, e aí a gente vai para uma pousada onde a gente não conhece ninguém. E depois a gente vai para o presídio às 6 horas da manhã, o ônibus passa, leva a gente, aí começa a humilhação dentro do presídio. Se a comida não tiver na quantidade correta, se não for o alimento correto que eles deixam entrar, vai tudo para o lixo. Ninguém se importa se você viajou 9 horas, se seu filho não cometeu um crime, se você teve dinheiro, se você passou fome para levar aquela comida lá para dentro. Ninguém quer saber de nada, nada. O que importa é que você está ali cumprindo como um condenado, como um bandido. É muito triste a gente ver várias senhorinhas indo e voltando, porque não tem nem noção de como que é uma vida. E ninguém tem pena de ninguém ali dentro. Ninguém. E aí a gente volta para São Paulo, e quando chega em casa, o filho dele pergunta para mim: vovó, como é que está meu pai? Como é que está ele no trabalho? E aí a gente fala para ele está bem. O que ele está fazendo? Ele faz cadeira, Braia. O trabalho dele é de fazer cadeira, porque lá no presídio o Lucas estava trabalhando e ele trabalhava de fazer cadeira. E diversas vezes eu tive que mentir para o meu neto, falando que o pai dele estava trabalhando, quando na verdade ele estava passando pelo inferno, porque aquele lugar é um inferno. É isso que é chamado presídio. Eu acho que quando uma juíza condena uma pessoa, ela tinha que entender que ali ela está condenando uma família. Ainda mais quando a pessoa é inocente. Ela não tem noção da destruição que ela faz nas famílias quando ela condena uma pessoa inocente. Eu gostaria de agradecer a oportunidade por ter falado nesse seminário, por ter aberto o meu coração, por ter representado tantas mães que queriam ser ouvidas e não conseguem ser ouvidas. Por ter representado tantas mães, tantas vós, tantas tias, tantos irmãos. Quero pedir à Justiça que mais uma vez, que antes de incriminar o inocente, pesquisem mais, vá mais a fundo. Não é a primeira imagem que aparece lá que você já tem que condenar uma pessoa e destruir a vida das famílias. Porque, como eu falei, para condenar é fácil, mas para absolver é muito difícil.
After those two testimonials, nothing better than to hear the actors of the justice system, each one with their vision faced with the reality that we have in front of us with these videos. But before we hand over to the speakers, I have to, first of all, as I talked about the Public Prosecutor's Office in São Paulo, which in a specific case did amazing work in the defense of the judicial order and the constitution of justice as a reality, as a democratic reality, we hope. I also have to, Dr. Dalberto, also talk about the judicial power and talk about Dr. Luis Lamfredi, who is co-presiding this panel with me, and who has been working with the justice system, with penal jurisdiction in particular, and has been worried in the construction of what we call the rule of law and the constitutional state of the prison system in Brazil. So our homage for both bodies, not just for the public prosecutors, but also to the judicial, and in São Paulo specifically, represented here by Dr. Luis Lamfredi, whom I hand over now to read the bios of our speakers this afternoon. But also, and before I do that, I'd like to greet and congratulate our leader at the Citizenship Court, Justice Sketchy, the coordinator of this event, who has greatly contributed for Brazilian jurisprudence, specifically in the penal sphere, with great sensitivity, with great wit, and with a lot of technical knowledge, since you represent what is best in the Brazilian justice system. So it is with great pride that I make this reference to our dear colleague, Justice Sketch.
Good afternoon, ladies and gentlemen. Dear Justice Reinaldo da Fonseca, I feel privileged to be here by your side. And whenever this happens, not only with you, but also with Justice Schiachi, I say that this privilege comes from the inspiration of both of you. And you bring this inspiration to all of the justices' work, to this jurisdiction, and also you bring all of the attributes which Justice Schiachi and you wear so proudly. I should say that we all feel very safe with this jurisdiction that relies on justices, judges with the size that you and Justice Schiachi have. All of the justices from the High Court of Brazil have. And these attributes are not only reasonability, sensitivity, wiseness, but also courage. Since the exercise of jurisdiction in this role that goes against the majority is not to please everyone, but to make justice. And in that sense, above all, from the challenges of a topic like this one, to face this due to its causes as law in the perspective of life. And here we have illustrations of reality, illustrations of how reality happens within the prisons and the field, so to speak, and things that happen in the world through processes. So we have an addition dose of sensitivity from the judge to produce the rights and to make them present in their rulings. So here I would like to pay homage to Your Excellency. Your work, your role is a reason for all of us to be inspired. As you so well said, we have a full table. We have great professional judges here, and we have the privilege of watching the debate that we'll have soon. Our first guest, Justice Reinaldo, is Dr. Anderson Giampaolo. He is the Chief of Police for the state of São Paulo since 2002, and currently he's responsible for the training courses department of the São Paulo Civil Police Academy. He is a master in evidentiary law and also a professor of criminology in the Civil Police Academy of São Paulo. He has a number of other titles, but I think that the ones I've mentioned are very significant to show the qualities of our guest. Dr. Anderson, you have 10 minutes for your presentation, and we thank you for being here. Good afternoon, ladies and gentlemen. Firstly, I wanted to very quickly thank Justice Reinaldo Soares da Fonseca, a minister from the National High Court of Brazil. It is an honor to be by your side. Minister Justice José Sketch Cruz. And represented by him, I thank all of the other justices of the House. And it is a pleasure for us having you here. Dr. Luiz Reinaldo Santana Lanfred, he is the appellate judge in São Paulo, currently in the National Council of Justice. Dr. Adalberto José Queiroz Teles de Camargo Aranha Filho, a pleasure to be here. Dr. Pedro Carriello, public defender here, representing all of the public defender's office. Dr. Daniela Favaro, I have shared some panels with her as well. Dr. Mário Sarrucci, the National Secretary of Public Security at the Ministry of Justice and Public Security. It is a pleasure. I actually should send my greetings to all of the other doctors here that mentioned the award of value. It is a great satisfaction to be by the side of my friend, Dr. Maria Dias, our partner from the Academy of São Paulo. And also special thanks to whom today I can call my friend, which is Professor Janaína Matida, who is the person who invited me to come here and talk about what São Paulo is doing. And from the person of Janaína Matida, who is assessing Justice Sketch Cruz, I should begin my speech. Let's talk a little bit about what São Paulo does. Today's morning and yesterday we had a number of theoretical issues raised. Law, evidentiary, and criminologic issues were raised, but also from other fields of science. I really like this. And by the Professor Janaína Matida, a person I really admire, I should begin my speech from the standpoint of what I have to present and what the Civil Police of São Paulo and the Police Academy of São Paulo has been doing. We have a body of 28,000 policemen in our police. And if we consider the civil policemen that are working at the edge of the activity, we're talking about 20,000 policemen on the streets. And we're talking effectively of a preliminary investigation. We're talking about an extrajudiciary stage, a stage of the process that we understand should guarantee rights, not only in the judiciary stage, but also in the investigation itself. We understand that the preliminary investigation is a stage of the process where the defense should be present, above all on the topic that we are dealing with today, which is the identification of people. Our investigations should be guided by epistemology. And that is why we cannot only depend on legal matters or what Lahire calls gesto iuris. 226 of the Civil Procedure Code that has been interpreted since 2020 of a consolidated case law. Today we have the resolution 484 from December 2022, and São Paulo also has the GP 26 ever since October of last year, that in the Articles 139 regulates the identification of persons. So from the normative standpoint, we have a lot of foundations. And as Professor William Saconello highlighted, for us to talk about investigation from an epistemologic standpoint, we need to consider matters of the world, matters of the facts, because a law cannot encompass everything. That is why we need to work with psychology, with cognitive aspects, and Professor Jennifer Lackey gave us an excellent speech. Psychology talks about how important it is for us to listen to people, to look at what they are actually saying, their message, and from then on to build an investigation in what epistemologically interests me with an evidentiary body. This is the evidentiary weight, and we can talk about the completeness of evidence. We cannot set aside people's identification since the resolution 484 in the Article 11 will say that memory can fail, but the judge should be careful in valuing and assessing the identification of people. And in that sense, São Paulo opened its doors for many partners entities. IDDD is one of our biggest partners currently, and this is a sign that the identification is open for the defense. CODJUS, which is led by Professor William Saconello, is another partner that has been helping us greatly. And here, as a representative of the Judiciary Police of the state of São Paulo, I can tell you, I am speaking on behalf of several judiciary polices throughout Brazil. Since Professor William Saconello is very solid and robust of several policemen. There are teachers in the police academies where we take people identification seriously. And as we saw this morning, we also consider the matter of the investigative interview. And without the partner entities that I mentioned, this wouldn't be possible. And in the preliminary investigation, we need to consider a number of aspects. And like Professor Whelan, I am an optimist, since I see that we are making progress. I believe that we are not where we should be, but we are making progress. And how have São Paulo been making progress? Considering the number of human resources that the city has, São Paulo has been investing with the partnerships that I've mentioned in a continued capacity building for their policemen. For the policemen that work on the final activity, we have something ever since the creation of the H659-866 in 2020, the initiative of IDDD, the ordinance of IDDP from this case law that has been consolidated of the interpretation of Article 866, and we are investing on this continued education. We have nearly 2,000 policemen that have done a number of trainings within the academia, and above all, trainings that involve the partnerships that I mentioned in the beginning, particularly with what has to do with identification. And our academy has also invested in the initial training of their policemen. Not coincidentally, we are now concluding the biggest education process in our civil academy. We began with 4,000 policemen, and we are ending with nearly 3,400 policemen. We have rebuilt our historical of teaching, and we work with an access of memory. We are working with the new policemen, not only in identification, but also the techniques for interview that will perhaps lead to identification. And then the Academy of São Paulo reached the last stages of the Innovaria Award. We study on the perspective of matters that are of the law, there are facts, and that incorporate all of the fields of knowledge that can bring something to the law. Because sometimes we are arrogant in a sense. But next year we'll have another 3,500 policemen, and then if we can reach all of the 20,000 that are on the field, this would be great. And I can talk about other police academies that are doing the same. With this endless work that we have alongside Coach Jus and Professor and Teacher Aline, we have now, or we will have by the end of next year, 9,000 policemen out of 20,000 that have been trained on interview techniques. We'll have policemen that know what is identification, what is the lineup, they know the prohibition of having you show up, they will know a prohibition of showing a photo album, and also the necessity for us to have a strong body of evidence. And as our Justice Luis Roberto Barroso said about the doors of the system of justice, since the police investigation is indispensable, the door of the justice many times is public prosecutor's office. And we all work in this field, but we know that the main entry door for the justice system is the judiciary police. And once more, I'm being optimistic here. We still have a long way to go, but this police has been doing its part. And not only the judiciary police of the state of São Paulo, but all of those polices. Evidently, we have made progress, as I try to show here, at least on the sense of being an optimistic, and telling you, all of you here, defenders, prosecutors, lawyers, that despite the effort that we are making in São Paulo, we still have a long way to go. And I wanted to end my speech bringing up one of the matters that bother me and that bother Professor William. We know today how we can make a good identification. Differently from the techniques of interview, since we do not have that in our code, we do not have a normative act, establishing the techniques for interview, but São Paulo is moving towards that. And today we know that a good lineup needs to have not only the suspect, but more, at least other 4 people. We know that the suspect and the fillers need to be according to the description of the victim. We know that for a fair lineup, there cannot be a lot of differences between the suspect and the other 4 that are knownly innocent. We know that we can no longer do the show up. We know that we can no longer present the suspect photo album. And as a practice, this in the state of São Paulo is prohibited. But I wanted to leave you with a reflection today. In the face of those progresses, and in face of what São Paulo is facing now, and to which we do not have answers, not even the psychology has answers, but we need to know where to find and how to find our feelers. There are a number of initiatives. This has not been normatized. And over there on the top, we can see a lineup done from an artificial intelligence tool. And where I am the suspect myself, and below I use, and Dr. Dora Cavalcante, I use the case of Igor Barcelos Ortega, and I use this case in classroom. All the 3,500 policemen that are finishing their education now know the case of Igor Barcelos. At the same time that I show them, look here, this is where he's made a mistake. But I also try to show them what would maybe be correct. And below over there in my slide, you can see a lineup done not by an AI tool that has its problems due to what psychology and its studies calls the backfire effect, which is the matter of the similarity between the suspect and the fillers being so high that this would also get in the way of the identification. And underneath, I do this from Igor, which would be the suspect then, and I try to make a lineup with fillers from a database that the civil police of the state of São Paulo today has with more than 3 billion pictures. And how do we do that? We do that with the aid of artificial intelligence. And we are aware of the problems of the tool. But the big question and what São Paulo is asking itself, now we discussed that the police academies, the CODJU, Teacher Lilian, we all discussed that. What would be best? This lineup where I choose people that exist, this might be a problem with the right to the image use, and São Paulo has found a solution, has been discussing that with IDD. But in this lineup that I present to you below, I have a lineup by similarity and not by similitude. And they have the positives and the negative points as well. But this is more for a reflection for you, ladies and gentlemen. All of you are a part of the legal profession and the legal system. And today we are now debating and discussing exactly so that we can reach a criminal justice system where the legal decisions and the rulings, as we know, depend not only on the judiciary branch, but on the cogs of how the entire justice system works and all the subsystems that are working jointly with the judiciary branch. So it is in that sense that I make my contribution in telling you that humbly, in my opinion, we have made a lot of progress. We still have a lot of work to do. This is a matter being discussed today, and I think that this could be a starting point. This event could be a starting point for future debates. Thank you very much once more. It was a pleasure being here. I want to thank Dr. Anderson. He is raising another aspect of the criminal case law that is dependent on the judiciary police apparatus, and the police academy from São Paulo has been making a lot of contributions in that sense to all of Brazil and to the other police academies in Brazil by their education, their humane education, and their technical training. And I admire you, Dr. Anderson, and I've been admiring you for more than 15 years now. when my second son began studying the Polytechnical Police Academy and in Butantan, the Butantan Institute, and the other men were close to him trying to go up the stairs of the Butantan Institute and to go to the Federal University of São Paulo.
Since that time, as I was appellate judge, I was looking at the Police Academy in São Paulo. For us, it is wonderful to see and to know that the Academy is growing within a public policy of training and professional development, looking effectively at criminal jurisdiction in the best way possible. Congratulations for your exposition. Thank you very much, Justice. We now continue with the next presentation. I have the great pleasure to call on my friend Mario Sarubo, National Secretary of Public Safety. After a police chief, we're now here from public safety of the country. Mario is from the Public Prosecutor's Office of São Paulo, where he worked in most relevant job titles. He's here. He was the head of that organization for 2 consecutive terms. He is a professor, our professor, always professor of the Armando Alvarez Penteado Foundation, and truly today has great challenges ahead of him at the Senasp, all of them very well thought of in the sense of resignifying the role of the police, of the law enforcement agencies, like justice, for them to bring something additional for a citizenship police, a police that thinks about the process. And I remember our dear Professor Sergio Pitombo at the law faculty of the University of São Paulo, who said that police investigation is our first instrument of defense, where it takes place. And that instrument, that tool that is so important, and with that concern that it can bring together objective actions of judiciary, police, and that have that concern for training professionals that lead an institution to really bring it forward in the best way possible. And Mario today, after going through, after having his professional experience where he really understands this from within as an institution that receives all of this work. But today, from a coordinating perspective and bringing here new ways and new sort of a fresh air for this qualified police that we really want in Brazil. Good afternoon, everyone. I greet Minister Reinaldo Soares. A great pleasure to be next to you. I also greet Rogério Scretti, Lanfredi, my Dr. Alberto José Queiroz, Telesio Camargo, and all the authority and all of these friends that are here. And I request your leniency to greet them all, friends, dear colleagues that are with us today in this wonderful and important event. And I would start by bringing a personal experience from Minister Justice Juarez da Fonseca in 2003 or 2004. He was a victim of a robbery in the subway in São Paulo, and he was imprisoned. I did the identification, and a few months after that, one could say, I was presented at a forum, at the audience, at the trial for me to recognize him and for the process to move forward. I found him in the hallway, and he was completely different. He had been all hairy when he robbed me, and here he had no beard. His hair was shaven. There were no features whatsoever. He really did not look like the person. But I said, "You stole from me that day, and I had a little bag that was coming from class, and you threw those discs that I had in bag, and there were a lot of classes I had stored in that bag. Do you remember where you threw them? I would like to recover them. I have a whole history in there." I think it was at a square, which gave me, he said to me, "I threw them in a square, and I had the absolute certainty that it was him." But within a democratic justice system where we all work daily, this was unacceptable. If I had to be submitted to an identification without that previous chat or exchange, I would not be able to identify him because he was actually presented in a totally different way. And here I bring, if I may, and as a prosecutor, something that I believe is essential in this issue of identification, which is the principle that is essentially in the penal process and in a justice system of a rule of law, which has to do with the duration of the process. It's impossible to do justice in a process that takes months or years, and where a victim or a witness has to identify someone years after the fact. And this becomes even harder when we think about this, when we stop to study a little bit and think about neuroscience and so forth. Professor Elizabeth, the studies that we have access to and that you've all debated already in the false memories, that are aspects that I believe are very important for us to build a system that provides us with the safety, so we're not forced to watch the videos that we've been watching that really affect us all, are very upsetting. We're all in one way or another part of this justice system. Identification is, in fact, a great challenge today in our justice system. And this whole experience that we had at the public prosecutor's office and victims of robbery, myself, made throughout this journey, whether as a prosecutor or a secretary of public safety, I've always been worried with this. I was a director of the school of the prosecutor's office school. I was invited to teach at the Superior School of the Public Prosecutor's Office. We had a great event to deal with identification, looking to train our colleagues at the prosecutor's office and the judicial community as a whole, attorneys, justices, so that this topic could really draw attention to an important issue, so we don't commit injustices in the Brazilian justice system. So therefore, we find the pathway to achieve this to be training of all the professions, of all the actors that are part of the justice system, whether they're lawyers, attorneys, or delegates, whether they're police chiefs. And here we bring the example of the Police Academy of São Paulo. We're working on all those lines as well at the Ministry of Justice and Public Safety. We have our own office training, which is a space, a specific directory for professional development of the SUSC system. And a congress that we held in the month of July was precisely to deal with this issue of recognition and interviews, techniques for identification, so that at the police we can have new attention to misidentification and false memory of every aspect that we have placed and pointed out throughout history. And we have seen judicial errors that are very serious because of that personal identification. There is another aspect that I believe is important to talk about, and which touches on our work at the Safety Office, which has to do with the judicial. Brazil today, public safety in Brazil today is essentially, or 70–80% of the system of the country is made up by the military police through the apprehensions in the act, but especially through the budgetary difficulties and the investments that are not there in the judiciary police as a whole. So the delegates work with a deficit of professionals. They work with a deficit of rapporteurs, of delegates, of law enforcement staff. So all of this has really affected negatively their work and has forced professionals that are highly experienced to look to end their investigations in whichever way is possible. So when that happens, when a procedure as a whole that begins at the police can actually end up with a grave error, and then we're seeing once again our justice system in Brazil with the production of grave injustices. So we are doing work at the National Secretariat of Public Safety for public safety, working with organizations of the civil society so that we can find a parameter or some kind of metric that can bring guidelines to public policies at a national level as to numbers of professionals that we should have in our judiciary police or in our military police even. But I am really worried by the judiciary police because there are studies that show that less than 10 or even 5% of the crimes are cleared up when they're registered in the police for the lack of professionals so that we can move forward in this. And so in wanting to do identification, we could have judiciary errors, as it happened in the state of São Paulo, at a football stadium from our team, when there was a death and there was a young man presented as and then the police itself and the prosecutor's office ended up clarifying the mistake that they did, because that young man was incarcerated despite it being a short time. The degree of depreciation of that individual, what he went through at that time, those days, those hours that he was imprisoned, he will have to take this with him for forever. So we have to really be quite careful with this. We have 2 minutes, okay. Briefly, I would like to bring, there was a discussion with another topic that worries us greatly at the Ministry of Justice, which is the identification through facial biometry. This is an issue that concerns us greatly. When we use AI, the technology needs to be an ally of the human being, an ally of the professional. However, we need to really be careful with this type of facial recognition. I see today municipalities and states and everyone wanting to invest in facial recognition, but we know that AI has to serve man and not the other way around. AI is always important. We have to highlight that they always work based on databases. And when we look at the databases of AI, it will look well. It will look in our prison system. And when we look at our prison system, of course, what will we find? We have that most people are Black, and that's where the problems begin. On facial biometry, we have a project which is the Safe State, which will work with identification through facial biometry. But we are already seeing grave judicial errors. For example, a man that was with his family in a not in the Palmeiras Stadium, but a different stadium, and he was identified through AI. Mistakenly, he was taken away from where he was in the middle of the game. He was exposed in a most horrendous way to later on, after a few days, be identified as innocent. And the error was facial biometry. So we need to train, we need to invest in professionals that can effectively provide us safety from the beginning, from the face of judiciary police all the way to the justice system in the judiciary branch. I think my time is up. If I have gone over, I apologize. Thank you for the opportunity. This is one, Dr. Mario, to hear you after a wonderful, enriching experience at the Public Prosecutor's Office and now at the head of the Public Safety Secretariat, dealing with issues that are already here, issues of the future that are already with us. We see distortions of AI, of facial recognition, and this worries us greatly. I am very happy to see that we are great hands, and we have the executive power is thinking, the executive branch is thinking about these issues that I believe are extremely important, they're current, and they're also important for the future. Thank you, Justice. We now move on to other presentations. We really have a wonderful afternoon. I have to mention that our next presentation by Dr. Daniela Favoro, Prosecutor of the São Paulo Public Prosecutor's Office, Coordinator of the Criminal Operations Support Center. She was Coordinator of the CalCrim in São Paulo. She is a Master's in Law by the Catholic University of São Paulo. She is a professional of extreme competence and has great sensitivity, which leaves us all when we work in process, in trials, when she's in person representing the Public Prosecutor's Office, very safe, very certain of the position. I'm sure we will hear a brilliant presentation from her now. Dr. Daniela. Good afternoon, everyone. I would like to thank you, especially the words of Minister of Justice Reinaldo and Justice Lamfredi, and to say that this role as prosecutor of Carlos Edmilson, I can say that what was done by myself was nothing more than use the tools that were at my disposal, legal tools, to try to minimize the system that we operate, to minimize the errors that's operated by humans and has fallibility as a part of it, unfortunately. I'd like to thank especially also present at the panel, Dr. Mario Sarruba, my former boss, former commander, and I tell everyone that he taught me how to have management with dialogue. And what we see here today is precisely that need for dialogue with the civil society. The Public Prosecutor's Office cannot call itself a representative of society if it's not open to the society itself. And I'd like to also thank especially Dr. Lanfredi, that this is on a personal note. He did for my 11-year-old, he managed for my 11-year-old to become extremely happy as he went into the fields with São Paulo players when he turned 11. Despite the fact that I rooted for the other team, on that day, I really rooted for São Paulo's team, and they won.
Actually, the password in the computer is the day of his birthday when he went into the field. I wanted to bring two matters that at first glance might seem easy, but that are not only necessary for the debate that we're having ever since yesterday, but also might at first seem easy, but they have a great deepness. The first issue is, what is the finality of the evidence in the penal process? Those answers are given when we are taking law courses, particularly when we are taking the subject, the penal process. The second question is, what is the role of the Public Prosecutor's Office? For the first question, we can say many times in a process on a daily basis, on our daily work, when we are using the penal code, we're trying to convince the judge that the facts are true. The facts that we or other prosecutors or defense attorneys are alleging. We use the evidence of the penal process in order to convict or acquit. But actually, when we look deeply into the aim of the evidence, we could say that this is not the goal that it should have. The evidence is trying to find the actual truth, and this cannot be ignored by us that are a part of the legal profession. And if we understand that this is indeed the goal of evidence, we need to value what we call diligence, a concept that was brought by the Inter-American Human Rights System that says that the investigation should be complete, exhaustive, impartial, and above all, expedite, as our Dr. Mario Sarruba that spoke before me said. The Inter-American Court indicated consistently that the duty of investigating has to search for the result and not the means. This is not just something formal or unfruitful. With due diligence, the investigation should begin without delay, seriously, in an impartial manner, and in an effective manner, and it should be done through all available manners and searching for the truth. And also, all of the people that are working on the justice system, prosecutors, judges, attorneys, they can contribute to the production of evidence. And the Article 5.6 of CPP says that the judge can make the anticipated production of evidence. And this has been explored here. Our memory is limited, so the evidence needs to be produced as soon as possible. Now going to the second question. What is the role of the Public Prosecutor's Office?
Nós, como atores do sistema de justiça,
as a part of the justice system, and since we are very close to the police, it is essential that the public prosecutor's office is trying to find the qualification of the evidence. And as a great colleague once said, and he was responsible for helping me in the case of Carlos Edmilson, Dr. Eduardo Querubim, is the qualification of the administration of public security in its specific activity. The public prosecutor's office should make a prosecution that is responsible in trying to find actual truth. The public prosecutor's office should foster public policies and state policies that will bridge eventual necessities. And the public prosecutor's office cannot remain still on the face of problems or deficiencies that could be corrected ever since their beginnings. It is up to the public prosecutor's office to make diligences to start police investigations in order to assess the facts broadly and with minute attention. And through the speech of Dr. Giampoli, we see that the policemen are being trained so that the identifications can be done in a way that has been preconized by the Civil Code of Procedure. And even beyond this, only an identification by itself would be a failure. But the qualification of the evidence in all of its senses, ever since the beginning of the investigation, would be great. We need to try to gather information ever since the communication of the occurrence of the crime, audios, images from operational cams, from such as in the case of uniformed police when they are servicing calls, and particularly in cases, for example, of drug trafficking. What has brought up certain suspicion, this should be described within the police report. The instruments of the crime, the custody chain should be preserved. We need to see whether the public prosecutor autonomously should adopt urgent diligences that are at times necessary. And the idea here is to overcome eventual deficiencies that might compromise the efficacy of the investigations of the public prosecutor's office. That is its duty. I brought a few cases that I'll mention briefly. And one of them was recently tried by Justice Ribeiro Dantas. And there is this idea that the public prosecutor's office cannot stay still. In the case, there was an acquittal, but also there was a slap on the wrist for the public prosecutor because some images should have been sent, and they weren't. And once they were requested, it was too late. The images had been lost. The public prosecutor's office, as has been said here, I think that for more than one speaker, has the constitutional duty of exercising the external oversight of the police activity. And what is this external control? Many people are mistaken when talking about the external control. We are not a disciplinary board of the civil police, and that is not the intention. The external control is done through articulation in collaboration with the police institutions, since they are the responsible parties for subsidizing the public prosecutor's office with the necessary evidence. And the exercising of these disciplinary actions has a need for the public prosecutor's office to see whether the rules are being followed, but also to dialogue, build jointly protocols of action with objective parameters, identifying errors and proposing changes, bringing models that will work. In 2022, if I'm not mistaken, we had an event, me and Dr. João Paoli, about identification and about the matter of the suspicious sending of evidence. And then we had the idea that if there was a resolution talking about identification, then we should get together to deal about the matter of parameterization of would be the suspicions with reason or without reason. And once the working group was assembled to see what would be a suspicion with foundation or without foundation, I was impressed and very joyous with the active presence of the civil police and of the uniformed police. Because when we're talking about qualification of evidence, and Dr. When he said that when we have two members of the public prosecutor's office, well, actually a member and a former member, we have the same thoughts. The amount of police investigations that are reasoned and opened due to flagrante delictos is huge. And we see that this was done by uniformed policemen. But this demands our action so that we will work alongside the uniformed police. And this type of work came not only by us creating these parameters for action, but also in us raising the matters to the uniformed police that are being discussed in the superior courts, but also bringing a stop poll and also a consideration of how to use operational cams. What would be the consequence of those operational or body cams, or the consequences of not using them? And the police, as one of the actors in producing evidence, since 95% of the robbery cases depend on the uniformed police caught them on the act, this should be considered by the public prosecutor's office. And lastly, the scientific police. Nowadays, São Paulo has one of the scientific polices that is the most qualified in Brazil. And this should be employed by the public prosecutor's office, by the uniformed police, in favor of the qualified production of evidence. Of course, for that, we need a lot of funding. Since it is not enough for us to just talk about qualification of evidence in improving the collection of evidence if we do not have not only trainings, but we do not have human resources or available means so that this evidence production is possible. We have worked intensely over the last few months trying to have financial resources so that we can deliver that to the scientific police, not only in buying fridges, for example, to store DNA, but also in buying drones so that we can reproduce the facts in 3D. Another action of the public prosecutor's office is to verify alongside the scientific police whether the photos are being taken of people that in the case of microscopic reports are being taken. My time is short, so I'm going to rush here. All of this part of the investigation should have a participation of the public prosecutor's office. We can't just sit down in our cabinets and our offices waiting for the evidence to be produced. The evidence is produced by the police means, but it is we that afterwards will take the produced evidence to the judiciary branch. And lastly, an action in the penal process. As I've said, we are open to failure. We are subject to failure at times, but this frailty should not be taken to the penal process. Very recently, I had a situation in which there were body cams. The images had not been sent for a reason or another. Perhaps since the prosecutor was not aware, we have a protocol of action for the uniformed police. They have on the police report that the policemen were using body cams, and this request was made at the final stage of the 402, and the judge did not accept the request because he said that this should have been done previously, and since the evidence was deficient, there was nothing else the judge could do. That is not our role. Our role is to try to find the actual truth for all of the participants of the legal profession. And if it is necessary to send the images, we need to do that, even if at the last stage. I don't know whether the culprit was, whether this person was considered the actual culprit or not, but we work on the defense of the society. Anyone who is a victim of a crime or society as a whole, they need to know who is the culprit. They don't want a conviction or an acquittal necessarily. They want to know who is the culprit. And that is the role of the public prosecutor's office. It is not to condemn, it's to try to find the truth of what actually happened.
Muito obrigado, doutor Daniel.
Thank you so much, Dr. Daniela. You have just confirmed everything that I just said about your role as a member of the Public Prosecutor's Office in acting on concrete cases, including on the scope of the third section of the Federal Supreme Court. And I want to take advantage of what you said to make a registration about all of the construction of the qualified production of evidence and of the transformation of the mandatory character of the demand on the Civil Procedure Code. And this has been resignified from the precedent of our colleague, Sketch Cruz, that at first caused some unquietness, but it started working since the polices were being equipped from this call to action, from the fifth panel, the third panel of the Federal Supreme Court. And the qualification of evidence is what we expect as workers of the legal profession. And Dr. Daniela talks about the suspicion with foundation. And this comes from some presidents of the Federal Supreme Court, because we started having as a justification from the police the use of a helmet on a motorcycle, as if there wasn't a law that someone who is riding a bike should wear a helmet. I mean, this is completely absurd. And when you're riding a bike without a helmet would be the rule. This is unfeasible. And so it would be suspicious to wear a helmet. So we need to notice how important all of this is. This is no big deal. It's just transforming the case law from a mere recommendation to building a pathway of mandatory aspect without invading the field of the executive branch, without breaking into the concept of the separation of branches, but actually calling on to an effective judiciary control of the fundamental guarantees that begin from the principle of legality within the penal process. I couldn't contain myself when I was listening to Professor Daniela, because this is exactly what we need to register and how we need to make the law be applied with the initiative of Justice Sketch Cruz, when he suggested the semantic exchange of the recommendation by the mandatory aspect. Thank you, Justice. Your considerations were highly relevant. This is noteworthy. And when we were within the WG, one of the thematic committees, if I'm not mistaken, the second one that was working with building new protocols for police investigation on the topic of identification, then we received important subsidies in understanding why the police was acting in a certain way. And it was very interesting indeed. We were going around the country with a survey asking the civil police, the judiciary police, some key, for them to answer some key questions about the challenges, the hurdles that have to do with the matter of identification. And we were surprised when we understood the policemen themselves felt that they were helpless in how to attain the evidence. More than anyone else, they were asking for perfecting in that sense. They couldn't get this information even from police academies themselves, not only from an operational or a conceptual standpoint, but from a material and concrete standpoint. And Mario talked about very vulgarly speaking, but the police in the country has been left in scrambles. And so by the police institution itself, with all of its significant representatives. But the role here, it is a transformative role indeed, that a jurisdiction with this incidence and this ability to transform, then we can bring the matter to a different level with a different degree of demands.
The quality of the investigation and that diminishment when we tolerate or we consent to the fact that it takes place, that leads us to an institutional inner force that doesn't help us. We will now move forward with our dear friend Pedro Carriello, public defender from the state of Rio de Janeiro, who also worked very hard, always with a lot of energy, that really catches on in terms of human rights defense and the institution. He is a captivating person. He's always there with his vitality and with his ability to bring us hard topics, but always with in a very appropriate manner, always with great confidence. Pedro, I would like, first of all, to thank the invitation, the possibility for this dialogue. I think that today we need to have an effect that transcends. When we were able to see today, when we were listening to the narratives that came before me, that only the owner of the pain knows how much it hurts, as the samba goes. But today, it really hurts every open wound, for every evidence. We really need to pay attention, evidently also with technical defense. So I'd like to start with a kind of penitence. The world is challenging, people transcend, and we need to break away with that idea. And I think the High Court of Brazil has given us very much grounds, not just in this seminary, but in other instances. And I think you'll all agree. It really brings us forward with the votes, with the sessions, with the debates, with the dialogue that comes before the construction and the building of a ruling, with a process that is democratic, and that it constitutes a diaspora that allowed for it to begin. And we need to see this, that it begins to become evident when we see the penal system in Brazil. The High Court the National High Court of Brazil still has had some rulings that don't stay within this idea. At some point, we need to really pay attention to this fact. We appeal to the Supreme Court. Sometimes we're successful and sometimes we hurt ourselves. And it sticks to the person that is in prison, and that's the photographic recognition. So it's not a wonderful rainbow, right? There is still a lot to do. We need to say this with elegance, with eloquence, but we need to say this. So this is what I begin by saying. It's important today to transcend these testimonies. And what's our role? Firstly, to talk about the construction of dialogue with the National Council of Justice, which is a monitoring body that provides us transcendence for the penal process in Brazil, the public policies. Today, we had a declaration a few years ago, the declaration of unconditional elements in the prison system. It's a wonderful rhetoric, right? Court decisions, court rulings that are so well informed in the real world. That's the National Council of Justice. And in the society and every institution. So I need to start with that, to talk about the importance of dialogue, of contributions. And there are many actors here, many individuals, academics. It's important. And I'll tell you, this racial penal process, today we have literature of Black academics, and that helps us a lot. I think we're on the other side. We want to avoid the errors committed. And we are so thirsty for this, to know the right word, to know how to say that which doesn't hurt, which doesn't offend. So it's important to have support. And the support are those colleagues that are invisible here. In your daily work, attorneys, at public defenders' offices, they are submerged in this drama. These are colleagues. We're talking about Black women that are defenders. I work with one such individuals, and it's important for us to dive in. Janaína gives us hermeneutics. We work with that. So these actors here are absolutely essential in this whole mess. I think you had the opportunity to review this. We have to be able to say you made a mistake. We are Republican. We are democratic. We can show the way. I don't need to move forward. I don't need to keep going, but that's the idea. I'll give you an example. The example that I'm going to provide, which is very common sometimes here at the National High Court of Brazil, is the photographic proof. It's so hurtful, such as the identification issue itself. What kind of evidence is that? What's the counter evidence? Sometimes the High Court legalizes that. The other evidence. No, but doctor, justices. This identification has already become classic. You have chosen already. You might say, no, that's not the case, and then it happens. And then it goes to the Supreme Court, and it's quite delicate. It's been really delicate. So this whole resistance becomes important, this transcendence, this fight for this path. Let me not dwell on criticism alone, on this wonderful panel full of very diverse people. I hug you all. I embrace you all. But we understand that there are some ways forward, some ways. Firstly, a kind of alert. I was reading the other day a book on politics from Felipe Nunes. There is a section that talks about Nietzsche. I didn't read the whole book. I grabbed the other book, not Nietzsche, and it's nice, right, isn't it? But there's a section on Nietzsche. I should have read it. But what's our great monster? It's public safety. I'm going to take advantage of this forum. What does Nietzsche say? He says, whoever combats a monstrosity needs to be careful so that he or she don't become a monster as well. If you look at the abyss looks at you back. And the monster of the abyss sort of feels, what is our worry? What's our concern, especially those that are on the defensive side? I also work in human rights. I combat also police violence in Rio de Janeiro. It's these practices that I will now tell you about. This is the fight that we are part of. For example, in Rio de Janeiro, there was a death of a police officer. That has become more common. There is vengeance. There's the idea of militarizing the enemy, occupying the territory. There is a great cooperation being organized. Civil police, military police, federal police, and soon there will be the municipal guard, and I'll talk about this because it's absurd. We need to understand that the political guard, the municipal guard is that
pelo bem, pelo posto de saúde, pela saúde o aparelho educacional.
For the educational apparatus, it's not possible for people to understand that it's irrespective of where you are, but it is possible, it is believable, it is reasonable to bring the municipal guard as an instrument for safety that is militarized, looking and apprehending. It's another militia element. There'll be more violence, the more police violence.
Essa sereia,
that mermaid that is that seems like a public safety element combats the monster and finds the abyss. The municipal guard is the idea of bringing forward.
O contrário, botar insegurança tem que ser aproximação. Não foi eu que disse, não. Isso foi um cara lá do Uruguai. E a gente lida com o quê? Só com o inimigo territorial. E o que aconteceu, senhores? Foi feita uma ordem coletiva no Rio de Janeiro, em 2017. A decisão da Guarda Municipal passou pela terceira sessão e de lava também do ministro Schietti. Vamos registrar isso. As boas decisões necessitam ser divulgadas, né? Então, mais uma aqui. Senhores, o que determinou um juiz de plantão? Olha, 2017, a posição de 88. Depois da morte do policial. Uma busca e apreensão coletiva. Já? Meu Deus do céu. Tempo esgotado? Jura? Posso falar mais 2 minutos? Dois. Ou seja, nós utilizamos de uma busca e apreensão coletiva para que se obtivesse, evidentemente, impedisse isso. Nós perdemos no Tribunal de Justiça local e tivemos êxito na 6ª turma, onde foi a cultura do HC coletivo e o absurdo, parecia uma África do Sul dos anos do apartheid, onde se permite que uma ordem judicial se vasculhasse todo jacarezinho, que anos depois teve a maior incidência, com 28 mortes e um policial ferido. Rapidamente, que eu tenho mais 2 minutos, infelizmente, desculpa. Uma outra matéria que eu acho de suma essencial, agora com uma prática, colegas defensores, Innocence Project, promotor de justiça, nós no Rio ingressamos com uma ação civil pública há alguns anos, impedindo
action a few years ago, stopping the civil police at the time to publicize people that were provisionally imprisoned. And this is a source of suspicion. And so we needed to stop this culture. And for 100 years now, Brazil is used to making expositions. Here we can see a picture from the state of Alagoas. We can see this as if it was an award, the award of making this security activity effective. And so we were successful in that civil action. And lastly, there was an appeal from the public prosecutor's office, but we were successful in the last instance, the Federal Supreme Court. And I wanted to talk about so many things. I wanted to talk about presumption of innocence in the sense of anticipatory guilt. But I must closing saying that this is a transcendental victory. Very briefly, Justice, this is so important. Paulo Alberto Silva Costa, he had 70 suits, 70 processes. Most of them came from the same police station. A picture that they got from social media. Paulo Roberto, with 70 lawsuits, had his preventive arrest decreed. He had convictions that were final, convictions that weren't final, that could be appealed. And they were working with IDDD. We shared with them this fight. Clarice did the beautiful work, and we assessed almost 70 of the processes, one by one, until the habeas corpus reached the Supreme Federal Court. And then we saw that the single dimension was being repeated in the same police station. And you saw that it was a show-up. This was such a victory. It is transcendental. Sometimes this is a good thing. And we were able to do that. This is perhaps one of the most noticeable sessions. Guilherme also made an oral statement, and Justice Reinaldo was there for nearly 2.5 hours. So there's this automation of nearly 70 processes, and the habeas corpus was for one of the reports specifically. And here we're talking about the transcendental nature of the labor process. And then we reached the consensus. I mean, a consensus, but in closing, we were able to have a stopple on that case, and we were able to release Paulo Alberto for him to answer even to the lawsuits that were final, so that he could answer to those lawsuits in freedom. And for where we had those processes, to make a deep dive to see whether the evidence was the same in order for us to overthrow. This is the public prosecutor's office. This is a transcendent phenomenon of fight and of a living. And just in closing, I apologize. I just wanted to remember, I said so many things. I wanted to bring further solutions, but that's it. I wanted to remember you about Candeia. I think that the samba music helps a lot of people. I do not have the voice of Daniela Mercury, and I would not do this. But the samba from Candeia has a beautiful music for the police officers that are tough, that are aggressive. Sometimes they can be on wheelchairs. Their life will change. And there is a song that is by Cartola that says exactly this, that people who live in the suburbs are trying to run away from this diaspora. They ask, let me go. I must walk. I'm going on this path. I'm running around and I'm searching. Let me go. I need to walk. I'm going around and I'm searching. I should smile so that I do not cry.
As you can see, what I said at the beginning is confirmed. Except that it's confirmed as a response to Mauro Capelletti. The first wave of obstacles to access to justice is actually made up of the Brazilian public defender's office.
Tem algum defensor público aí me
Is there a defender who can help me? I would like to thank Dr. Pedro, who expressed himself very well here, very much bringing a difficult contribution. And that is what the public defender's offices have done in this third section, especially with the support of actions on behalf of the civil society, such as the Innocence Project and other institutions have shown. And evidently, we are very happy to have the voice of the public defender's office in this seminary, in this panel that has actors and views on the qualification of evidence itself within the penal process. I'd like to say that I agree with much of what Pedro has mentioned that troubles him, and that the rule of law is not rhetorics of the High Court of Brazil, and we'll have the response. It's not just through rulings that are emblematic, such as facial recognition or custody, that is under discussion at the High Court, but also as to the inconstitutionality in this country. We have had a very strong dialogue at the Inter-American Court of Human Rights, and within the 5th and 6th courts, we have proclaimed the decision of the Inter-American Court in the counting of 2 Brazilian prisons in Recife and in Rio de Janeiro. And that decision deserves to be celebrated, deserves to be celebrated as a step forward for the control of conventionality in this country. Aside from that, we have the responses that have been given to the trials in other institutions in the penal process as to what it means to have a qualified evidence. If we find our evidence, it's because that evidence also exists. We have sometimes videos, sometimes we have photographies, sometimes we have testimonies, hearsay, and sometimes eyewitness testimony. And so the evidence needs to be collected, and you will find the feral power of Dr. Daniela in the construction in search of material truth, which she already mentioned. But I'd like to say that I really would like to highlight the incredible work of the Public Defender's Office, of the citizens that really came to fill the gap, which is to bring the voice of the most vulnerable all the way to the justice system. And you're absolutely right. I would like at this time to hand over to Lanfredi once again. I would like to greet Dr. Janaína and also our dear counselor Paulo Coutinho, who is here present and who has been doing wonderful work with the elderly, with people with disabilities within the National Council of Justice. And our Vice President, former Vice President, but always Vice President, Justice Fernandes, who is here as well. So, Lanfredi, I hand over to you. Thank you very much, Minister. We are moving towards the closing of this panel, and I have the great satisfaction of announcing the next speaker, Dalberto José Queiroz Teles de Camargo Aranha Filho, who is a doctor in political law from the Presbyterian University of Mackenzie. He is now the head of penal sciences at the Mackenzie University. He's the president of the criminal court in São Paulo, and he is now one of the leaderships of in São Paulo and also at a national level, and he deserves our great respect. He arrived at the president's not for late work. It's an honor. This tells you a lot about the complexity of the difficulties that this entails. And appellate judge Camargo Aranha brings consistency, brings coherence, but integrity, sobriety to the justice in São Paulo. He is the head of the court in which I preside, and I am very happy to be under his coordination in this section in the São Paulo court. So it is with great joy that I now invite you to present. Good afternoon, everyone. I would like to initially the table, greet Justice Fonseca. I admire you greatly for your lessons, my friend and my college mate. So many battles, Mario Sarrubo, National Secretary today, Dr. Anderson Giampaoli, Police Chief, Dr. Pedro, Public Defender, Dr. Daniela Favaro from the Public Prosecutor's Office in São Paulo. I would like to also greet Justice Rogério Schetti, whom I admire greatly, Minister Fernandes, my great friend, responsible for half the lies you heard today, and Luis Lanfredi. I would also like to extend my greetings to some other individuals. My dear friend, Mr. Hassarrubo, my colleague at the Justice Tribunal, Ana Paula Sommer, Dr. Flavia Hautami. It's important to highlight her work. I would like to make a consideration as to the importance of these 2 days, the importance of this panel. If I wanted to add something else, I would just be being redundant because Luis Barroso already talked, Edson Fachin, all the justices, Schetti, who was at the table yesterday, Dr. Lanfredi, Dr. Cavalcanti, Justice Evarista, everyone who has participated already in this seminary have brought the relevance of this meeting. I start by saying, I don't mean to use any academic terminology. I would like to say that I don't believe that there is any victim or witness that misidentified on purpose. The idea that someone deliberately harms someone else that they don't even know doesn't sort of cross my mind. And that's due to the facial recognition, which is evidence that depends on memory, so it's fallible, which justifies statistics, the estimation that 70% of wrongful convictions take place through wrongful recognition. When I am a part of a panel with such important and intelligent people, such as this one, I have 2 problems. The first one, I do not have a long speech since everything that was important has been mentioned yesterday and today. And second problem, I am
in a position I do not deserve. So I was going to talk about this memory failures. I do not intend to speak too much about this, but there is a book that talks about how the psychology of the testimony can help to prevent the misidentification of suspects. There are two important variables, which is one of them has intrinsic factors of the memory crime, such as the longest the time you take to make the identification in relation to the date of the crime, the harder it is to store the imagery. And what concerns me, and that was said yesterday, is the second variable. The second one has to do with the system. It has to do with the factors pertaining to the system that can be controlled by the justice system. This is very important since they can decisively contribute to a wrongful identification. And our justice system itself might lead to a wrongful identification. I'm going to give some examples, as was the interview. The guidance that the person who identified had, well, what is the guidance that this person receives if they are not seeing the perpetrator there? If that person is in shackles, for example, the probability of identification is higher. I'm going to mention an example from my own experience. I used to be a judge in the third court of São Paulo. We saw this daily, and I already fought against this practice that the person that has been in prison goes into the court, and he was already wearing the jail suit. And from then on, the jurors were already thinking that he was guilty. He had to prove that he was innocent, and no longer the ones that were accusing him that had to prove that they were guilty. And even more serious than this identification, but the identification of the participation of the justice system, is the photo identification. When you present only one photo, there is an inducement. But when you have a number of photos, there is a possibility of electing the wrong suspect. So regardless, the justice system, regrettably, in this sense, is collaborating to a wrongful identification. Contributions in trying to minimize the risk of false testimony. No judge has the intention of convicting an innocent person. But the matter is that the judge is making his judgment by someone else's perception. The judge has not seen the facts happen. This cannot happen. So their conviction comes from someone else's perception of what the victim has stated, what the testimonies have said. And so if this perception that the judge receives is distorted, for example, within a wrongful perception, he's going to form his own perception similarly. For example, if within a process I have the victim making the identification, the testimony identifying, and the defendant denying, and without any other evidence, hardly ever this person will be acquitted. If this identification was correct, the decision is correct. The ruling that the judge has admitted was correct. But sometimes this wrongful perception forms a wrongful conviction by the judge. Those were the elements that they had, the elements present on the process. Resolution 484 of 2022 of the National Council of Justice is commendable. This is a big landmark because it details the identification considering the consolidated case law by this Federal Supreme Court, by this observation of the Article 266 of the Penal Process Code being considered, and then the identification will be definitively more safe. The considerations of this resolution are perfect because they have a basis on reality, on the streets, basis on what happens daily. And those considerations have a crucial aspect of our society, which is the structural racism. And once more, I shall say, the structural racism has been established particularly in photo identifications. I was happy to hear from Dr. João Paoli talking about the evolution in the manner that police produces initial evidence. That is why we have the Ordinance 26 of 2006 that institutes in the civil police the consolidation of service rules for the judiciary police. In this ordinance, as Dr. Venâncio said, this essentially repeats in its article 139 and 147 the National Council of Justice's resolution. That is a point, a big progress. But what we saw very commonly was trying to find best practices for the facial identification with the support of artificial intelligence. And here, I must ask for a brief pause for us to reflect. The recent progresses of science and data science and artificial intelligence, alongside the requests for safety, created a security society, Big Brother itself, and they are formed by statistic probabilistic data that are more and more sophisticated within a data bank that grows every day. And here I ask you to reflect. Then we had changes in paradigms, changes in democracy and in fundamental rights. And I'm going to bring some examples about the use of technology for facial identification based on AI in the law of data protection of the article of Samuel de Oliveira and Ramon Costa. It's always good to mention the source, right? But they say that in China, 200 million cameras are a part of the vigilance system that is able to recognize basically any of the more than 1 billion inhabitants of the country. In Dubai, the capital of the United Arab Emirates, one of the main airports of the city, has more than 80 security cameras. They capture and they digitalize through scans people's faces as they are walking by. Once the person has walked by, the generated images will allow the continuation and the exit of that passenger safely, or will indicate other diligences. For example, you're leaving, you're going by with your luggage, then you're being monitored by the surveillance equipment. So that we don't talk only about foreign cases. In Brazil, we have the program Rio Mais Seguro, or Safer Rio, with the use of a facial recognition software that is based on AI. The goal is identifying and keeping suspects that are running from law abroad. We have been through some delicate situations, and this matter of artificial intelligence, of face identification, biometric identification, has to be well established. I believe that in most of the country, but in São Paulo, you cannot enter any commercial building, any clinician's office if you're not making a registration. Then your picture, your document, and sometimes your fingerprint is there. And you might be surprised eventually by something that you learned, but actually you didn't do that. And they're going to ask you, how wasn't it you who did that? We have your picture, we have your document, we have your fingerprint. And you say, well, the whole of São Paulo has those information. So I have to be careful with that data. But it is hard to understand the application of this technology with a strict consideration to fundamental rights, such as intimacy, data protection, and freedoms. This is one of the most concerning topics, since it is connected to the presumption of citizenship and the preservation of the democratic regime. This is so important that throughout the world it is being discussed. And in the European Union, we have the Directive 186 and now the 1089 regulation from 2009 that has been trying to give a direction to how to deal with the data. We have an excellent article, the use of facial identification technology for aims of public security and penal prosecution in Brazil, mapping decisions and possible regulatory pathways. This is in a book, and that has been coordinated by the Justice Gilmar Mendes. The writer informs that in Brazil we only have a single reference, the General Data Protection Law. Then on the fourth article, 6th item excludes from exclusive applicability describing the activities of data managing as exclusive competence of the public power. In the same article, there is established a limitation for this exclusion, bringing peculiarities with public interest and the need for the principles of the law itself to be considered. And there is a bill that is ongoing consideration that talks about how this data can be managed. And within this context, even though we can set aside the technological resources, actually we cannot set aside the technological resources of AI, there are still key issues to be solved. And there are scholars that say that all of the data from artificial intelligence, from the algorithms, are real data. And if our reality is racist, we cannot turn to the machines because they'll give us the same result. We need to filter, to qualify these images, these data that are being brought. And here I want to close. Within the fundamental rights, intimacy, data protection, freedom, and the notions of citizenship and democracy, and the use of this technology with a focus on storage and management of those data. And when these matters are being discussed, good practices to avoid misidentification thus far are retained within the strict observation of articles from the Penal Process Code of Brazil. I only want to bring a single additional data to qualify the identification from the edge, from the police officers into what will happen in the trial. For that, we need to apply the idea that somehow the absurd amount of investigations and processes need to be equalized so that we can have full and complete attention to each one of them. And I can give you a simple solution, depending on the legislator and the legal profession. We need to subsidize the legal goods. If we consider everything, you can remove half of the problems that exist, and you can find a better way in action, or a better pathway for action. I'm sorry if it took too long. Thank you very much. The appellate judge Adalberto brought the tone for us to close this panel with his balance, with his intelligence, with how deeply he brings this topic to us, and showing a number of perspectives from the several actors, the several players involved, bringing the need for us to fulfill the Article 226 with the variables related to timing and to the current days. When we are in a time of artificial intelligence that is so key to this particular topic related to the qualification of investigations through processes of identification and also through the qualification of the evidence that begins on the investigation itself and then goes through appraisal by the accusers, since we are at a democratic rule of law. Thank you very much. Appellate Judge Adalberto. And we want to pay homage to all of the judges in Brazil, and particularly to the Court of Appeals in São Paulo that has an extraordinary experience and has been giving us great contribution as a legal community in Brazil. And so now we close this panel. And so I want to thank all of the participants of this panel and to say that we are not leaving as we've entered, because each and every one of us brought a different standpoint in addition to such an interesting topic that will effectively bring reflections and deep reflections like the ones we had today. So I close this panel.
Senhoras e senhores, agradecemos os pronunciamentos.
Ladies and gentlemen, we thank for the speeches done, and then later on we'll have the fourth panel. We ask that you wait within the auditorium.
We have presiding the table the Minister of the National High Court, Augie Fernandes, and the Councilor Paulo Coutinho Barreto, and as speakers, the attorney and founder of the Innocence Project Brazil, Rafael Tucherman, the criminal Leandro Carneiro, and the Councilor Marina Diaz. To conduct this panel, Augie Fernandes. Good afternoon, everyone.
A quem para o Distrito Federal se deslocou com essa
For
temperatura.
those who came to Brasilia with this wonderful weather, it looks like those who came from abroad brought us rain, which is wonderful. My colleagues here at the table, at the panel, my colleague here who will share with me the role of mediation, Paulo Barreto, the participants, Dr. Bianca Kremer, Leandro Carneiro, Dr. Mariana Diaz, and Rafael Tucherman. I salute you, I greet you. And I was asked when I was arriving that I should introduce the topic briefly. The topic, as you know, is what we want and we don't want. In other words, with regards to identification, and I have to confess something. I deal with the criminal law since the second half of the last century, since 1978. When I was what today is public defender, which was called something different before that, and from 1981 I became a judge up until now. And when I went to see the charter written up by the National High Court of Brazil with the support of our dear Schietti, I realized something I hadn't realized in a very long time, which is that this Article 226 is not an old known, but it worried me. Because for identification, and it's wonderful, it talks about the steps that one must take. It could be the witness, it could be the victim. At the first point in time, it asks for the identification of the accused, whatever it may be called. And after those first steps, if there is no personal identification, there is a photograph. And only in the morning, Skady, I realized, imagine a victim describing the following person. Do you know the author of the action? What does it look like? Well, he is elderly. He has gray hair. He is dark-skinned. He is not slim nor overweight. He has a northeastern accent, and he has a mustache. The first photo will be mine, right? It's along those lines that I bring the theme for your consideration. I will call on, first of all, as I was told, I will first call on the playing of a video with the testimony of Diana de Sousa Melo, which was a victim of facial recognition, wrongful misidentification. Let's see.
Eu sou psicóloga, servidora pública, estatutária do município de Nova Iguaçu, dentro da Secretaria Municipal de Assistência Social há 10 anos. E atualmente estou como coordenadora de promoção de igualdade racial. Mulher negra, cria da Baixada Fluminense. Passei por uma situação recente, a qual venho relatar, compartilhar com vocês, no dia 31 de abril deste ano, durante a Conferência Estadual de Promoção de Igualdade Racial, um espaço ao qual fui representar o município que eu atuo como delegada eleita, na Conferência Municipal, e estive na Conferência Estadual representando esse município. E no último dia desse evento, passei por uma situação de abordagem do segurança presente, a segurança pública do município do Rio de Janeiro, no centro do Rio de Janeiro. E fui abordada por 3 agentes do segurança presente, trazendo a alegação de que eu havia sido reconhecida pelo sistema de reconhecimento facial que está sendo adotado pela segurança pública do Rio de Janeiro. Esse sistema tem sido implantado em algumas cidades do Brasil e ele vem de fora, já foi implantado em outros países, inclusive alguns já foi banido pela constatação de que ele não reconhece corretamente os rostos de pessoas negras como eu. Ser abordada por esses agentes de segurança pública me impactou de formas que eu mesma não saberia mensurar. Eu, naquele momento, fiquei incrédula, muito irritada com a situação, mas também muito assustada, por lembrar de como corpos como o meu são tratados nessa sociedade, Os meus pensamentos na hora eram: eu preciso me defender, eu preciso me posicionar, porque eles podem me levar para a delegacia, eles podem ser truculentos, a minha segurança está em risco. E foi muito interessante pensar nesse lugar, assim, a quem serve a segurança pública no nosso país, porque eu, particularmente, nunca me senti segura. Os meus nunca se sentem seguros e a minha família não está segura. E passar por essa situação publicamente, além de vexatória, me trouxe esse lugar, questionador, de quando corpos como o meu estarão efetivamente seguros, em segurança, já que o reconhecimento fotográfico sempre nos expôs, a bala perdida sempre nos encontra, os índices de violência sempre são encharcados por pessoas negras. E essas são as únicas estatísticas que geralmente nós ganhamos disparadamente. Então, eu tive o valor do meu trabalho questionado por mim mesma, no lugar de se eu estou coordenadora de promoção de igualdade racial, atuando com políticas de promoção de igualdade racial, de garantia dos direitos da população negra e indígena, qual é o sentido, né, do que a gente produz cotidianamente se todos os dias nós continuamos sendo mortos, sendo abordados, sendo confundidos, tendo nossa competência questionada, tendo o direito de ocupar espaços questionados, né? Do que se trata o que a gente está construindo e se é que estamos construindo alguma coisa. Seguimos, porque precisamos seguir. Eu sei, no fundo, a importância do trabalho que eu desenvolvo, a importância de, enquanto mulher negra, ocupar alguns espaços. Então, não pretendo desistir, mas é muito violento. E o racismo institucional nos afeta o tempo todo. A estrutura atua na manutenção das mais diversas violências contra corpos negros. E o racismo algorítmico, ele é só um aperfeiçoamento disso, né? Porque agora as pessoas, a segurança pública pode alegar que eu não errei com uma pessoa negra, foi a inteligência artificial. E as máquinas não erram, elas são programadas para não errar. Mas quem é que programa? É um sistema racista. O tanto que elas não reconhecem corretamente corpos negros, porque elas não reconhecem corpos negros como pessoas. Ou seja, basicamente o que a gente enfrentou ao longo da história. O processo de desumanização dos nossos corpos que nos expõe às mais diversas formas de violência. Essa situação impactou os meus amigos, a minha família, pessoas como eu que viram a matéria na televisão. Eu fui abordada por ambulantes, em eventos, eu fui abordada por pessoas que falaram: ai, você é aquela menina lá. Cara, eu fiquei preocupado com isso, eu fiquei com medo. Aonde eu for agora eu vou ser abordado? E eu, infelizmente, não podia dizer para ele: não, fica tranquilo, não vai acontecer com você. Muito ao contrário, eu disse: toma cuidado, porque nós estamos em risco. E isso pode acontecer com qualquer um de nós. Enfrentei questões de impacto emocional, precisei buscar um serviço de saúde mental, precisei buscar um psiquiatra, precisei buscar atendimento psicológico para lidar com efeitos de estresse pós-traumático. Enquanto psicóloga, a voz até escapa, enquanto psicóloga eu acompanho todos os dias pessoas que são diretamente impactadas pelo efeito do racismo, pelas ações do racismo. E isso definitivamente precisa acabar.
Bem, eu acho que
I think
agora
that
calhou muito de uma forma
it
perfeita
really fit in
com a nossa próxima
with this testimony fits in very well with our next speaker.
eu passo a palavra para o Dr.
I now hand over
profissional de segurança pública,
to
criminal da Polícia Civil do Distrito Federal.
Leandro Carneiro, criminal expert at the Civil Police in the Federal District. And he's the coordinator of the AI nucleus of the Civil Police of the Federal District, who will be able to bring of his knowledge related to the issue of technology-related facial recognition. Thank you very much. I would like to say that it's a privilege to be here, first of all. Good afternoon, everyone. I would like to thank for the event, for the invitation. I'd like to congratulate everyone who's here. Thank you for your time. Time is one of our more scarce resources. We have been at this event since yesterday, and it's part of my commitment at setting up this presentation so that we could really take advantage. It's a short time to say a lot, so I will try to move through a technical basis so that we can understand how the facial recognition system works, what's interesting and how it's interesting to use, how it can be helpful in a positive manner, and how it's not advisable to use it. So we'll deal with some best practices. These are not our best practices, they're international best practices, and that will lead us through the sort of technical or technological pathway. For those of you who are here, it aims to give us a basis so that we can make decisions as to the use of this kind of technology. Let's start by clarifying what it is, artificial intelligence. We heard a lot of terminology, many acronyms, but for us to arrive at a common point, AI is actually hard to define because it's abstract. Intelligence is abstract. What is intelligent for me or for someone may not be for someone else. So an attitude, an intelligent action at one point is not intelligent at another point or a place. So the term artificial intelligence is abstract. In the doctrine, in books, we have various diverse definitions. When we talk about machine learning, which is a subfield, it actually becomes more concrete, more clear. So we have here a system which trains a model to conduct, which from data infers things. We can train the model through a mathematical algorithm to give us a result based on those data to which it was submitted, that were fed into it. So with that definition, we managed to exemplify that an artificial intelligence model is a mathematical model that reflects those data that was submitted to. That's the idea.
Opa, passou. Pronto. E aí, exemplificando, né, imagina que o meu problema...
Imagine that my problem is to divide between cats and dogs. I have a database, and I submit that database to training. So my model will absorb those features, those attributes. What is a cat? What is a dog? What do they look like? And then naturally, I have to have variety that encompasses the reality. I shouldn't have just one species of cats and many dog species, otherwise it will fail at the classification of the cat. The same happens with if I have the number of images also needs to be balanced. So it's various factors and a variety of points that we need to keep in mind when we set up that database from a statistical point of view as well, so that they have the sufficient attributes for the model to absorb those attributes. And those attributes need to be relevant for my case. If I'm training cat images at night and then place the system to work with images of cats during the day, it won't work. I need to set up the images so that it is a similar scene to the one which the model will find itself in. Right. This issue of the regulation of AI is quite hot. It's quite spoken about at the moment. We have this regulation being discussed, and it's divided into three categories: high risk, low risk, and forbidden. So some cases were actually banned. Some ways in which AI is used in Europe were banned in real time in public areas, for example, which is what we just watched in the previous video, were banned in Europe.
So, for example, you are at a center in Paris, and then Big Brother is monitoring all of the faces present there. This is undergoing discussion in the American Congress, and the big point is regulating a dynamic and evolutionary technology without blocking its growth, without binding its development. And here we're talking about national security. This type of technology can be used for military means. So we need to have this discussion as to regulate the technology, but without blocking its progress, and also allowing the countries to protect themselves and use this type of technology in their defense. Here in Brazil, this topic is being discussed in our Congress. Not as vigorously, but it has started. So reach a point where society will need to be more participant in that. We'll have to better understand the topic, to participate in votes. Need to understand how we want to use the artificial intelligence systems within our society on a daily basis. And somehow this might be positive for us to have other models being launched and discussed, so that when this reaches us, we'll have previous and consolidated discussions about how the ideal use of technology could be conducted in the country. Now, going into the facial identification and a system and algorithm for that, we see that there is a pipeline, a flow. So how is this score calculated? How do you determine the similarity between two faces? There are 4 separated algorithms, or even more, but here we're only considering 4, that once combine a system of facial recognition. So the first step is for us to detect the face, the image where we have a square around the person's face. This is an algorithm that only does that. It detects faces. This is its goal. So if I send an image with 4 faces, you should have 4 squares for the 4 faces. And then I go to the next algorithm, which is aligning the face. We need to align that and put that into a canon position, which would be facing forward. So there is a rotation of the face. You have a system where you of the face, the square that has been turned forwards, and then you turn that into a vector. You do that for 1, 2 faces, and then you have 2 vectors. And once you have 2 vectors, mathematically speaking, you can see these vectors within the same vertex, and then we can calculate the distance between them. And that's the idea of similarity between faces. That is how we calculate representations, 1 for each face. We have 2 vectors, and then we plot the vectors within the same space and we calculate the distance between them. In that case, we have a distance between a cosine. We have a connection between 2 lines, and we can calculate the distance between them. We have closed vectors in similar faces, and vectors are always mean different faces. And this is the result that we reach when we run 2 different faces within this algorithm. People with similar faces will be closer to 1. We can go from 0 to 1, and different people will have a similarity closer to 0. And for us to statistically calculate the distance between what are different and in similar faces, we are in between those frequencies. We have positive and negative frequencies. We are using LFW as an example. This is a data set, a body of images and faces that is used as a for that. So let's say that you have a facial identification algorithm, you submit it to a data set, which is a benchmarking tool, and then you can say, well, my algorithm has 99% of accuracy within this data set. Obviously, if I transport this algorithm to a different data set, for example, as the one over there, you can have a variation in accuracy. So more difficult data sets where I have more similar people, where I have a higher degradation, lower luminosity, lower light exposure, I'll have naturally worse results for the same algorithm. I am making comparisons for different data sets then. And if someone says, well, a certain algorithm has 90% of accuracy, but this accuracy is for which data set? For what basis has it been submitted for them to have that 99% score of accuracy? It's important to keep in mind, because if it is submitted to a data set that is not representing the reality where it would operate, the score is useless. You need to confront the algorithm according to the reality in which we will operate. So this is what we have of most common. Image pairs. When one does not have a degradation, maybe an official picture, and the other one with a degradation, normally taken in an uncontrolled environment, a wild environment, as it is called within literature. A photo with and another without degradation. In the worst case, we have both photos with degradation. Both of them were taken in an uncontrolled environment. We have a light incidency where the face is not visible, it is not positive, so there are several situations. What is important for us to understand and to interpret the degradations present at the faces? So this was a study that was conducted for you to have an image with and without degradation. And the degradation increases over here from left to right. And you can see in the graph that the accuracy of the algorithm is decreasing. This is something expected. So the more degradation I have in the picture of the face, higher the degradation that the algorithm will show. So let's imagine that I have a closed, cold algorithm. I don't even know what is the algorithm within the system. How can I calculate what is the impact of degradation for that system? I'm not able to do that. If the supplier does not give me this information, me as the institution of public security, am not able to quantify what the impact would be. And if I'm working on a system of facial identification, I need to assess the concept to which I am submitting my algorithm. So if I have an extremely degraded image, I need to be aware that the algorithm will not present the 99% accuracy that we saw. There will be a degradation upon that. But to what degree? This is the study precisely. You see the level 3 photo, the middle one, where you look and eventually you might even think, well, I can run it by this system. You can see the contours, but if you look in the graph, at level 3, you have a severe decrease in the ability of the algorithm, the blue level, in comparison to the best level, the blue one. And for us to understand this degradation, how the algorithm works with that, in which the algorithm is robust and which it is not. This is exactly the point where we can make an expert examination, where we can analyze the picture to verify its quality and understand whether that is feasible to submit to the algorithm or not. Well, some application examples here, when we have the comparison one by one, when we have a picture removed from a camera with a picture from the bank. And here I want to mention what is the examination of facial comparison. It is an examination where we have two images. We have two criminal that have studied for that, and they will try to assess the evidence in a morphological manner, and they will be assessed by an algorithm in their analysis. And then we want to know whether it is possible to use the algorithm or not. So in this examination, we have the detection of morphological contours that the person will present. So there are a number of contours in the mouth, the nose, and the hairline. And lastly, we're going to elaborate a report where we have a scale. But we're not going to deliver a positive or negative result, identified or non-identified. This is not what we're going to send back. We send back a scale that supports or not supports the position of that being a person. And the material gives you a possibility of that being this person or not. And there is a methodology within the report. It's a matter of the reproducibility of the evidence. This is not only for the defense, but also for the prosecutors, of how important it is for us to be able to repeat how we reach those results, for us to use the open code algorithms in explaining their functioning. The confrontation 1 by none, when you have an image and you want to find the persons that are most similar to that one. This is very risky because sometimes you can have a number of mistakes in ordering them, but you can limit an investigation to a smaller range of people, which can be sometimes the beginning of other investigative processes. There we did an interesting work, a session of documents and of people that committed a specific crime. We grouped of the faces and we understood who were those criminals within the federal district. We put the false name for the false that were untrue, and we made a ranking to find the group that is committing this type of crime more commonly. Another application, we are trying to find players that are committing crimes at a location and then go to a different location and trying to match those crimes to tell the police stations in the area to endeavor efforts in that sense, since they are acting in different locations. This can make the different teams make the same investigation in several different locations. And it would not be possible to solve a problem of about 1,200 imprisoned people. And the federal police had the mission of individualizing the conduct of each one of those. And how could they do that when looking at the videos and trying to connect the video with the person imprisoned? So we used a facial identification algorithm exactly to limit the scope, to identify where those people were within the videos, to deliver that to the responsible experts. In that case, it was Rafael Ribeiro from the federal police. And then they did an examination of facial comparison with a methodology so that there could be an evidence production for us to deliver to the federal Supreme Court. We have an international group, and this is an extremely relevant one, which is FEED-WG. There are a number of guidelines for best practices, not only for developing facial identification, using facial identification algorithms, ethics matter and how they are approached throughout the world. So those guidelines can be used by those using and by those building the algorithms. We have an ISO being built. It will try to answer the following question. What is a 10 picture? What are the attributes to that photo of a face so that they'll have a 10 and a 7 and a 5? Because from the moment when we can qualitatively analyze the image of a face, we can say that this algorithm can work until a grade 8 picture or a grade 9 picture. So for us to have metrics for the quality of a image of a face is an important step for us to understand where certain algorithm can be used or not. Here we have the content of it. So we are mathematically trying to understand aspects of such as luminosity, of blurs in the picture, and so on and so forth. Here we are dealing with problems of imbalanced data sets. So we are using, with the use of artificial intelligence, this comes from the 2000s, and ever since then a lot has changed. we had and we still had a number of imbalanced data sets. So we can see the amount of men and women, the amount of certain ethnicities. So when you are trying to use these data sets for an algorithm to learn, you're going to produce the results that you're seeing over there. You can't expect something else. They're not going to do more than what they were trained to do. So for me to have a palatable algorithm, I need to insert qualitable data, particularly through the good practices that were established by another team, not the team that is conducting the training, and then you can attain the data from that. Point one. Well, for some reason, my slide was not very well presented, but then we have an example of a data set where clearly the authors were careful to have a balanced data set. We have 25% for each of the ethnicities. So from the mistakes that were committed clearly, in several cases, scientists noticed this and were starting to resolve those problems. And we have a number of researchers that are trying to specify and to clarify the reasons for the distortions in results of the algorithms. Some studies say that putting too little images or too many images for a certain group will have the same effect of sabotaging the result of that group. So you need to employ a number of good practices and rules so that you can effectively assemble a base and then submit that to an algorithm. I'm sorry for the rush, the time is brief. So my final considerations. The facial identification is being expanded. It was my entry door within AI. My master's degree was in facial identification. It has evolved a lot ever since then. There are mistakes. Those mistakes are being corrected. A lot of money is being invested. Face identification is a success case. Many times we need to know when and how to apply that. We, as experts, and when we receive an examination, we need to assess the context of those images, how they were produced, what are the degradations, the characteristics of the image, can I submit that or not to a facial identification mechanism, until what point is this worth it, will I have advantages or not. An examination of face identification has a morphological part, and then there can be an analysis with the system, with the support of the facial identification system. So basically, the result is I have a system for facial identification that will produce a result, a similarity. But if I want something more concrete, a more robust evidence, something that indeed will be an evidence, I need an examination of facial comparison, which is an examination conducted by two criminal experts that will observe a number of other matters, including the morphology of the face. It's not enough to just throw two faces within a system, and any result that I have from it, I will consider to be true.
Thank you so much. I'm so sorry for the speed of the presentation. Just to end, I would like to invite you all to the Criminal Institute, which is next to the City Park. We conduct several exams and studies and tests there, philosophy and DNA. We don't do, but everything else we do at the Criminal Institute, Criminal Law Institute. If you send us a message, we can set up a visit. Thank you. It wasn't a talk, it was a lecture, because the information that you provided were from another world. We often don't actually see this, and I'd like to make a comment. If I am talking to a group of lawyers, pay attention to a detail. The law firms of the future will be made up of technologists. I remind you of Susskind's book, which is the one that perhaps predicts the future best in the area of law. There's one on the law firms of the future. His works at the moment are not in Portuguese, but in Spanish and English. but you can find them online easily. I remember such joy the day that I discovered that on the following semester I wasn't going to teach maths any longer. And now what I see is that the math is coming at us once again because of this switch of the technology approaching us in the area of law. I would like to thank Leandro for the depth and objectivity and his agility in dealing with this subject, which really evidenced very clearly the difficulties in terms of technical difficulties, the need for human supervision, and because of that, the problems. And that's my conclusion, the problems of the use of facial recognition for searches and for apprehension requests that take place. And now, moving on, due to time, I would like to invite Dr. Marina Diaz, the Executive Director of the Institute of Defense, the IDDD, former President of Institute in São Paulo, and the Institute for Defense of the Black Population. Thank you so much for being here with us. Good afternoon, everyone. I would like to greet, first of all, Minister Fernandes, Justice Fernandes, Councillor Barreto, colleagues. I would like to also greet everyone here, Janaína, Machida, and Flavia, my colleagues and partners. And I prepared a presentation, but I will not actually use it because I have a short period of time, so I will focus on my speech. The IDDD is a non-governmental institution, an NGO for the democratization of the access to justice. We have 4 programs: the defense of the right, the fight against super imprisonment, and so we deal with various strategies that go from research and capacity building, advocacy, other strategies, empowerment in the territories, communication, and many other initiatives. But what I would like to talk about is one specific project today, which is the proof under suspicion, started in 2017, and it looks to qualify the production and valuing of evidence in the penal process, especially those that have to do with memory. And now also we start to go into the issue of excerpts, of facial recognition, and in artificial intelligence as well. I will not be able to describe every activity conducted by the Institute, but I will highlight some, such as a notebook for guidelines for the justice systems on recognition and witnessing that were made up by a task force on specialists, and among which Janaína, Machida here and others were part of it. After that work, with the cooperation of judges, defenders, delegates, prosecutors, and representatives of the civil society, the notebook has many proposals with a great legal framework on the topic, bringing the perspective of the racial theory so that it can be a tool. This work has been spread in trainings conducted by the Institute that has the coordination of Professor Janaína Machida and Veronica Mestrosa, and we have conducted 4 training sessions with judges and aides in partnership with Amapaz Institute, with lawyers associated with IDDD, with partnership with INADEPI, and with Anderson here, who is a great partner. It also opened to civil police delegates from the entire country. We're starting another training with the Federal School of Magistrates. It's still open for registration if you wish to participate as a judge and also aides, also for federal and national judges. You can find information on the Instagram of the IDDD. We also launched a dossier of interviews, texts, and data on the issue of evidence in Brazil that can be found on the website, Proof Under Suspicion, on the work on recognition that ended up in the Resolution 484. The Institute has also worked in emblematic cases reminded here by Pedro. One of the cases that I also want to remind you of, which is Paulo Alberto's case, that was built up with the Public Defender's Office in Rio de Janeiro and had 62 plus trials, all based on photos taken from social media. This Paulo was set up free in a historical decision that acknowledged a systemic violation on behalf of the justice system. And from that, I would like to highlight two topics that talk to the proposal of the table and that deserve our attention. Witness, as a police witness, and the police focus, the way in which the police structures on offensive policing that prefers or has a priority on young Black men, resulting in arbitrary incarceration based on biases. The urgency in the definition of minimal parameters and the need that the judiciary needs to have to justify objectively as to how that suspicion was consolidated needs to happen. In São Paulo, since 2020, almost 12 million personal searches were carried out, less than 1% out of which resulted in convictions. Therefore, the suspicion doesn't become concrete in 99% of the cases. Sex as a vigilance on just one group is one of the factors that compete for the overrepresentation of the Black population in the prison system. 1 out of 3 people in prison, 2 out of which are Black. Therefore, the fact that we don't have objective information on those systems by the police, such as the justification of the act resulting in prison, and this is very grave. The lack of transparency, and this makes it impossible for us to have transparency or surveillance of the institutions and the justice system, aside from being very relevant information for policies in public safety. The only information we have today on this kind of work is that there are violent practices based on discrimination that are based on subjective criteria. That is the information that we cannot argue with. The IDDD carried out a research in Rio de Janeiro at a favela, and the research encompassed Rio and São Paulo, and brought forward 2 protocols for the search of Black people and white people. Black people have 4 times more probability of being apprehended than white people. 81% of Black people have already been approached, and in white people it only happened in 17.9% of people. 6% of Black people heard explicit references to their race and color during the apprehension, whereas white only 7% had race and color mentioned. Faced with this, the IDDD came in with an amicus curiae versus the state of Argentina in front of the Inter-American Court of Human Rights, dealing with discriminatory practice on behalf of the police. The Institute took the Brazilian context to trial with the aim of making the process well known, and even though the drugs were found with both accused, the means through which they were apprehended were actually deemed illegal. But Argentina was told to change their legislation to avoid arbitrarities in inspections of bodies and vehicles. and the training of police forces, and it determined the recollection and publication of statistics on how the police force operates in Brazil. I'd like to highlight the recent trial at the STF that fixated the thesis that considers illegal the approaches by the law based on race. The case, however, kept the conviction of the defendant. We had Exxon Fakim be part of the vote, and they worked together with the Coalition for Black Rights. Before and trying to respond to the table, I'd like to highlight the resolution from 2022, whose text was suggested by the IDDD in conjunction with other organizations, and the project makes policemen describe a series of information detailing the motivations for which they have a suspicion and how they make the approach. This text would be a great step forward in trying to mitigate abusive practices against the Black peripheric population. The other issue that I will mention very briefly, and that we need to definitely deal seriously with, especially when we discuss the qualification of the proofs in the penal process, is the disproportionate weight conceded by the judiciary to the police testimony. Police testimony in trials needs to be valued such as any other witness. The testimony, they don't have more veracity, especially when there are no other evidence. Aside from the fact that there is an attribution to the memory topic that has been exhaustively dealt with today. There are defendants affirming that the word of the police officer is not enough, and it's not evidence as such in a penal process. These rulings also call on advancement of technology and the use of body cams that may and should be used to actually attest to the testimony, providing credibility to the actions of the police agents. We cannot not open to external tools that can value the evidence in processes. With that, I say that I am enthused with the idea of having a dialogue and a debate that is so important and so urgent with actors of the justice system here at the National High Court of Brazil. Thank you very much.
Muito obrigado.
Thank you very much, Dr. Marina Diaz, for your brilliant speech. But it not only talks about the activities of the IDDD, but also talks about what we need to chase in the production of evidence. And once again, I now hand over to Dr. Rafael Tucherman, attorney by the University of Rio de Janeiro.
Boa tarde.
Good afternoon, everyone. First of all, good afternoon, Justice Fernandes, who has made us joyous with his return to the criminal area after many years. Minister Augie was not able to participate of this revolution, but certainly he will contribute for this revolution to be sustained, to have a basis, and can grow. So it's a great joy that you have come back to this panel. Dr. Paulo Coutinho, also thank you so much for your presence. Marina, our friend from IDDD. Dr. Perito Leandro Carneiro, who managed something of a miracle. I am a dinosaur of technology, and I managed to understand how facial recognition takes place. So congratulations, Dr. Leandro. When I knew about the topic, I thought about whether or not it would be a contradiction to come here to talk about identification, because we are going beyond people identification. But there is no contradiction. On the contrary, the horizon of people identification needs to take us precisely to being able to see this as evidence that is very much relevant of criminal investigation and of the criminal process. When Justice Katie started this revolution, we had a very different scenario in which the recognition of persons was not just the fundamental basis in terms of evidence, but it was trusted blindly, and at the same time, the recognition was carried out in a totally illegal and informal way. We are walking not so fast, but we are walking so that the identification is carried out in the appropriate way, in the way in which the law recommends. Perhaps one day we will arrive at a point in time in which our goal is that we go beyond the recognition of persons as a trustworthy process, which is not. Perhaps the largest contribution of Brazil is with our concrete cases, ours at the Public Defender's Office as attorneys, but the concrete cases aside of drawing or calling on our attention, they're also useful in we're going to compare the tragedy, which is equivalent to a plane falling. When a plane falls, and it's terrible when that happens, within all the pain, at least there is a teaching, a learned lesson that we can provide it with, such as it happens with judiciary errors. Each innocent person that is convicted and imprisoned, and that shouldn't happen to anyone, but it does happen. We fail. The system fails and will continue to do so. There is a lesson to be learned from each case. Our cases teach us a lot. But the issue of our discussion here today teaches us, among other things, that aside from identification, normally and perhaps almost always, there are proofs, there is evidence that if produced and considered during the investigation of the process, would avoid for all of those innocent individuals to be or to suffer wrongful imprisonment, which is terrible on its own, but even more so when it's about a wrongful conviction. I apologize for the expression black box, but the black box, it's actually orange, it's not even black.
In the sense that the black box might reveal what went wrong with any of these cases so that this will no longer happen. So let's very briefly speak about some of the project's cases, beginning by the case of Antônio Cláudio. He is a man from the state of Ceará, the city of Fortaleza, and he was condemned as the motorcycle maniac. He was an atrocious criminal in Fortaleza, raping women. This allegedly was Antônio Cláudio, and many of the depositions were recanted, except for one by a minor. I'm going to speak about nearly all of the cases, but the eyewitnesses were the basis for the conviction. And then there was an image of a street camera that recorded the actual motorcycle maniac many years before Antônio Cláudio was condemned by the crime and convicted by the crime. And the victim themselves said that the person on the video was the perpetrator, but this was never used as evidence. So we were invited by the Public Prosecutor's Office of Ceará to help this case, and we received the images from the TV cam, and we sent that to an expert. Evidently, we cannot identify the face of the perpetrator through that, but it will help us in what I'm going to show, in calculating the height of the person. So even by making a comparison with the motorcycle that we knew the model of, with the characteristics of the person riding it, we were able to demonstrate by this photographic report that the perpetrator was 25 centimeters taller than Antonio. And the investigators were convinced of the innocence of Antonio Cláudio, and they made a practical experience. Antonio Cláudio was not able to reach the pedal of the motorcycle when they put them on top of it. So this evidence was forgotten, left behind, and after 5 years of wrongful conviction, this picture led him to be acquitted and to be rendered innocent. And so the eyewitness account was basically the only aspect that led to his conviction. And here we have the difference in height. The second case, the case of Kleber Michel Alves. He was convicted by a crime that actually never happened. The rape of a vulnerable person, a minor, something that allegedly had happened in São Paulo. Kleber Michel Alves was incarcerated for 3 years. His son was born after he was arrested, but so he took nearly 4 years to meet his son. But in the process, there was an official evidence that Kleber worked with footballs, and then he was going to get those balls that were done by imprisoned people in the prisons. But this evidence was set aside because they did not know the exact time that Kleber went to the prison. This is a prison that was very far away from the city, was the alleged crime we heard. He was condemned, and he was convicted actually based on the eyewitness, as well as the false testimony. And he only entered the case because the photo of him was shown, and the alleged victim had to point someone, and they pointed out him. So this also was an illegal showing of his photo. And once more, the pictures were possible to obtain since Kleber, and he always said that he left his city that day, which is Sumaré, and he went all around the state of São Paulo. This trajectory of him going, and then later on we're going to assess the trajectory of going back. And this left traces of signals for the phone antennas to reach. And so those traces were registered, but sadly were never verified. And those traces were absolutely compatible with his version of the facts and would completely exclude him from the scene of the alleged crime. Here we see the times, 10 a.m., and he went by Campinas. For him to reach the penitentiary, it would be 1 p.m., and the victim said that they were attacked by 12 a.m., and they would be with the criminal until 6 p.m. So we have a long passage of time that would eventually exclude Kleber from the possibility of being the culprit for this crime that actually never happened. So the system detects that, and here we have the path in the way back. And amazingly, one of his locations, he was south of Serquilho at 3 p.m. It is a very precise location, and he was south of Serquilho at 3 p.m. And he couldn't be there if the crime was being committed all of this period. And then he went back to Campinas at 4:27 p.m. Due to other circumstances, the victim recanted in the face of the public prosecutor's office that had an amazing work on this case after it was closed. The prosecutor of Serquilho contacted me and asked Kleber to be released right after this was proved. But this could have not happened in case such a relevant evidence had been used in the process itself. The case of Silvio José da Silva Marques, he was a fighter in Rio. He was a warrior, not only because he was a professional fighter, but he spent nearly 6 years in prison by an attempt of robbery causing death. This was a brutal crime. There were co-participants that were never discussed, that were part of the crime. But this crime occurred in a region of the suburbs in Rio de Janeiro from 9:30 a.m. to 10 a.m. We have uncontestable evidence that the crime began at 9:30 a.m. And the biometry of Silvio has shown that he had entered the gym at a time that was completely incompatible with him being present at the scene of the crime. So at the same time, the crime was happening. So the crime happened at the street of Samin, and Silvio trained in Recreio dos Bandeirantes, nearly 30 kilometers away. So this evidence was ignored. It wasn't even analyzed, even though it was in the files of the action. So due to a misidentification, Silvio was convicted. Also, there was an easily obtained evidence in his Facebook and the Messenger app. There were messages from the confessed co-criminal right after the crime was committed, reporting what had happened, reporting committing the crime, and this evidence was hidden, and it was very relevant in order to prove his innocence. And now I'm moving towards the end. Maybe I'll need another 2 minutes. In the case of Lucas, and we saw a very emotional testimony from him, but he was arrested as having committed several robberies to pharmacies in São Paulo. He spent more than 2 years arrested. He lost the early childhood of his son. And this is an impressive case indeed, because on the day of the robbery, one of the workers of the pharmacy saw in the security cams someone who appeared to be Lucas, and she told the police officers. She said, "I saw this on the security cams, and it seems like this was Lucas." But no one looked on the images, the footage of the security cam. Obviously, those images disappeared. Many years later, when we entered the case, we tried to recover those images, but they had been lost, obviously. But regardless of this, Lucas was convicted. I'm going to mention now the last case, perhaps the most emblematic one, Carlos Edmilson da Silva, an emotional report, 12 years of wrongful conviction. This is unbelievable. And in his case, as perhaps you might know, there was genetic material in 10 of the crimes that we worked with. There was a genetic material acquired, collected, and not processed by the experts. The undeniable evidence was there, and it stayed there, while Carlos Edmilson spent more than a decade in prison. Dr. Flávia Raal did artful work, and it was a slow work, case by case, and after a few years, we were able to acquit Carlos Edmilson when the proof of his innocence was at the face of everyone. And this was only used after 12 years of a wrongful conviction. I'm going to finish right now, I promise. Here we have the letter sent by the Federal Prosecutor's Office with the collaboration of the São Paulo's Public Prosecutor's Office. We were able to prove his innocence. And so, very briefly, we have pathways. What can we do from here on so that criminal investigations won't become a desert without people's eyewitness identification? And we have a resolution from the National Council of Justice saying that judges need to consider other evidences. These elements need to be searched for, they need to be produced. So we need to heed those elements beyond the identification. And our penal procedure code already has provisions for this process. There needs to be a collection of all evidence that is enough to clarify the fact. Not only the evidences that will show the culprit, but the evidence that will clarify the fact. And this is for the use of the defense even. And a mea culpa from us, the lawyers, we excuse ourselves from this obligation, that we have an ethical and professional obligation to immediately search for evidence that might show that our client is innocent. While this does not happen, when we have something that was brought to the criminal case law brought by Justice Ribeiro Dantas, which is a sort of sanction when the state is not doing their part in trying to find the evidence that can prove who is the culprit. So the national conclusion in this case should be acquittal. And a possible interpretation of the Article 167 is that if the state is not trying to maintain the registrations of a crime, the consequence should be the same, the acquittal of that person, in order to avoid that other errors continue to happen with such a high frequency within our country. Thank you so much for the attention.
Bom, nós estamos fechando as cortinas.
So we are now closing the curtains of this space today.
Todos sairão daqui e já se disse isso.
This has been said, but I am sure that every single one of us who has been here will leave this place better than we came, with some concerns, but with a certainty. We must improve.
Fico à vontade porque estou somente agora.
And here I feel very comfortable because after 10 years I am going back to the criminal field of the National High Court of Brazil, and I can see that our colleagues are doing their part as well. I also think that the lawyers, and by the testimonies that I heard here, the reports that were mentioned, the experts, the technical professionals that help us bring essence to our lives in making justice, all of them are working and endeavoring efforts towards this goal. So I want to send a tight hug to the workers from the National Council of Justice and to Rogério Schietti, who is a brilliant professional. I am older than Schietti, and you don't know how big the pleasure is for me to have voted for Schietti to enter the court. Looks like you entered by a vote, right? I am trying to show that I have relevance here, but that is the truth. And the group that works with him, in the case of my colleague, is today a national reference in what is best that is being produced by the Brazilian penal process. So now I wait for the guidance of the staff, and I'm an old man, and all old men have stories to tell. I'm going to bring the story about a case from here when I was from the 6th panel until the year of 2014. And we're going to see that sometimes AI or the computer at the time, because AI did not exist at the judiciary, sometimes describes, stores, and produces right data through wrong ways. Once I received a habeas corpus. The situation was the imprisoned person ran away from the jail in the state of São Paulo. And since they did not want to return to the jail, they stole an identity card. They glued on their photo and they started walking around São Paulo as if nothing at all had happened, as if they hadn't committed any crime. With a new name, their photo placed within the ID. So the world was perfect for him. A beautiful and tragic day. He was driving in the roads of São Paulo, and the people from the road police stopped him. And he went to them without any concern. He said, "Good afternoon." They answered, "Good afternoon. Please give us the car, documents, and your ID, your personal ID or your driver's license." He gave them the documents. And the police officer went to the police car, looked at the database, went back and said, "You have to come with me. You're arrested." Arrested? Yes, you are arrested. There is an order for your arrest. He was taken to the police station, and that is when he found out that he had stolen the ID card of another man that had been incarcerated. And this is truth. And this is bad luck, man.
Eu conto essa história porque eu fui o
And I
relator.
tell the story because I was the rapporteur of this habeas corpus.
Quando ele chega na cadeia,
When he got to the jail to be arrested by the crime of the person in the ID, the community of the prison said, "No, that's not the guy." He said, "No, I know him. He was arrested for something else, somewhere else." And that's the end of the participation of the computer on the daily lives of a convicted person.
National Council of Justice, Daniela Madeira. And as speakers, the president of the Innocence Network, Ana Vasquez, virtually, the attorney and director of the Innocence Project Brazil, Flávia Rahal, the journalist and writer Rubens Valente, and the director for promotion of rights of the National Secretariat of Access to Justice, Letícia Peçanha. To begin with our panel, we invite Rogério Schietti. We can say good evening already, as it's 6 p.m. in Brazil. We are arriving at the end of the very intense seminar that followed a very thrilling evening last night. And we will now conclude our seminar, as it's been mentioned, with the participation of illustrious speakers on the topic, and I will be mediating jointly with Councillor Daniela Madeira. And I believe we can move on to our first presentation after Daniela Madeira makes her brief intervention. Good evening, everyone. I would like to thank the invitation of Justice Schietti of Lanfe, this invitation to be here this evening talking on this very important topic, which is the cost of an innocent person's conviction, which reflects so much within the judiciary branch. I would like to greet everyone, Dr. Letícia, Dr. Flávia, Dr. Rubens, Dr. Ana joining us online. And as Justice Schietti has announced, we can now move on to the first speaker, Ana Vasquez, who is the president of the Executive Council of the Innocence Network, director of education of the Innocence Project in Texas, member of the council of the Hilton Forest Science Center, and she will join us through video since she was unable to be here in person. And Dr. Flávia Rahal, who will ask the questions directly to Ana. Dr. Flávia is an attorney at the University of São Paulo. She has a master's from the University of São Paulo, and she is conducting her PhD in the same institution. She is director of the Getúlio Vargas Foundation, vice president and founding director of the Innocence Project Brazil. And she's a counselor of the Institute of Defense for the Right to Defense, where she was president of the council. She's vice president of the FIEP for the defense of democracy and the rule of law in São Paulo. I now hand over to Dr. Flavia and Dr. Ana. Good evening, everyone. Good afternoon. I would also like to thank Justice Chieti, as it's become clear in last night's evening. He's a great leader, he's a reference, and he really leads us in the discussion of this topic that opened up so that we could arrive today with so many people from so many different fields of expertise, opening up to a fruitful dialogue on this very relevant topic, which is the recognition of persons. Justice Chieti, is always an honor and a satisfaction to be able to be here next to you. Councillor Daniela, it's a pleasure. Thank you so much for being here. And I greet Rubens Valente, a great journalist, and Dr. Letícia Peçanha. I will, as founder of the Innocence Project Brazil, have the great joy of asking some questions to Ana Vasquez. Ana Vasquez is the president of the Executive Council of the Innocence Network. She's an activist, therefore, in the cause against judicial wrongdoing. She is a person that suffered herself that wrongful conviction in famous cases in the United States, that is well known as the San Antonio Four. Ana is providing us with the honor of participating of this event. The Milton hurricane didn't make it possible for her to be here today, but she accepted to be part of this dialogue, of this construction through Zoom. And before I ask her the first question I have, when we think about the topic, or when I was thinking about this afternoon's topic at the closing of this event, what is the cost of an innocent person's conviction, I remembered that one of our assistants that has recently left a wrongful conviction accepted to do a psychological follow-up to try to recompose or build up his life. And in a very honest manner, he shares some of which he is going through in that therapeutic process. And the other day he told me that he's convinced through one of the sessions, after one of the sessions that he had with his psychiatrist, that what he went through is like a tattoo. Something that will never leave him. Even if he tries to erase it, there'll be a mark left. But in contrary to a physical tattoo, he has a tattoo on his soul, and he will have to live with this through his whole life. And Ana Vasquez has that same tattoo. She went through this as well, but very courageously, with great wisdom and much strength, she transformed that branding into not something that shames her. On the other hand, on the contrary, she turned it into a condition of becoming having a leading role in her life, and being an essential activist in this cause of wrongful conviction. So Ana is this voice of someone that, having gone through and being able to talk from that side, from that point of view, that the only person that can talk is the person that went through it, is the role of, for many years, having worked in the construction of a more egalitarian justice, and being a focus of hope for many people that are going through what she went through. So it is with great honor and joy that we receive you, Ana, here. And I now hand over to I move on to my first question. You, Anna, could share briefly with us the wrongful conviction of which you were a victim and what was the process like for exoneration?
Thank you, Flavia. And thank you, Brazil, that is there. What I want to talk about right now is the wrongful conviction. What I was accused of and ultimately spent many years in prison for was the aggravated sexual assault of 2 little girls. A crime that was never even committed. Back in the day, in the early 90s, the way the judicial system looked at us, they stated that it was satanic panic. They stated that it was something that lesbians do, being a part of the LGBTQ, and for many years ago, it was something that wasn't very agreeable with. People did not like the fact back then. So as you can imagine, the wrongful conviction of being accused of harming two little children is something that I still deal with today, even after 25 years plus. And to talk about the exoneration project, the process, as you can imagine, that is a whole other battle. As I was watching some of the cases that you were talking about earlier, some of those things could have been handled right away, but because of the process, it just it failed. The system failed us, and the process was four years longer in helping to Innocence, that and myself and my 3 friends. And it is just so hard to overturn this wrongful conviction.
Ana, você pode nos dizer, could you tell us what was the main mistake that took place in your trial, that which took to your wrongful conviction, and if there is something that could have been different?
The error that was found in my wrongful conviction was the recantation of the alleged victims, but also the science, forensic science changed. It was wrong back then, and it took 20 plus years for them to finally realize that and right that wrong. It was the science.
Como e por quê? And why and how did you decide to become an activist after your exoneration?
The reason why I became an activist was because I saw it so many more times that this was happening to the wrongful convictions of people. I could not just stand back and watch it happen, knowing what I had just endured after so many years. So becoming an activist was something that I became passionate about. It was something that I had to do. I had to be a voice for the voiceless because I knew exactly what was needed. And I knew how I felt while I was in prison and not having my case looked at and people fighting for the injustice that we had endured. We wanted to prove our innocence and nobody came to our aid. It wasn't until years later. So because of all that I had gone through, I felt the need, the passion to be an activist and to continue to push this wrongful convictions to the forefront. We have to admit that there are wrongful convictions happening everywhere. Being the president of the network now, it's not only in Brazil, we're talking in Japan, we're talking in Peru, we're talking very many places, 70 plus innocence organizations around the world. It's an unbelievable thing, but this continues to happen. and I'm just not ready to walk away from it.
E como os inocentados são apoiados por entidades públicas após a sua exoneração e liberdade nos Estados Unidos, especialmente em relação à
Especially in
indenização?
relation to indemnization.
Unfortunately, Flavia, there isn't very many support services here in the U.S. either. That is something that we're lacking in the services, because I don't think that people really realize what this wrongful conviction has done to myself and many others. I believe that they think once we are proven actually innocent, that we should be made whole again, and that is just not the case. We're not talking about what I had to endure while in prison and what my family had to struggle with, what our children had to struggle with. It is not just one person that it affects. It's a ripple effect, and it continues on. It continues to move, and it affects people in so many ways. So the support services, it's something that we lack, and it's something that is very well needed, especially here and everywhere. It's almost like we're setting people up for failure. If they don't have a support system in place, and we're releasing them after decades in prison, finding out how to maneuver through that process, it's just almost impossible to do.
Finalmente, Ana,
Finally,
qual é o
Ana,
custo de condenar uma pessoa inocente?
of the conviction, of the wrongful conviction of an innocent?
Flavia, I could talk about that for hours. You know, this is the part that really gets me, Flavia, because I cannot express in the right terms or how deeply that it continues to affect myself and other innocent people. Yes, there are many of us that, went through similar situations, but we all have that common similarity, and that is that the system failed us. And again, going back to what we had to endure and the loss of loved ones while we're gone, the loss of family and friends, the mental health that I continue to deal with. Bobby, after so many years, I still struggle to speak about this. And I really want the people in the room to realize that it's not a quick fix, that we need to start thinking about the larger picture and not just let's find them innocent and everything is done, everything is good, they should be made whole again. That's half true. That's half true, because gaining my freedom was everything. I never realized what I was going to continue to have to live with. The mental health, for example, the loss of loved ones, the loss of years of my life. I was, a young adult. I never had the chance to really experience life or make a name for myself as in having not the way that I saw it as I was growing up. I had plans, I had dreams. Getting into trouble, I never did. I was one of your model citizens, and still to this day, I maybe have one ticket. But it's just the things that I had to endure and see and experience, and hearing, the loss of my loved ones and the effects that it has on my family. It's just a continuation that I'm still trying to rebuild on. So bottom line, and I'll end with this, Flavia, is that these wrongful convictions need to stop. They are detrimental to people, to families, to children, to so many people. It's not just a one-person problem. It is not. Thank you, Flavia.
Obrigada, Ana.
Thank you, Ana.
Queria só
I
fechar,
would
ministro,
like to close by telling you that I was talking with Anna yesterday for a long while, and she was telling me that her mother in particular, who is a very Catholic person, suffered greatly because her case had a widespread repercussion that was involved with a scandal of a fantasy of satanic rituals. So she was swallowed by an accusation with 19 years of age of that seriousness of being having allegedly abused two children. And still, in virtue of that accusation, of her and her three friends that were taken into this tragedy of having been part of satanic rituals with a strictly Catholic mother that suffered much more than just watching his daughter going through what she went through. And I close by saying that when I was thinking from the point of view of the Innocence Project Brazil, what's the cost of a wrongful conviction? Evidently, we have no way of measuring that because it's not just the financial cost. It's not just the emotional cost. It's the cost to those families. Their stories always have a character that is outside of prison, that is the motor, the engine, but that feels so as imprisoned as that who is actually wrongfully convicted. So it's the sister of Antonio Claudio that provokes us and that visits him, travels. It's the mother of Igor that was here talking. It's Lucas' mother. It's the mothers. The mothers have a very important role in this construction.
That is impressive. The mother of Carlos Nilsson, of which history you heard recently, she was interviewed during the moment of the arrest. She was a very simple woman. She was exposed for 10 minutes in an interview of a very low level, and the journalist was asking, what do you think about your son being accused by 15 women? What do you have to say to those victims? And she kept her honor. She would raise her face and say that her son was innocent, but that she should apologize, even though she did not believe her son had done that. And when he was released, 12 years later, actually, a woman that did not have money enough to have a bed in her house, but that would monthly visit her son and travel 5 hours to do so, her great joy was to tell her neighbors, did you see? I always told you that he was an innocent man. So you have the mothers, you have the fathers, you have the girlfriends, the boyfriends, you have the children. So many people are suffering this tragedy with such strength, and they feel like their freedom is being deprivated, such as what happens to the person incarcerated. We saw the picture of those people with their family, supporting two people that will suffer the same as the person that has been incarcerated. So we need to consider that because from the perspective of our project, we're not working in actions of indemnization, but we have built pathways. We have partners that are specialized in this field and that have a beautiful work. They're extremely competent and they work pro bono, trying to find some compensation for these people. And I can tell you that until now, all of our attempts were frustrated. In none of the cases of the project able to have Court of Appeals to recognize the money indemnization. The arguments are many. Maybe the judge was induced to error. Maybe the person who had to answer for this mistake is the friend of the mother of the children that led them to lie. But actually, the truth is we weren't able to a single ruling deciding that this should be compensated. And for those people that felt invisible, that felt not seen, not heard, not respected, that once again the state is denying them a law that seems to be so basic, so elementary, they feel once again attacked that which they have as most important, which is their dignity. We see the model from the United States that Anna mentioned, which is not enough, but they have federal laws. They have 38 states outside of the capital that are regulating the right to indemnization. They have minimal parameters a year for wrongful convictions that do not depend on the demonstration of the responsibility by the judge. Because no one here is saying that the judge is intentionally making mistakes, but for those of us that are suffering the error is there and needs to be repaired. This would be something that we could talk about for days on end, but it was important for us to bring our experience, for us in facing this pain once more and say to that person, they still recognize that they are wrong, but they won't recognize that it is their fault. And once more, you're feeling hopeless. So it is for us to bring hope to people like Anna, that with all of this pain, were able to transform their lives in a powerhouse in fighting the judiciary errors. This is the reason why this topic is so important. Thank you very much.
Eu queria agradecer a
I
Ana.
wanted to thank Anna, Dr. Flavia. I don't know if Anna has already left, but we'll never have her space for speech about it. We've never been through that. But we can become aware and try to make these errors in the judiciary no longer a reality. So she is a person that not only went through what she went through, but is demonstrating here what she went through. And then we can see that she, as Flavia said, has become a leading actor in her own story. This is why it's important for her to fight so that other errors will no longer happen. And so moving on here, we're going to hear now Mr. Rubens. He's a journalist ever since 1989. He was born in Paraná. He has a degree in journalism by the Federal University of Mato Grosso do Sul. He has been in the federal district ever since 2010, and he works in the public agents of investigative journalism in Brazil. I hand over the floor to you, Mr. Rubens.
Começo agradecendo o convite feito pela doutora.
First of all, I want to thank Dr. Cavalcante for the invitation, for the Innocence Project invite. Through Justice Sketch, I congratulate the National Council of Justice for raising this discussion. I wish that all of the courts in the country were discussing this. As I said in the introduction, I have been a journalist for many, many years, and I started writing about police, and I covered operations of the federal police. I lived in São Paulo, in the city of Cuiabá as well. And so I'm used to the problems inherent to police investigations. And I must say that I met police officers and people that work with the legal profession that had good intentions, that were concerned with the quality of evidence and everything else. But I also found, and I came across doubts about public agents, and particularly when those investigations gain the attention of the media. So it is necessary to redouble the attention there, because we have the content of an egotistical need of attraction, and so the public agents are much more at risk of committing what are called honest mistakes. And I wrote a few pieces about innocent people that were arrested, such as this article that I published in Folha de São Paulo. And after a conversation with Dora in a restaurant here in Brasilia, we came up with the idea. We searched for 100 cases of wrongfully convicted people, so we worked with those samples, and the final conclusion is that the failures in the identifications, they feed the machinery of Black and poor people being arrested. The first case was in 1976 and the last one in 2020, and the article was published in 2021. The higher time of arrest was 19 years, and the misidentification is the basis of 42 out of the 100 cases. And the correct identification here is the identification of documents. The persons might be arrested since they are homonomous. Maybe a brother was arrested in place of the other brother. And in 7 of the cases, they were wrongfully pointed out by the authority, but not necessarily through lineup. In the case of the wrongful identification, 71% more Black. The most common professions, and here we try to show how it should be done. This has been surpassed by the manual and the resolution that have been edited by the Federal Supreme Court and the Council of Justice. And here we have how the identification used to be conducted. The police officer will show a picture from social media or send a picture of the suspect to the victim and ask, oh, take a look here. Is this the person who assaulted you? Sometimes the police officer will call the victim and say, I found the responsible party. All you have to do is come to the police station and make the identification. The police has had the practice of showing photo albums to suspects, and after the number of these articles, the Federal Supreme Court recognized and considering the exoneration of 1 out of the 100 cases reported by us. You can click this article and you can read about what each one of those persons faced. The first case in the Innocence Project, and I had an opportunity of writing about that. It was the first article that I was like, okay, thank you for the trust. And the judiciary welcomed all of the evidence brought by the Innocence Project and exonerated Artesino. I'm not going to be too long because we're short in time. Here we have Artesino celebrating, and I also wrote other things. In parallel with the work of the Innocence Project, such as this case of the hairdresser Sidney Silvestre Vieira. It is a case that to this day, I don't know why he was arrested, and he doesn't either. Basically, a man died after assault, severe assault, and the police arrested José da Silva, let's say the true responsible party. And that person said that Sidney was with him in the scene of the crime, that helped him commit the crime. And Sidney gets arrested in his house, which is 40 kilometers away from where the scene of the crime actually was. And Sidney said, I don't know who this person is. I don't know who the victim is. And to this day, we don't know what led police to his house. Afterwards, that person actually said, no, yes, that's the one, that's the Sidney that I pointed out. And time goes by and I had access to a video where the accuser said, I was absurdly tortured. I accused him, Sidney, because the police fed me his name. And to me, this is an unbelievable case that could happen with any of us. In case police is targeting a suspect and tries to build their case on top of someone, then that machinery is brutal, and for you to prove that this is a lie, well, he took a year and a half to do that. And after our article was published, he was actually released. What I want to say is that in all of those cases, and I don't know what about other experiences, but in all of those cases, I felt a deep rejection of the public prosecutor's office in admitting their mistake. They rejected that insistently. They did not accept the discussion, which to me is a shock. And journalist school, we learn if you made a mistake, you're going to recant. You need to correct your mistake. This won't nullify your mistake, but will make the mistake lighter. And I felt the complete opposite from the public prosecutor's office. And the same with the police. When you discussed evidence, they would say, no, the judiciary branch has decided. They have tried. Who are you to discuss what the judiciary branch has determined? No, but the judiciary branch said that because you said something else. So, seems like crazy talk, but this is a deep discussion and something that I think is damaging to the public prosecutor's office themselves. And in my opinion, what we have been discussing here is just the tip of the iceberg of a problem that from a standpoint, I don't know whether if it is more severe, but more disseminated, the problem of the evidence. We're discussing wrongfully convicted people. But the problem of frail evidence extends itself to all of the inquiries and investigations about corruption, money laundering, several other accusations that are not necessarily
so black and white, so to speak, for us to be able to clarify an accusation. But in the cases of corruption, there is a huge amount of subjectivity, and I see this repeating itself. And when the public prosecutor's office is targeting someone who is well known and famous, this is something that actually scares me. The institution asked me to talk a little about the media, about the press. Now, reaching the end and conclusion of my speech, the press has not been doing their work. They are giving the coverage when the mistake has been detected, thanks even to the judiciary and other organizations. I think that the press has been publicizing those cases quite well with the necessary visibility, but they make severe mistakes when discussing the foundation of those errors. That discussion basically doesn't even exist. I want to know here in the audience who are the journalists sent by their vehicles to cover the event here. Can you raise your hands? One. Where's the one? Where does he work? Danilo from the Legal Consultant, the website. And this is enough to show a deep misunderstanding. Oh. Well, is any member of the public prosecutor's office here? Three. Very well. Congratulations for being here. But this shows the tremendous challenge that we have in debating those topics. The press makes profound mistakes when they are narrating certain investigations as closed cases. And I've said this from the beginning, in my writings, in everywhere I worked, basically. Someone said that. We need to emphasize that this is an investigative stage, that this investigation can still be contested or not. We need to attribute the information to the common practice. And here, the press will adopt as hard fact something that's still ongoing. The criminal, so they will say, and this is a serious mistake in communication, and press needs to try to have access to evidence, and sometimes this is hard. Many of the cases are under secrecy, and secrecy at the situations works as a shield against the mistakes of the prosecution. Many times they say, no, releasing that will get in the way of solving the case. But no, sometimes this will get in the way of not showing the mistakes that they are committing in the case. And so the press needs to go after these evidences, and sometimes we can't do that. Sometimes we need to make our own judgment of what is happening. And it's an unequivocal role of a reporter to try to find the complete process. This is an ethical, moral, and professional imposition. It is something that we see not happening very frequently. People are very comfortable with that. Once an editor told me, Rubens, the judge knows what they're talking about. They know, the judge knows what they're talking about. You know what they're talking about. I'm going to go back to this headline. Without evidence, hairdresser is arrested. For me to include that at my headline, there was an absurd debate since my vehicle was asking me, who is saying that there is no evidence? The judge has affirmed that. And the main evidence was the accusation, as I said, but this accusation was recanted. Well, if the only evidence was the accusation and it was recanted, then there is no longer any evidence. But we were able to do that. But for me to be able to have this title, which is apparently something simple, was an arduous task. But the press and the vehicles are afraid to have to indemnize someone. Even the judge can go against this type of headline, legally speaking. But the press needs to create mechanisms that are more and more strong, and this needs to be within the daily routine of the press. Thank you. In Brazil, our press does not have normally their own investigation team.
There are a few cases, maybe in the south of the country, some TV stations have that, but most of our vehicles here do not have the American or European model, which is having an investigative team within the vehicle. And that team is supposedly freer and has more time to investigate what is being said by the media themselves. So it would be a parallel investigation by the press themselves. That would be a natural investigation, and another team trying to investigate what is being said, whether this is correct or not. And in Brazil, this does not exist. We do not have the persons of the checkers, the fact checkers. And fact checkers are, they are a type of professional that has disappeared in Brazilian press. And those professionals had an obligation in certain news to call the person and ask them, did you actually tell that? Did you actually say that to the reporter? And nowadays, even the American press uses that. I get an interview to the New Yorker, and I spend an hour and a half with a fact checker on the phone.
She was asking me what I was wearing because I said that I was this way or that way in the article, whether in fact I had quoted a book that I said I quoted. I was impressed in a positive manner, and she was challenging me to remember what happened. And if they called you, that's it, right? After the fact checking, there's no problem at all. I would like to have a fact checker such as this one at the New Yorker. You're really going after every single fact because we fail all the time. It's human action pressed by time. I would like to then close here. I spoke too long. I thank you once again and congratulations on the initiative. Congratulations, Mr. Rubens, for your exposition, for your experience as a journalist. And he touched on an issue which has to do with structural racism. It's the issue of structural racism within the penal process, which is something that needs to truly be faced to avoid the perpetuation of injustices that take place in the penal process. And finally, we would like to close with Letícia Peçanha, who is, she coordinates the Racial Nucleus Institute at the, she also works at the Magistrates School in São Paulo and the Ministry of Justice and Public Safety. Dr. Letícia, thank you very much. Good evening, everyone. I thank you. I thank the National High Court of Brazil and the Secretariat of Access to Justice for the execution of this seminar, which is coming to an end. I congratulate the whole panel, and I talk about how honored I feel of being part of this event where so many people I admire are part of. As a public defender, I can say that the decisions of Justice Getty are real examples. So it's a time of great joy for me. Today I was asked a question. We were asked a very difficult question today. How much? What's it worth? The wrongful conviction of an innocent person? And I thought about how I would get to a response. Of course, I won't be able to get to the reply, but we can start thinking about this issue. And I remembered that when we start studying law, one of the first things we learn are the principles of penal law. And I thought it would be worth it for us to think about the principle of intranscendence. Our Constitution says that no conviction will move on from, but we can talk about if we don't actually go beyond the sphere of that person's life and their relatives. We talked about the effect of those wrongfully convicted and what the effect has on their families. But if we can try to imagine a collective that is founded on racism, Black people have thinkers. I was trying to think about the word I would use to talk about Nina Rodriguez that talks about subjectivity of Black people. And we think about identification of people as a subjective tool. We can imagine that we have a great probability of making a mistake in this procedure. As Black people, we end up being seen as responsible for our body, for our race, and for our ancestors, and seen as inferior beings. I brought a book that I like very much, which is called Whistling Vivaldi. The author is a professor at Stanford University, and the work is called Whistling Vivaldi because he talks about many cases. One of them is about a young Black man living in Chicago and how he felt when he walked past the parks in the evening at night in the city, and white people were really bothered by his presence. And this really hurt him. He felt really uncomfortable by this. And as a strategy to manage, to sort of diminish that threat environment, he used a strategy that he thinks helped him in this sense, which was to whistle the Vivaldi's Four Seasons. Why? The author proves scientifically that the weight of the stereotype limits the potentiality of people. So he did this based on women trying to prove the ability of conducting mathematical analysis for Asian people. They felt better and they did better at the test. And if you say that it was to test their physical ability, they actually did worse in the test. So the expectation has a very big weight, and that limits our abilities. For that reason, the cost of a wrongful conviction is collective. It affects all of us. The tattoo that Flavia talked about, the case of Anna, made me think about a time when I was part of a jury. I wasn't a public defender. The defendant was a Black man. He didn't have any criminal record whatsoever. He spent 2 years in prison preliminarily based on a wrongful identification, and he was accused, such as Anna, of raping and killing 2 children. He ended up being exonerated by the council, and I think most of you know that at the time the defendant is in the room. I was in the room and I said, oh my God, he was absolved, he will be so happy. And I sat in my little corner, I waited for him to come in, and I was looking at his face while the judge read the ruling. And there I was looking at him, and I thought, he's going to cry, he's going to celebrate what's going to happen. That man spent the entire session very seriously, and that's how he ended up. His image never left my brain. When I actually had the test for my public defender's place, I actually told him this story. We talked about the trial, and I talked about retribution theories, education, a whole lot of things. But down the end of the day, there are other hypotheses on this, and I ended up telling him this case. So watching this man, his pain, his suffering, he was dead alive. He wasn't there. It really touched me. It really upset me. And having gone through that changed my experience as a human being. Going back to the cost of a wrongful conviction, it's not maths, it's not individual, and it goes beyond society, because we cannot consider as healthy a society that imprisons its youth en masse. 65% of those convicted, according to the census, are young, are Black. So we need to base that on something. the cases that we saw the other day, the news on the film acknowledged, it shows that most of the Brazilian population have this sort of cloud, this cloud of stereotypes, this cloud of racism, the uncertainty of leaving the house, not knowing whether we will come back alive or free. We cannot measure the cost for mental health of Black families that don't know if their children will come back from school. And this shows that in 2024, we still have to fight against the permanence of the colonial logic against Black people. Also, the conviction of the wrongful conviction of innocence has an effect on the Constitution itself, and we cannot let the Constitution go, because if we do that, really, it's the end. What are we doing here? So, within the Secretariat of Access to Justice, we have some initiatives to improve the criminal justice system, face institutional racism, and also reduce violence against minority or vulnerable groups. And I wanted to talk about two projects that I believe are, well, the ones that I like the most. The first one is the Mirante project, which looks to produce evidence and data on institutional violations to human rights resulting in deaths, to contribute with judicial actions and look for rule of law, memory, the reparation, the compensation of institutional violence. This project is a mechanism, perhaps, to independently, as the Brazilian state requested of Nova Brasil Favela, we are working on an initiative that talks to this, of people recognition, and there is a national inquiry that looks at judicial errors to understand how they happen, who they happen with, why they happen, and what can we do. In this project, we want to analyze emblematic cases, such as a case that this is the Paulo Betti case that has more than 60 trials, lawsuits, and we want to mobilize the civil society around the criminal justice system. We need to bring the civil society closer to this issue. I forgot to ask for the technical team to show an image that I sent you. I wanted to close with images of a project called Dreams Mural, which spreads tools to inspire Black people. And we have a racist imaginarium and stereotypes of the Black community. This is a collective called Us for Us, of Black representatives of rights. This is represented by Felipe Siqueira from Bahia. This is an album of photographs such as this one. This is what we want in terms of identification for Black people and recognition of Black people in this country. I thank you once again. And if you have any questions or comments, or we can build public policies and change the horizon of recognition of persons in Brazil. Thank you.
Bem, é tempo de
It is
encerrar.
time for us to close. I would like to try and sum up everything that's been said here, but it's practically impossible. So I will merely read here an excerpt of a text that, in my opinion, can serve as an appeal. This is a text that I published. It's called "We Still Need Institutional Will in the Production of Evidence in Criminal Processes." And in that text, we talk about what's been done in terms of institutionals, by the courts, by the National Council of Justice, some policies in São Paulo, state laws, echoing these changes that have been taking place. At a certain point in time, in a pessimistic way, and faced with the volume of processes that we continue to receive at the the National High Court of Brazil, still convictions based exclusively on recognitions that are the only evidence in the trial, I say that it seems that nothing changed for a considerable part of the magistrates of the public prosecutor's office. Many people continue to be convicted based on an evidence that's illegal or insufficient. I think the biggest critique is for those institutions that are responsible of penal prosecution. I cannot stop from noticing that an infinity of individuals are being convicted, processed, or convicted without having committed the crime for which they're accused, while the rightful authors of the crimes are still free without having been reached by the justice. And here I bring some concrete cases, and I close by saying the following. It is about time for all of us to work to revert this deficit of evidence proof and in criminal investigations. It is worrisome that we continue to work with the logic of the convictions or eyewitness testimony or eyewitness recognition as enough for solving a crime. New technology, new techniques for investigation need to replace these primary methods and in the search for truth. Science must prevail over the opinion. Rationality of evidence needs to replace the subjectivity with epistemic parameters. There is no more room for voluntary basis, for institutional negligence that affect the life of human beings. I wanted to register my thanks on a personal note and also on behalf of the court. Thank you, thank Benjamin for the support you've given us in the collective work, of which magistrates and other staff here at the court are part of. I wanted to thank the National Council, the President, Luis Alberto Barroso, and Luis Lanfredi, a great colleague who is still here. He was here for the entire day. He's back there. He's hiding. And his entire team, Manfredi, Carol, the whole team that jointly with those that work in my office, Ana Machida, Leonardo San, worked hard for this event to take place. Every thanks goes to me, every recognition goes to myself, but really they did all the work, those who organized everything and made this entire event possible. The Innocence Project, as I highlighted yesterday, is an institution that deserves our respect and admiration for the wonderful work they do, and the proof of that has been given here at all times. We're very lucky to have you, Flavia, Dora, Rafael, as leaders of this movement that really spread through the entire world. I'd like to thank the speakers, in particular Dr. Mariela Madero, who was here with me presiding this table, this panel, and for those who had this wonderful participation. For the quality of this closing panel and all of those who came before them as well. A special reference to the artists that made this event more humane. Marco Zacarias for his exhibition outside, as well as Fernanda and Michael for the work of art that we await. And Daniela Mercury, for her energy, her voice. I don't know if they told you, but once I was in my office and half an hour before coming down, yesterday, Daniela Teixeira called me and said, Sketchy, Daniela Mercury is here. Do you think you can sing the national anthem today? I said, no way. Imagine it. It goes beyond the protocol. Bring her here. And she came here and we talked and she started training and doing vocals as she came. And it was wonderful. I'm very thankful for having really donated her time. All the staff, everyone who gave us support, the interpreting staff, very important. The audience, we're here on a Thursday, not a Friday, and you're all here faithful, and that's proof that something important has been said. And our special thanks, I can't even apologize. But it's very important for us to highlight those who have been shown here in videos, those who have suffered. It's because of them that we are doing this in one way or another, because what we hope is that mistakes such as those ones stop from happening. They've had their lives shattered due to a behavior that could be simple laziness or cruelty. I think that oftentimes, and we're writing a text on this, sometimes we lack empathy. It's not saying for you tapping on the head, patting on the head, or being good to those who committed crimes, but it's actually being empathetic, having the ability to try and place ourselves in their shoes. We also need to look at other actors, such as the victims of the crimes, but we need to at least look at the mothers that Flavia referred to. They are the ones that suffer the most. They are the only ones that trust from the beginning and always in the innocence of their children, and they never abandon them, even if they are guilty. And if they are innocent, they're the ones that go after the Innocence Project or the IDDD, and they fight with all their might to try and prove the innocence of their children after years after. The penal process is not legitimized by the authority, but by the truth. We need to improve the truth in these processes. We need to improve the evidence till it gets to a point where, as it is written in a book by Marina Gascon, and the title is Improving the Evidence. We need to improve the evidence. It's not just recognition. We need to improve the testimonies. We need to abandon the logic and the obsession for the confession. We need to use technology. We need to have mechanisms so that this public service that is so essential, perhaps the most important, that deals with freedom, is really a public service of quality. And this starts since the uniformed police in the streets, civil police, the public prosecutor's office, and the judges. While there is a uniformed policeman committing violations, and the prosecutor accusing and the judge trying, we will not move forward. We need for each one of those institutions and each one of those professionals to have responsibility of re-examining their institutional practices. Doing a conscientious evaluation to change the scenario of so much suffering that we are experiencing. So here we recognize mothers, and I will not apologize because it's actually not enough for them. I am ashamed of being part of a system which up to not too long ago accepted all this. We are all changing this. We are all very much committed to changing this situation. And I'm sure it will change. And I now close, since we started, art. I will now close with art. I will quote two excerpts of poetry, one from Belchior, where he says, living is better than dreaming. I will not sing, right? I know that love is something good, but I also know that any song is not enough faced with the life of each person. It's painful to realize that despite having done everything we've done, we're still the same people and we still live as our parents. But you loving the past, you don't see that the new is always coming. This is a wonderful excerpt. And to really close, Dr. Guedes, in his spring sun, we've cried enough. Much has been lost along the way. Still, we need to create a new song that brings us the spring sun. Open the windows of my chest. We know the lesson by heart. We just need to learn it. Good evening.
Falou.